এটা লাইকটা জানলো কি করে ডিপার্টমেন্ট?
Permitted to mention two order 41 suit for specific purpose.
Yes,
One review petition,
but review.
Review.
Yes, yes.
My lord. Date of execution hearing with help of
Review
police.
before the regular bench.
No, yes, with Justice Uday Kumar.
এটা যখন বেঞ্চ 8 you are sitting next. It will appear.
Your Lordship, may I be permitted to mention for inclusion of Order 41 rule?
Yes, please.
May I permitted to mention for an application?
Application, yes.
My lord, may I be permitted to mention, my lord, an appeal, my lord, under order 41, my lord, first appeal.
My Lord, may I permit to mention an review application? Lordship, may I permit for inclusion of the daily supplementary list?
Of what?
That. That 20.
If it is hearing, wait for some time.
My
lord, application, my lord. Civil application. দেখি ফাইলটা
My lord, I am for the appellant, my lord. Unfortunately,
গল্প ও ও as per report of the first appeal section dates first appeal was converted to FA. It was dismissed. The appeal itself has been dismissed.
I see.
So we will discharge the rule.
My lord, we have been briefed, my lord, after the
No, you are not responsible for that. Appeal has been dismissed. So we'll discharge the rule. I'll just check up what is the it is in connection with an application probably must be.
ability ইয়ার কি হয় সিআরএফ থেকে in has become
The application is pending রয়ে গেছে ডিসপ্যাচ করে দিচ্ছি
appeal dismissed.
অ্যাপিল ডিসমিস হয়ে গেছে অ্যাপিল আমি রিপোর্টটা রেফার করে দিচ্ছি রেজিস্টার we find from the report dated April 7 2026 of the assistant registrar Roman 4 that the appeal bearing FA 256 of 1989 comma in connection with which the present rule was issued comma has already been dismissed on April 22 2024 full stop. Accordingly the connected rule has become infructuous. Hence CR 1411 of 1989 is discharged without an order as to cause. Yes.
Apologize, my lord.
No. What for?
My lord, I'm before your lordship for one prayer, my lord. Since the ruling dispensation has
Yes, we know the
changed,
state panel. Yes, we understand that
That's-
we are discussing that also.
my lord, what I'm humbly submitting and praying before your lordships, in any matter where the state is not being represented for any reasons, my lord will be kind enough to adjourn the matter for 2 weeks, subject
do
to
that.
whatever possible.
Sure. Mr.
I'm sorry, my lord.
No, you are right, absolutely right. It will be an illogical discrepancy if we pick up the matter. No, definitely we'll adjourn for a fortnight. But make arrangements within that, please.
My lord, we
It
have
is
first
represented, we have to take it.
No, no, if state is
my lord,
represented,
first
definitely
let the oath
they
take place,
cannot
my lord,
do
because every
cannot একজনও থাকবে
I cannot. Unless specially requested by the GP or AG.
হ্যাঁ যদি স্পেশাল প্যানেলে হয় তাহলে থাকতে
Or
পারে।
requested, specially
আচ্ছা,
requested.
দেখা যাবে, যখন আসবে দেখা
my
যাবে।
lord,
Yes,
the
yes.
oath takes place, and then after that everything will get in order.
Very good. Sure.
Item number 2,
এটা লাস্ট চান্স দিয়েছিলাম, নেই কিছু পুরোনো গুলো ডিসমিস করার
Last time the appellant got to the matter.
ইচ্ছে করে একটা করে চান্স দিয়ে তারপরে এটা
Oh, 1989 and 12 matter.
By an order dated April 7, 2026, we had given a last chance to the appellants to argue the matter. Full stop, even today, at the time of call, the parties remain unrepresented at the time of call. Full stop, accordingly, CR 1679 of 1989 is discharged. FAT 1723 of 1982 is dismissed for default. Interim order, if any, stands vacated, no order is to costs.
item number 3, same.
ডেটটাও একই, সেম, এক্স্যাক্টলি সেম। নো, সিআর নাম্বার এন্ড অ্যাপিল, ইয়েস সেম হলে বলে দেবেন। ওই ডেটটা দেখে নেবেন শুধু আগের অর্ডার।
Item number 4,
My lord, may it please your lordship, I am
Mr.
for the appellant.
Yes.
Now, my lord, this is an appeal from an decree whereby, my lord, my ejectment suit was dismissed. Now, my lord, I have advised them, my lord, to withdraw this appeal because we have today a remedy under PP Act. It would be better, my lord.
Oh, you're the port.
I am withdrawing it. I am for the appellant, but
Right,
I
right,
do
right.
have the instruction.
Absolutely right. Right advice. So very well. So
My lord,
we're
Mr.
recording that. We'll keep that on record.
Yes, yes.
Very well.
But if possible, my lord, leave to proceed under PP Act. I don't know. My lord.
No, you are unconditionally withdrawing, okay?
Yes, of course.
Then we have to go to the merits, why leave should be granted.
No.
If you have a remedy under law, you can do that.
Yes, we'll just say that.
Yes,
That
yes.
if you have a remedy under law, you can
Yes,
proceed.
yes. That,
Say that.
that.
Otherwise, on merits, I mean, at that juncture, we'll not go into that.
Lord-
My learned brother is
Lordship,
right on that.
lordship, lordship.
Learned counsel for the appellant submits that the appellant seeks to withdraw the appeal and the connected application in order to proceed under the appropriate statute. Full stop, a written instruction in that regard, filed in court today, be kept on record. Full stop. Accordingly, FAT 2054 of 1982 is dismissed as withdrawn. Full stop, CR 2511 of 1989 is thus discharged. Full stop, interim order, if any, stands vacated. No arrest to cause. Full stop, it is made clear that the above order shall not stand in the way of the appellant to proceed under any appropriate statute or to pursue any other remedy, if available to the appellant under the law.
I'm grateful, my lord. Much obliged.
Thank you.
item number 5,
এটা এই আগেরটা যা হলো 7th এপ্রিল।
item number 6, item number 7, item number 8,
না এগুলো কি আগের অর্ডার নেই? তাহলে বলতে হবে তো,
সব last chance.
ওরা কল করে যাবেন না, সব সেম অর্ডার।
अभी तो last chance
সব
আছে।
লাস্ট চান্স একই দিনে টুতে যা হয়েছিল এগুলো সব, হ্যাঁ ওরকম ঝটঝট করে ডেকে যাবেন না, সেম বলতে হবে তোমাদের। ইয়েস,
item number 8,
সেম সেম
item number 9,
বলে দেবেন
same. Item number 10,
সিমিলার সেম অর্ডার।
item number 11,
যেগুলো নরেন মারা গেছে বলেছে সেগুলো কয়েকটা কিন্তু অ্যাপিয়ার করেছে। অ্যাপেলেন্ট নট ইয়েট অ্যাপিয়ার্ড কি করে?
Or extension of interim order.
বারবার অ্যাপিয়ার করছেন।
A recent foreign মামলা। না, এই গ্র্যান্টটা মানে extension of interim order টা
আর একটা জিনিস দেখে নিন, আমাদের তো এক্সটেনশন অফ ইন্টারিম অর্ডার ডিটারমিনেশন থাকার কথা না যদি অ্যাডমিট হয়ে থাকে অ্যাপিল। দেখে নিচ্ছি অ্যাপিল চার্জ কিছু আগের অর্ডার আছে কোনো এটা
admission order তো থাকবেই।
থাকা উচিত।
Admission order.
তাহলে এক্সটেনশন অফ ইন্টারিম অর্ডার হবে কি করে, তাই না? দাদাবু, হ্যাঁ এই তো অ্যাডমিশন হয়েছে তো,
ও তাহলে তো
তাহলে বলে দিচ্ছি যে
matter
সিঙ্গেল,
replaced before the
হ্যাঁ 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 অ্যাবসলিউটলি।
having determination.
Since the appeal has already been admitted, comma, let the matter go out of the list with liberty to the parties to mention for enlistment before the appropriate learned single judge having determination. You are appealing this matter as well. Next.
Item number 12,
12 is an appeal by the KMDA, my lord. I don't know whether I have
Okay,
authority.
Chaudhary,
to
you are for the
proceed.
respondents.
I don't know whether I have authority to proceed with the matter because of the change, my lord. I don't know. Kindly adjourn it for.
My lord, that is no ground.
No, that is a good ground.
That is a
Very good ground. What are you saying?
My lord,
Kindly
his
adjourn-
authority has not been revoked as yet. My lord, any case, they are out of time.
No, you are too.
Anyway, let him be granted some opportunity to
Yes, yes,
My
definitely.
lord, that's why,
take
my lord,
necessary steps.
Because I don't know. I'll have to
simply
ascertain, my lord,
adjourn.
because my lord, the rule is that my lord, it has to be somebody from the state panel who are interested to appear for KMDA.
So you take instructions after 2 weeks.
I'll take instruction.
No, take instruction within a week because he had some urgency and that's why it was
my-
special.
that's why it was fixed.
That was special.
My lord, they've not even chosen to use an affidavit to reply. That happened, the time expired before this change
That
took
will
place.
consider whenever somebody.
My lord, may I file my affidavit in opposition? Copy served
Yes.
in time.
Affidavits in opposition filed today by the respondents be kept on record. Full stop.
Affidavit.
Sorry. Singular. Learned counsel for the petitioner submits that in view of the change of
Adjournment single
no, no,
judge.
ground dito special.
My lord, officially, there's been no changes yet.
In view of the change of dispensation, comma, counsel is required to take instruction as to whether the earlier panel of advocates for the KMDA stroke appellant is still retained. Full stop. In order to enable the appellant to be properly represented, comma, let the matter stand adjourned till May 12, 2026, when it will be listed next under the same heading. It will appear as a special fixed matter. Mr. Banerjee, please ensure that at least you communicate properly so that your skin is saved.
এলার শুধু চেঞ্জ হয় না, এলার তো একই থাকবে যতক্ষণ হাইকোর্ট না উইথড্র করবে।
এখন কিছুই বিশ্বাস
সকালে
নেই।
submission করে গেছেন।
এলা তো
ধীরাজদা সকালে একটু আগে মেনশন করলো ধীরাজদা যে স্টেটের যা মামলা আছে সব সপ্তাহে
প্যানেলই নেই।
আজকে সকালে মেনশন করে
কি
গেছে।
বলছেন? কল কল
item number 13 with 14.
সিভিল ম্যাটার ছাড়া কিছুই হবে না আজকে।
Your Lordship, in this matter, I am appearing for the respondent being led by Mr. Anubhav Sinha. Your
So
Lordship,
you have no change of panel.
no, we don't. Your Lordship, the difficulty is neither my seniors and none of my advocates on record have been able to come as yet to
No,
court.
but this is a second occasion when it is happening. So we
Lordship,
cannot grant you further time.
Your Lordship, may I submit this? Your Lordship, today
To
is,
argue the matter, you are taking some preliminary point or something.
yes,
Mr. Sinha was taking
Your Lordship, what the brief facts was that I am the plaintiff in the suit. We had obtained an order of injunction. Now the applicant over here, they had earlier filed an order 1 Rule 10 application in the suit seeking to intervene. Their application was dismissed, against which they have not preferred any revision. Now they have filed this application. Can 1 is their leave to appeal. Can 2 is their application for
So you
continuation.
took a point if they are not parties, if it has
Yes, we
rejected
had
there.
taken that point. On that, our first preliminary submission was that about the ownership pattern of the
Have
company.
you got a copy of the order rejecting their order 1 Rule 10?
Yes,
That-
Your Lordship, that is annexed in Can 3. Our first, in Can 1, we had filed an affidavit in opposition also, in which our preliminary objection was that the pleadings in the Can 1 is not enough for the court to move to Can 2 or Can 3. Can 3 is the main application
So
seeking
we
to
want to
withdraw.
see that order because Can 1 is dependent on that order rejecting their.
Lordship can take up
Take
Can
a year.
3. It is there in Can 3 at page
22/5/2024.
Can 3 which page?
Can 3,
Okay.
page 392.
392.
That is the order 1 Rule 10 rejection order.
Volume 3.
No, 22/5/2024.
That is the order of injunction.
Order of it is still there.
It is still there. I am the plaintiff in the suit. I had obtained an order of injunction.
ওরা প্রিলিমিনারি অবজেকশন নিয়েছে এখানে লিভটা আমরা দেবো ও লিভ নিয়েছে যেহেতু পার্টি নেই ট্রায়াল কোর্টে এখানে লিভ নিয়ে অ্যাপিল করছে লিভটা
হেয়ারিং
গ্রান্ট
হবে,
করতে
লিফটে হেয়ারিং হবে।
ও সেটা পয়েন্ট নিচ্ছে যে ট্রায়াল কোর্টে অর্ডার 1 রুল 10 রিজেক্ট হয়ে গেছে তাহলে এখানে কি করে লিভ পাবে তারই ইন্টেলেকচুয়ালি
ওটার অ্যাপিলটা কোথাও উচিত ছিল, অর্ডার 1 রুল
অ্যাপিল নেই সেই অর্ডারটা দেখছি যে মেরিটে ওটা কেন ডিসমিস করেছে সেটা পেজ 392 তে আছে
অর্ডার 1 রুল 10
ওটা দেখুন 392 তে দেখলে বুঝতে পারবেন
The 22nd May 2024 is my order of injunction in the suit.
The suit is for
The suit, I had given a loan. The
which suit?
Yes, it is my suit. I am
Recovery
the
of money.
plaintiff in the suit. If
Rec-
your lordship can take up the cause title in the
No, it's for recovery of
No,
money.
you obtained loan.
yes, I had given the loan to the company to the defendant number 1
You have given the loan.
to Kitply.
You filed a money suit.
Yes,
In connection with that,
I had obtained an order of
no,
injunction.
they sought to add themselves as a party.
At later
On
stage,
what ground? What is their status?
their say is that the shares, I have obtained an order of injunction or the assets of the company. Their case is that certain shares are pledged with them. They would want to invoke these shares. However, due to the order of injunction, they are not able to exercise their alleged right. Now, I am disputing this fact of this because our preliminary submission was that in Can 1, where they had to show that they are an aggrieved party, they had to make out such a case, which they have not done.
Against that order 1, rule 10, there is no revisional
There is no
application.
revision. After that, they preferred this leave to appeal, which was filed in January or February of 2026.
Suit is for declaration, mandatory and permanent injunction,
Yes, Your Lordship.
not for money. But the privity concept, why does it come in? Because they have an independent, they say they have a first charge. So if this suit is decreed in your favor, their first charge will be directly affected first. Secondly, the injunction you have sought directly affects them.
Now, Your
They
Lordship,
cannot also,
on this point, they have two parallel proceedings pending. They have filed two proceedings. One is before National Company Law
that's
Tribunal
different. But
Guwahati.
if your suit is decreed, then their right is directly affected. They're a directly interested party.
On this point, we had taken out to Your Lordship's judgment of a very recent of Divyang Kankaria. Of Divyang Kankaria versus Salapuria Investment, which was passed by Your Lordship on 24th December 2025. Now, this judgment we were to place today and go into the merits of the matter.
ডিসিশনটা কতটা অ্যাপ্লিকেবল ফ্যাক্টস অফ দ্য
হ্যাঁ সে তো বটে কিভাবে ডিস্টার্ব করবে because if they are alienated from transferring or whatever, then their proceedings will also be affected.
Yes. But on this point only, we are carrying your lordship's judgment.
Well, that's a single bench judgment.
No, your lordship's very recent judgment of 2025.
Division bench judgment or
Yeah, division bench. You have a copy.
So we can distinguish that also, no difficulty.
Lordship, it is distinguishable on facts because my lord in that judgment had held that the party who is.
So you have to see that judgment, I mean.
Do you have a
নিয়ে আসো,
copy?
কালকে নিয়ে আসো।
You had given me the soft copy.
কাল করে তো আগের দিনও টাইম দিয়েছি।
না না, কালকে ফাইনাল দিন।
আমি ওরকম ভাবে ছাড়ি না, অতটা সহজে টাইম দিলে কোনোদিনই হবে।
Your lordship,
Cited judgment. You have to bring that only. Yesterday we granted time. Will not go on forever doing this.
your lordship may kindly pass over it once the order 41 matters are over, then a matter may be called, or your lordship may kindly keep it today, only for today's accommodation, I'm saying.
Well, an accommodation is sought for by the respondent, puts up as a last chance to the respondent to argue on the question of maintainability of the appeal and the leave application, comma, the matter is adjourned for the day.
Lordship, may it be fixed any date after 12th, my lord.
Why? No.
There is some difficulty from tomorrow onwards, my lord.
Tomorrow, what difficulty?
Lordship, we are being led by Mr. Sudhasotto Banerjee and Mr. Ranjan Bachawat. Mr. Bachawat is unwell and Mr. Banerjee might not be available tomorrow. That's why I'm praying that if it may be kept next Tuesday, my lord, on 12th.
Very well. Till Tuesday. But that will be your last chance. You have to come prepared with your judgment of
Yes,
what
my lord.
if Mr. Sinha is not.
Irrespective of the advocate on record.
You have
or my
got your arguments, but you have also got our point.
Yes, your lordship.
So cite that judgment whether that's applicable.
Yes, because it is purely a question of law over here at this stage.
At this stage,
It's
leave is
purely
not
a
granted. We'll hear you on the leave. We're hearing on the
I
Otherwise, you
cannot-
don't have a right of hearing at the order 41 stage.
And I cannot go on disputing the facts because I'm not.
We won't look into that. If
It's purely a
leave is
question
not
of law
granted, we
right
cannot
now,
look into
whether they have a right to appeal.
Next.
Grateful.
না টপে থাকবেন নরমাল চলে অর্ডার করতে
Item number 15.
yes
Limited service is ready, my lord.
you have
There is a delay of 54 days.
you have carried out the corrections.
My lord,
There are defects in the appeal.
my lord, only section 5 is not final.
Unless the appeal is defective, if the appeal is defective, how can you take it up? Yes, you have already corrected. You don't even know that. Section 5 of how many days?
My lord, 54 days.
54. Did you direct you to serve copy on the other side?
Yes, sir. I have served, my lord. There is
They have received.
2 respondent, one respondent. My lord, they are residing same address. One accepted, another. My lord,
They contested together in the trial court.
yes, my lord. Both.
Are you sure they contested together in the trial court?
But
Both appear to be delivered. Please check up. The last column appears that both.
first one, Sanjay Mala is received.
Please check up. Appears that both are delivered.
The one received, my lord. Second one is
Delivered at the end, delivered.
delivered to sender.
Oh,
Delivered to sender.
the first one is delivered.
First one is delivered. My lord. Both are brother, full brother.
The brother may be at loggerheads also. They were defendants. So this appeal is against what?
My lord, main, my lord, among contention of the appellant, my lord, record of right, erroneous record of right. They
Very
filed
good.
that,
This appeal is against what?
Appeal-
Injunction order or what?
my lord, injunction order. Thereafter, my lord, filed miscase before the appellate authority, appellate court. My lord, that is dismissed. My lord,
This case under which provision of law?
my lord,
Appeal.
misappeal, my lord.
You filed a misappeal before the trial court.
Before the appellate court, my lord. Declaration title shoot, my lord,
Against what?
against the, I am the plaintiff before the trial court, my lord. Against this,
What order did you challenge?
my lord, that order was chairman injunction order, my lord.
By the impugned order, what was done? Injunction was refused to you.
Injunction refused. Thereafter, miscase. My miscase is dismissed. Against
Case under what provision?
my miscase, my lord, my application is order 41, rule 19, my lord. Right. To restore the misappeal.
You're jumping a step. Your injunction was refused. You filed an appeal against that.
Yes, my lord.
Your facts you don't know.
My lord,
Actually, your section
I-
5 was dismissed by the appellate
Section
court.
5 was dismissed before the appellate court, my lord.
Appeal was against what? The refusal of injunction.
Yes, my lord. Refusal of injunction, my lord.
Are you sure?
Well, then give me chance one day. My lord.
Since learned counsel is not ready with the matter, let the matter stand adjourned for the day. So it is made clear that in the event learned counsel fails to assist us on the next date, the matter will be dismissed for default. Affidavit service factor to be kept on record. Next, Tatri.
Number 16.
Item number 16, my lord, I appear for the appellant.
My lord, I am appearing on behalf of the respondent. My lord.
Yes.
Lordship notice served.
Yes, I have got it, my lord. I would like to submit my lord, affidavit opposition in connection with the section 5 application. Kindly.
What is the delay?
Delay of 119 days, my lord. My appeal is against the first appellate decree upholding erroneously and a
Maybe, but
preliminary.
what is the count of the delay?
Lordship, the plaintiff, sorry, Lordship, the appellant is a daily wage earner. Lordship kindly takes up my application under section 5. I have, Lordship, set out the full and complete particulars from paragraph 9, page 4 onwards. He, Lordship, he used to work in a jute mill, which has since been closed. Now he runs a mobile recharge shop from the suit premises. He was not told that the learned trial court had passed a decree by his learned advocate on record, and there is patently, Lordship, a language barrier also.
How would you know this? I mean, how would you use an affidavit? Affidavits are used to controvert allegations, not on law.
Yes,
How do you know this is all his personal knowledge?
Yes.
Whether he had knowledge of the suit, he met his advocate, how would you know? What is the scope of affidavit in opposition? We grant permission to file affidavits only if not as a matter of course. Sorry.
But this is the advocate. He is blaming the advocate on the part. My
No.
lord, kindly see if lordship.
Subject to
Blaming the
correction,
advocate, it's a
Lordship. No, no.
communication gap there.
Yes, yes. I have not blamed the advocate. The only sentence I have stated against the former learned advocate, he was not told.
Paragraph number, if you kindly, lordship, kindly
Yes.
to turn page 5, internal page 5,
We are
paragraph
there only. 11, 12.
12 and paragraph 13, my lord.
Yes.
Eventually, after facing the continuous follow of the petitioner, his erstwhile advocate applied for the certified copy of the impugned decree, and all the it appears from said certified copy, and that it was handed over to the erstwhile advocate on July 29, 2020.
Not a very serious allegation.
You see, so far the present advocate is concerned, it has to be believed. Because the learned advocate has taken responsibility to draft this.
Kindly allow section 5 with cost, my lord. Kindly.
He's a labor, daily labor with cost will direct you to pay the cost to him so that he can continue the litigation.
Yeah, allow-
In this speaking, advocate must have been Bengali and his Hindi must have been like me. So there is a communication gap we totally believe, and is a daily labor that is on the affidavit.
My lord, kindly paragraph 9, my lord. Paragraph 9, my lord.
Yes.
The petitioner was regularly following the with his learned advocate to know the fact. Well, the
Since
Supreme
when
Court
did we
judgment,
become
my
so
lord,
strict in section?
the advocate grounds no ground for the section 5 application. My
No, no, advocate's ground is sufficient.
I
Advocate,
have,
if there are latches on the part of
allow me,
advocate.
I have reported judgment, my lord.
Yes, there are different judgments
Allow me
on the
some
issue.
days I will file the affidavit, my lord.
In the SLP, you cite those judgments against our order. We will allow the section. Learned counsel for the respondents seeks to use an affidavit in opposition. However, from the nature of the allegations leveled in the application for condonation of delay, it is evident that there cannot be any scope of the respondent having any personal knowledge regarding the same. Next para, the appellant is a daily wager. Daily wager mane tai. Daily wager, footstep. Next para. In the condonation application, it has been pleaded that the petitioner had certain communication gaps and despite having pursued the matter with his learned advocate, was not in the know of the outcome of the suit from which the present appeal arises. Footstep. Next para. Learned counsel for the respondent opposes the same and argues that blame has been sought, aspersions have been sought to be cast on the erstwhile learned advocate of the petitioner. However, from the relevant paragraphs, that is paragraph numbers 9 to 13 of the application, we find a quite plausible case of communication gap between the petitioner stroke appellant stroke petitioner and his erstwhile advocate having been made out, particularly in view of the language gap and the social position of the petitioner. First of next para, hence, comma, can 1 of 2025 is allowed, thereby condoning the delay in filing SAT 278 of 2025. Yes, move the order of appeal. What is the appeal against?
Lordship, the
That
appeal,
benefit won't be given to you in the merits of the matter.
Lordship, I shall.
Daily wager, no communication gap.
Lordship, the short point that I have taken, the appeal is against the first appellate decree passed, Lordship, by the Court of the Learned First Additional District Judge at Srirampur. Lordship, the suit was filed for eviction on 2 grounds. One of the grounds was admittedly not taken in the notice of eviction. However, that is not the crux of my appeal. The notice of eviction was only on the ground of default of rent. Suit filed, Lordship, on 2 grounds: reasonable requirement of the plaintiff and default of rent. Now, Lordship, the learned trial court returned the decree only on default of rent. And the finding, the specific finding, I shall show my lords the paragraph, was that 7-2 application filed, there was a default, the time periods contemplated under the act was not followed. Now, my lord, the trial court not only records this finding, the trial court specifically does not proceed to decide the issue of reasonable requirement at all. Therefore, my lord, the suit stands decreed only on default of payment of rent, with the learned trial court stating that the question of reasonable requirement is not required to be gone into. Now, my lord, I am aggrieved by the learned trial court's decree. I go up in appeal before the learned first appellate court. No cross appeal or cross objection taken by the plaintiff. My grounds were that the default of rent has not been properly appreciated by the learned trial court. Now, my lord, the first appellate court proceeds to decide 2 issues. Again, on the ground of default, my lord, very surprisingly, the learned first appellate court records, I am not in default. Thereafter proceeds to hold that therefore that issue had been rightly decided against my learned friend and in my favor. It goes on to hold that the bone of contention is reasonable requirement, which is not at all considered by the learned trial court. Proceeds to look into several portions of the evidence, etc., and comes to the finding that the reasonable requirement has been correctly held in favor of the plaintiff and against me. Lordship, therefore, between the 2 decrees, my point in the appeal is that there is patent non-application of mine.
33, ma'am.
Lordship.
Order 41, Rule 33.
Lordship, I shall look into it.
Right now. At CPC ওনাকে দিয়ে দিন তো। এটা আপনার হাত যাবে না, দাঁড়ান এখানে এমন জায়গায় আপনারও হাত যাবে না, আমারও হাত যাবে না।
একবার
এগুলো কিন্তু এবার আমি কাজে লাগাবো।
হ্যাঁ,
Order 41, Rule 33 টা ওনাকে দেখে নিতে হবে।
I am deeply obliged.
Yes.
বার। My lord. My lord, I will rely on the
Second limb.
Yes, Lordship, I shall rely on the proviso. Kindly cease, my lord, shall not make any order such and such whose decree has omitted or refused to make such order. Lordship, my point is not today that the learned first appellate court could not have returned a finding. There are
Just please read out the entire 33.
Yes,
Just
Lordship.
once
Yes, Lordship.
read it aloud.
The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make any such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents and parties may not have filed any appeal or cross objection, and may, when there have been more decrees in cross suits or 2 or more decrees passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees.
Precisely applicable to this. They have not filed an appeal.
Lordship.
Could not file an appeal.
Lordship.
At best, cross objection.
Cross objection, my lord.
Even if they don't file it, court has the power. Court's power is
Yes.
not fettered. Court did that precisely.
Lordship, today, subject
And
to
this is a
correction.
factual finding. The court considered evidence also.
Subject to correction. Today, Lordship, the point I try to place before my lords is not that the learned appellate court could not have returned a finding. I cannot say that. That will be against the law. Only 2 portions of the impugned appellate decree, if I may show to my lords.
And give back the book. Yes.
Lordship, I am deeply obliged. kindly takes, Lordship, the impugned decree is, Lordship, annexed as Annexure A,
Page
page
12.
15, Lordship, onwards. 15 in,
No, we look into the internal page 12 of the judgment.
Lordship takes internal page 12.
Or you are placing something else.
No, Lordship kindly takes internal page 10.
Well, yes.
Lordship kindly sees,
Yes.
if Lordship I read only
Code of content.
concluding
Well,
line of the top paragraph.
yes.
Thus, it is evident from the above.
Not a default, we accept that.
Yes. So, Lordship, but this issue was held in favor of the
So
plaintiff
that
and
is
against him.
reversed.
Yes.
You get a degree on that, rather an advantage on that.
And Lordship kindly goes on to see thereafter page, internal page 13. Kindly sees, Lordship, again the last sentence of the top paragraph. Issues number 6 and 7 have been rightly adjudicated by the learned trial court in
6
favor
and
of
7 were reasonably governed.
Yes, Lordship.
This finding you are saying is
Yes, Lordship. Kindly takes, Lordship, internal page 4 of the impugned decree, where 6 and 7, the trial court issues have been set out by the learned appellate court. Internal page 4 of the impugned decree, my lord. Is the property reasonably required for the plaintiff, my lord, finds? And 7, whether the plaintiff has any accommodation to him, Lordship kindly correlates this with the issues drawn up by the learned trial court, which is at page 47, where I've annexed the trial court's decree. Identical. Issue number 6 and 7.
What sort of adjudication is this by the trial court on 6 and 7?
Lordship.
You are not responsible for that, but देखो ना, trial court is 6 and 7. No, 55. Adjudication 55.
And kindly, Lordships, as Lordships have seen, kindly sees how the trial court decides that.
That is what we saw, internal page 9 and 10.
Lordship.
That was an absurd sort of, but yes, it's a mixed sort of thing.
Yes.
Yes, you are right. The last paragraph before deciding the issue says it is pertinent to mention that since already decided against you.
Lordship.
So this is not
the question of yes.
But the previous paragraph says it would be relevant to mention here that the basic need always varies, etc. Therefore, when one is assailing his or her requirement, should be canvassing or something. His or her requirement by way of a pleading and proof, it cannot be said to be unreasonable automatically without any strong and cogent defense on the part of the defendant. So the burden of proof was reversed.
Yes, my lord.
Wrong approach. But this penultimate paragraph of the under the issue number 6 and 7 is apparently in their favor. That it has to be deemed that they have reasonable
Lordship.
So therefore, appellate court was not entirely wrong in saying that this issue was decided in their favor, in the sense that trial court
expressed its judicial mind that
and they said, but not necessary. Therefore, I'm
view of the default.
So therefore, that itself does not vitiate this finding of the appellate court. I mean, for this line only, not that the appellate court did not independently enter into the issue.
No, the appellate court has gone in evidence everything.
So therefore, it's a not a concurrent finding. You're right. We won't say it's a concurrent
finding.
It cannot be a concurrent finding, but the first appellate court had the power. Section 107 order for Rule 33. So 107 gives the power to the appellate court to do whatever the trial court could do mutatis mutandis.
Also,
and order for Rule 33, even if that was not a ground of decree. Order for Rule 33 is precisely such a scenario where trial court did not grant decree on a particular finding.
Yes.
But appellate court can look into that.
Lordship,
so ma'am, we cannot interfere on this. Sorry.
Only one other finding, Lordship, kindly takes internal page 14 of the impugned appellate decree.
We are there, yes.
Kindly sees, Lordship, paragraph 14.
14.
Kindly sees, my lord, reasonably required. The provision is quoted. Already held in issue number 8. And therefore, Lordship comes to the finding. Thus, the plaintiff is entitled, as has been rightly held. All I am on, my lord, is that the appellate court did not apply its mind to what decree the trial court has passed.
We'll deal with that, but we won't interfere. Sorry. You have tried excellently. This argument is fantastic. But it's your best argument, but we cannot.
I'm much
independently consider first appellate court. The present second appeal arises out of an eviction suit filed against the defendant stroke appellant. Full stop, next para. Learned counsel for the appellant argues that although the trial court granted the decree for eviction only on the ground of default in payment of rent, comma, which was reversed by the first appellate court, comma, the first appellate court proceeded on the premise that the trial court had held the issue of reasonable requirement as well against the appellant, comma, which is contrary to the records. Full stop. Learned counsel takes us to the findings of the learned trial judge on the issue of reasonable requirement and argues that the learned trial judge ultimately dealt with the issue by observing that in view of a decree having already been granted on the ground of default in payment of rent, comma, the said issue need not have been further adjudicated. Full stop. Next para. However, comma, the learned first appellate judge observed in several places of the impugned judgment that there is no need to interfere with the findings of the trial court, comma, as if the issue of reasonable requirement was held by the trial court in favor of the plaintiff stroke respondent and against the appellant. Full stop. It is, comma, thus, comma, submitted that the learned first appellate judge erred in law in acting dehors jurisdiction by proceeding on the premise that it was affirming the judgment of the trial court on the issue of reasonable requirement as well, whereas the trial court refused to grant a decree on the ground of reasonable requirement. Full stop. Next para. Upon a careful perusal of the first appellate court's judgment, comma, we find that the first appellate court independently applied its mind to the issue of reasonable requirement as well, and only upon consideration of the evidence on record and appreciation of the same, comma, arrived at the finding that the plaintiff stroke respondent was entitled to a decree of eviction, comma, although not on the ground of default in payment of rent, comma, but on the ground of reasonable requirement. Full stop. Next para. A conjoint reading of section 107 and order 41 rule 33 of the Code of Civil Procedure clearly indicates that the appellate court exercises similar powers as the trial court, and since the first appellate court is the last court of facts, comma, it can, comma, even if a particular finding is not specifically challenged by the respondent by way of a cross objection, comma, look into the errors of the trial court and pass further or other decree and or reverse the findings of the trial court even if the respondent has not challenged the same. Push up. Next para. On such premise, comma, we find no scope of interference with the first appellate court's finding, comma, since the first appellate court has appreciated the evidence and come to its finding on reasonable requirement in a particular manner, and there is no error of law tainting such judgment. First up, it is well settled that the appellate court does not substitute its own views for that of the first appellate court merely because a different view might be possible on the facts of the case. First up, next para, insofar as the observations of the first appellate court that it was affirming the findings of the trial court, comma, we do not find that such minor discrepancy vitiates the appellate court's judgment or goes to the root of it, comma, since, comma, in the first place, comma, there was some discrepancy in the judgment of the trial court in that regard as well. First up, we say so because the trial court, comma, while deciding the issue of reasonable requirement, comma, observed that when one is double inverted assailing double inverted clause his stroke her requirement by way of a pleading and proof, it cannot be said to be unreasonable automatically without any strong and cogent defense on the part of the defendant. First up, although such reversal of burden of proof might not have been legally correct, comma, the tenor of the said sentence indicates that the trial court was of the view that in view of the pleading and the proof of the plaintiff as to the plaintiff's reasonable requirement having not been rebutted by the defendant stroke appellant, comma, the issue of reasonable requirement otherwise could have gone in favor of the plaintiff stroke respondent. Full stop. However, comma, ultimately the trial court did not decide the issue as such, since it had already decreed the suit on the ground on a different ground of default. Full stop. Accordingly, comma, we do not find any substantial question of law involved in the present appeal. Full stop. Thus, SAT 278 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 2 of 2025 is disposed of accordingly. No address to cause.
Lordship, may I pray for one indulgence only?
Time will বেঁধে যাবে ওই execution পিছিয়ে গিয়ে time দিতে পারবে।
Lordship,
Next.
may I seek one indulgence only, having regard to the social position of the appellant?
Social position ended in the with the
The
session.
decree is in execution. He'll have to
Just because they
some
don't
time
have
period.
they have a better position, social position, they cannot be deprived of their rights.
Some time periods may.
Execution case, you give your client advice, whatever advice you can in the execution case. The execution is the start of the woes of the landlord. So follow that dictum and proceed accordingly.
I am obliged.
Item number 17.
Next. 17? Yes. Yes, Mr.
Partition to my lord's direction, my lord, I have in the copy of the section 5 application.
Mr. Banerjee is referring. Yes. Section 5, what is the delay, sir?
38 days.
What is the reason?
This is for handing over the plaint and other documents.
To you or someone else?
To me, my
You,
lord.
very In view of sufficient explanation for the delay having been furnished, comma, can 2 of 2026 is allowed, thereby condoning the delay in preferring FMET 491 of 2025. What is CAN 1?
Can one, my lord, for
It will come later, after admission.
after admission.
Yes, what is that, please?
My lord, suit for partition, my lord. My lord, I am the defendant. My lord, in the partition suit, my lord, the Order 31 Rule 1 and 2 injunction petition by order of the status quo, my lord, I am depriving to my lord my work of construction.
That is the purpose of status quo.
My lord,
So that you are deprived of your construction.
my lord, being my lord, since this is a partition suit without claiming an equity, my lord, I inherited this property from my father. My lord, the plaintiff, my lord, purchased from the other co-sharers. Now when
In your written objection, did you disclose, are you making construction? You have made
Yes.
construction already.
no, my lord, construction I have made and construction is going on. Some boundary wall is going on. Now, my lord,
So what is the stage of the construction? What is...
now, my lord, in view of this, my lord, the order of status quo, my lord, the construction.
No, did you
work has-
disclose before the trial court that you have already made construction?
Yes,
or
yes, my
something?
lord, that is, my lord, in their plain they also stated, my lord, I have started construction.
What was the stage of the construction when this injunction was passed?
My lord, the learned trial judge, my lord, says, my lord, since I am the co-sharer, I cannot, my lord, my lord, make any construction, my lord.
No, but if you construct, if you create a boundary on the better side of the property, then
No,
there will be
no.
unnecessary complication. Why?
What?
Property should be maintained as it is in a partition suit. Unless there is exigency, some exigency, suppose you have almost completed your construction, only the plastering is left on all those things we
Is it
construct.
an ad interim order or contest order?
Ad interim order.
Not ad interim. What are you saying?
Contest.
Till disposal of the suit.
Yes, my lord,
Don't mislead
contested.
the court, Mr. Ghosh.
My lord,
You're
contested.
too senior for that.
Okay. This is till disposal of the, so you lead evidence, so get it disposed.
So what is your ground otherwise? Did you disclose what is the stage of the construction? You are building a boundary wall, constructing a boundary wall,
My lord,
thereby
boundary,
dividing the property.
no, boundary wall as well as my lord, my residence. My lord, that is, my lord, the
What is your objection? Written objection in the trial court? Trial court written objection?
my lord, before the trial court, my lord, my objection at page
Yes.
in can 1, my lord, page 38.
So you said you have been living there since long.
Yes.
There was a repair work necessary for the boundary wall. That is your paragraph 10.
Paragraph 10.
Paragraph 10.
Right.
So you say that পূর্বাধিকারীর আমল হইতে নারীর নিজ অংশে অপরের বিনা সংশ্রয়ে বসবাস করত ভোগ দখল করিয়া আসিতেছেন। সো ইউ আর রিসাইডিং দেয়ার। এক্ষণে বাদীর ভদ্রাসন বাড়ির বাউন্ডারি ওয়ালের সামান্য একটু অংশ ভাঙিয়া যাওয়ায় বাদীর, আচ্ছা ভেরি গুড, ভাঙিয়া যাওয়ায় তথা পঞ্চায়েত আইন অনুসারে ভূমি ছাড়িয়ে রাখিয়া বাদীর জ্ঞাতসারে নির্মাণ করা আবশ্যকতা সব প্রাচীরের অংশ।
মানে এই মুহূর্তে বিবাদী তাহা বসবাসের বাড়ির ঘেরাবেড়া বাড়ির সামান্য প্রাচীরের অংশটুকু মেরামত করিতে না পারিলে এই বিবাদীর পক্ষে তাহার পরিবারের মহিলাদের লইয়া বসবাস করা কঠিন হইয়া পড়িবে।
So you are saying you are only repairing the boundary wall.
Boundary wall.
Yes, what do you say to this, Mr. Banerjee?
Yes, my lord, if your lordship kindly sees the photographs that was
These were
placed
not in the
before
trial court.
So commission was
before
not
the court,
made.
Trial court, it was there. My lord, if your lordship says. It's a boundary wall, he is saying. Can it be?
What boundary wall?
Yes. And this is his house. Just he is trying to encroach my property, my share. This is not the nature
As
of the
my learned
boundary wall.
brother said, was there a local inspection here?
No,
No, my lord,
Is your case that yes?
yes, my lord, there
Who
was,
annexed this photograph? Who annexed?
my lord, they have before the trial court,
How do you know that?
because they have not annexed it here, my lord.
The
But we
Bibadi
have
Pokke
taken-
Dakila Firisti.
Yeah,
So
that
it's
was
not
there.
there. Photographs are there. Let us see. Page 42. Photographs are not there.
Because we have taken the photographs and we have produced the same before the court below.
No, but there is no reference to any photograph.
Yes. Not only that, my lord, if your lordship kindly sees the paragraph, what is the finding of the court below?
Let us
At
see.
this stage, defendant submitted by GT where is clearly written that the defendant is proceeding with the construction of his house. That is at my lord, paragraph last, it appears, my lord, if your lordship kindly
It
sees.
appears.
Construction means this is already constructed.
That is already constructed, that we are not on that issue.
Then
Just
which portion he is constructing?
his construction, he is saying that he is constructing the boundary wall, whereas he is trying to construct enhance the entire building.
GD entry is a part.
Yes, that was a
See
part.
that? Let us see that.
GD
That
entry
was a part of the Firisti.
This is a down.
না একদম না, কিছু দরকার নেই। কেন রিওপেন করবো? অ্যাপিল অ্যাডমিটই করবো। আগে দেখা মিনাল। Yes, what is that, Mr. Ghosh? What is the GD entry you produced that has been referred to?
That is his GD entry.
Yes, we are asking
No,
him.
I have,
only.
my lord, I have,
Page
my lord, I
42
have,
is the Firisti. It refers to several things, including a magistrate court something. OC ke dorkhaste xerox copies 5.
my lord,
So annex the Firisti, not annex the GD.
my lord, OC dorkhasto is there, my lord, page 50.
Page 50, 50,
Page
yes.
51.
51 আছে।
And my lord, the page 50 is the my lord, field inquiry in connection with the 144 proceedings.
144 proceedings is by your client.
By his client. And that has been dropped.
Page 51 is your complaint. You are Mohsin Mondol.
Yes, 51 is my complaint.
So there you say, বসত বাড়ির কাজ শুরু করিয়াছি।
Yes, my lord, that is my case,
Your
my
court.
lord.
Contradictory.
বর্তমানে আমার বাড়ি খোলামেলা such and such.
My lord, kholamela means, my lord, I have, my lord, started my construction and, my lord, this since the boundary of my
In your objection, you don't say that.
Yes.
In your objection, you try to mislead the court. You say that when I am living there for long, when I wanted to repair my boundary wall, I can't live with the women of my family in the house because the boundary wall is damaged. That's why I want to repair the boundary wall. You are caught out when by your own GD entry where you say I want to build a Bosot Bati. That was relied on by the trial court.
মানে কাইন্ডলি কামসা আমার পৈতৃক জায়গার উপর বসত বাড়ির কাজ শুরু করিয়াছি বর্তমানে আমার
Please stop there. বসত বাড়ির কাজ শুরু করিয়াছি means
বসত বাড়ি মানে that
বসত বাড়ির কাজ শুরু করিয়াছি not does not mean that you reside there. It means that you are constructing your বসত বাড়ি or doing some construction work there.
মানে বসত বাড়ি since I am residing there for মানে minor construction I have started বসত বাড়ির কাজ শুরু করিয়াছি
বসত বাড়ির কাজ শুরু করিয়াছি means what?
মানে existing building মানে I have started construction.
Sorry, no.
And মানে kindly see বর্তমানে আমার বাড়ি খোলামেলা থাকায়
Read on.
বর্তমানে আমার বাড়ি খোলামেলা এলাকায় রহিয়াছে।
read on.
বাড়ি শুরু করিবার পূর্বে নিম্নলিখিত আমার বাড়ির পাশে অন্য ব্যক্তিগণের কথা অনুযায়ী আমি ডাক করিয়া নির্দিষ্ট মাপজোপ করিয়া বাড়ি তৈরি করিয়া কাজ শুরু করিয়াছি।
Sorry.
কিন্তু
You know that much Bengali.
without claiming any equity, my lord, I may be permitted to,
No,
my
no,
lord,
no question of any. There is no error in the order.
my lord, being my lord in the partition, my lord, I am not claiming any equity.
No, don't build that. Right advice by the trial court. The present appeal arises against an order whereby status quo was granted in favor of the plaintiff stroke respondent in respect of nature, character, and respective position of the parties in, with regard to the suit property till disposal of the suit. For some next para, learned counsel for the appellant submits that the appellant just wanted to repair the boundary wall of the premises where he is already residing, at which juncture the status quo order was passed, thereby affecting the privacy of the family members of the appellant. For some next para, however, from the trial court's order, we find reference to a GD entry dated November 9, 2024, lodged by the appellant, from which, as per the trial court, the defendant was proceeding with the construction of his house. We find from a copy of the same, which is annexed to the stay application filed in connection with the appeal, that the tenor of such complaint of the appellant was that the appellant had started making construction of a building on the suit property. Next para. However, the same is in stark contradistinction with the averments made in the written objection filed by the defendant stroke appellant to the injunction application in the trial court, where an impression was sought to be given that the appellant was merely attempting to repair the damaged boundary wall. Thus, since the property is joint in nature and ought to be maintained in statu quo during pendency of a partition suit, we do not find any legal or factual error in the impugned order whereby status quo has been directed to be maintained with regard to the nature, character, and respective positions of the parties in the suit property. Hence, FMAT 491 of 2025 is dismissed under order for Rule 11 of the Code of Civil Procedure. Can 1 of 2025 stands dismissed accordingly as well. No address to cause. Mr. Banerjee, we are not referring to this because you don't have a right
Yes,
of hearing.
sir.
We're dismissing at the order for
As you
So we are not referring to it. We are
Yes, yes.
referred to it in the order also.
Right.
We are referring on Mr. Your learned friend's
GD entry.
his GD entry. You should not have annexed this GD entry.
Item number 18.
Yes, next.
My lord, I am praying for not today.
Refused. You move the matter.
No, no, sir, I am not.
You are sufficiently
No, no,
senior.
my lord, I am not the advocate on record.
Is the advocate? Then you
Why
don't have a
not?
right to
Why-
pay for time.
Or no, Vatajan is on the.
No, no. Appeals
Fix- is
order
not-
for matter, then it goes out of it. Sorry.
But can I not today only?
No, no.
Then short pass over.
Yes. Short pass over.
Item number 19.
Yes, Mr. Mukherjee.
But 19 possibly they will not appear because by this time we have already taken the position, my lord.
What are you? Oh, second appeal.
If you let's kindly see the last order passed by your lordship, my lord.
You are the respondent.
I am the respondent.
Last order. Last time copy আছে last order.
Order sheet জেরক্সের মধ্যে আছে ওই যে
ও respondent আগের বার অফিস। Oh.
I have the copy if necessary. আছেন জজ সাহেবের কাছে?
eviction suit করেছিল respondent, appellant counterclaim করেছিল declaration of tenancy right. ওর ডিক্লারেশনটা ডিসমিসাল, কাউন্টারক্লেমটা আর এর এভিকশন ডিক্রিটা ভালো একটা অ্যাপিল করতে যদি আইদারের ক্ষেত্রে থাকে তখন ওকে জিজ্ঞেস করা বলেছিল যে এভিকশন ডিক্রিটার এগেইনস্ট অ্যাপিলটা করেছে। যদি তার মানে কাউন্টার ক্লেম ডিসমিসাল এগেইনস্ট কোনো অ্যাপিল নাই,
আমরা ওটাকে মেনে নিচ্ছি আর কি।
মেনে নিচ্ছে যে ক্লেম
হুম,
অ্যাজ এ ম্যাটার অফ কোর্স এভিকশন ডিগ্রি তো
হুম, হুম।
Now they have, I don't know whether they have prepared any appeal or not because no copy has been served also. And by this time, my lord, this is the bailiff's report, full satisfaction, my lord.
we'll give a last chance to them, Mr. Mukherjee. We will record your submission. At the time of call, comma, none appears for the appellants. Full stop, learned counsel for the respondent submits that the eviction decree against which the present second appeal has been preferred has in the meantime been satisfied by the plaintiff stroke respondent taking possession in full satisfaction of the decree. Full stop. The photocopy of the certified copy of the order recording such satisfaction is handed over and is kept on the record. Full stop. Next para. On the last occasion, comma, when the matter was called on for hearing, comma, the aforesaid aspect of the matter was discussed, and on instruction, comma, learned counsel for the appellants apprised the court that the appeal has been preferred only against the decree of the first appellate court, whereby the eviction decree passed in the respondent's suit was affirmed, comma, thereby indicating that no appeal had been preferred with regard to the dismissal of the counterclaim of the appellants, comma, seeking to declare their tenancy rights. So, be that as it may, comma, a last chance is being given to the appellants to argue the appeal under Order 41 Rule 11 of the Code of Civil Procedure. First up, let the matter stand adjourned for the day with the above observations.
Well, let that be kept with the record, my lord.
Recorded in the first sentence.
Item number 20 with 21.
2021, my lord.
Yes.
I appear for the appellant. Lord, pursuant to your lordship's last direction, Lord, the respondent disclosed that the respondent number 2 have died. Lord, they have furnished, my lord, the details and better particulars. Lord, they have stated that the respondent number 2 have died in the year 2014. Lord, in any event, my lord, the principle of Order 22 will not apply, my lord. Your lordships can invoke Order 1 Rule 10 and bring the legal.
Then the decree
Lord, it
is
is
an appeal.
Ad interim order.
Your suit?
No, my lord, it is the suit of the respondent number 1 plaintiff. The
No,
person,
then the death occurred prior to the passing of the impugned order also.
prior to passing of the
That will hit the impugned order.
Let's.
We require their presence. Please give a notice to them. We'll give a last chance to them to appear and argue before. What is the date of the death?
The date of death is 26th of June 2014. And my lord, 14. My lord, I would be also taking a preliminary point that the court has no jurisdiction also. That this is a commercial dispute. And third of all, my lord, the learned court granted ad interim order beyond the prayers of the injunction application.
Lord, counsel for the appellant submits that the interim order of injunction was passed beyond the prayers made in the injunction application before the trial court. Subsequently, comma, the suit ought to have been filed before the concerned commercial court. Next para, however, comma, a more foundational issue crops up as learned counsel submits that the respondent's advocate has communicated to him that respondent number 2 died on June 26.
26 June.
June 26, 2014. First up, if it be so, comma, a question arises as to whether the impugned order can subsist in the eye of law, comma, having been passed inter alia against a dead person. First up, be that as it may, comma, this is the second occasion when none appears for the respondents at the time of call. First up, as a last chance to the respondents to appear and argue the matter, comma, the same is adjourned for the day. So give a notice to the other side if you can.
That's
that we took up but could not take up.
Number 22.
Them praying a short Passover also.
Move it.
That's if
Not in every matter. Move the matter. You argue matters. Other matters you have argued. Argue. What is the matter?
My senior is not instructed me to this matter.
Who is your senior?
Short Passover.
Who is your senior?
Shudranjan Chakravarti. He is doing a matter in court number 7.
Well,
That's it.
pass.
Grateful, Lordship.
Password. Short. It up. This is the password. You order it.
Item number 23.
23, my lord, I'm appealing for
Yes,
the appellant.
Chatterjee, what is that?
My lord, plaintiff is the appellant before my lord. In a suit,
Take the microphone a bit closer to you. Yes.
my lord, plaintiff is the appellant.
Yes.
My lord, now in a suit, my lord, where my lord I challenge, my lord, the sale deed executed by the defendant number 3 and 4 in favor of the defendant number 1 and 2, my lord, is void. My lord, my pleading in the plaintiff, my lord, that my lord, I am the first class heir, and my lord, being the first class heir, my lord, they do not have a right to, my lord, sell the property in question, my lord, without giving me that preferential right. Now, my lord, this is a suit, my lord, under my lord, my respectful humble submission, my lord, this is under section 22 of the my lord, Hindu Succession Act. Now, my lord, what transpired from the learned trial courts, my lord, both the appellate court and the learned trial court is, my lord, the learned trial court has held, my lord, since he is also one of the co-owner, my lord, there is no, my lord, law preempting, my lord, a co-owner to sell his property. My lord, trial court dismisses on that ground. Now, my lord, appeal court, my lord, goes to the section 44 of the Transfer of Property Act and says, my lord, the restriction is, my lord, to the third party who cannot enter.
That's a different.
So, my lord, these are the two contentions.
To Hindu Succession Act din to. Question is, Mr. Chatterjee, whether the sale deed is bad, as the trial court said.
No, that has not gone into because
you have a prior right of refusal, but you could have asked for having a preemption sort of. I mean, you did not ask for that.
No, my lord,
you outright challenge the sale deed itself.
section 22, my lord, has two folds. My lord,
my
lord, we have one.
Please give a copy. Onatta din.
And খুলে দিয়েছিস? My lord, take section 22.
Yes, please. Just let us read it together.
Yes. My lord, where after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in class 1 of the schedule, and any one of such heir proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. Now, my lord, my right accrues here. Subsection 2, the consideration for which any interest in the property of a deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all cost of or incident to the application. Now, my lord, this section 22, my lord, in my respectful humble submission, proposes a stage where, my lord, the sale is yet to happen. Now, my lord, once the sale is occurred, my lord, this 22, my lord, where, my lord, I have a right under 21 to come before a regular civil suit instead of an application and say the conditions of 22(1) has not been followed. So, therefore, that sale which has taken place is voidable.
One does not mandate a notice. At best, it can be implied. But how do you say that that vitiates the sale? Otherwise, no co-owner would be able to transfer.
No,
any
that is
property. You have a preferential right. We agree.
This is restriction is only with respect to class 1 heirs. My lord, my father and me, two brothers, not even the son of the brother. So it is restricted to only the class 1.
Yes.
So my lord, that restriction is there, and this is admitted position. 3 and 4 is my own brother and sister in class 1. We are following from the same, my lord, branch. Now, my lord, in that respect, my lord, our honorable High Court, my lord, following Kerala judgment has.
Beside that, the sale deed is bad.
My lord, the court says in such a situation where, my lord, if I can prove before the court that I was not put in notice or I was unaware, then, my lord, the court has a right. I have a right to go in civil court and say that these conditions
Transfer
of 20.
Property Act into Transfer Property Act. Opore lal. Yes.
Now, my lord, if my lord takes a Kerala,
because now, so Chatterjee, you are aware that
44.
No, we are not on 44 actually. 44 is a different regime. Now, notice.
Yes.
Person is said to have notice. Sorry, section 3 definition. Transfer property.
Yes, yes. 3. My lord.
Section 3 definition of a person is said to have notice. The last one. So, Explanation 1, please.
Yes.
Correct.
Where any transaction relating to immovable property is required by law to be and has been effected by a registered instrument, and any person acquiring such property or any part or share or interest in such property shall be deemed to have notice.
No, sorry, this is not
Yes.
you are not acquiring. No.
No.
Right.
Now, my lord,
Let's look into this judgment.
yes, my lord, kindly takes up, my lord, Kerala. My lord, Kerala is the first judgment that has been followed
I
by.
understand Kerala is a better on your point, but let us first see how.
No, it has upheld Kerala.
Let
2008.
us see what has been
Yes,
held.
2008.
That a sale is bad. That is something difficult to gulp. So
No,
let
it
us
is
see that having been-
voidable. My lord, I have a right to approach the court. I have been shut out of the court saying that I do not have a right.
No,
Well,
you
two
have filed a
things.
suit challenging the sale in favor of a third party.
Yes.
So our question to you, Mr. Chatterjee, whether your suit is maintainable as it is, or you can get a decree, whether the sale is vitiated by Section 22 altogether.
Yes.
Suppose a notice is not given.
Yes.
Then we can carve out a right for you. You can understand that.
Yes.
But if a sale is already over, whether that sale is vitiated in law, Section 22 is not a legal bar to a sale.
Yes. Well, I understand what is falling.
Yes. So
Kindly
let us see
takes
how
up,
that was dealt.
well, what was the issue in 2008? Well, kindly takes up paragraph 16 of that judgment.
Paragraph
16, 2008, my lord, CHM. The first question that falls for determination before us, my lord, has got that?
One second. Yes, yes.
The first question that falls for determination before us is if the transfer has already taken place before filing of an application under section 22(2) of the Act, whether the right of the preemption conferred under subsection 1 of section 22 is lost. So, my lord, while discussing this issue, my lord, kindly takes up.
Therefore, Mr. Chatterjee, do you understand the implication?
Yes.
You do?
Yes.
Because it, in a sense, validates that there can be a sale before that.
Yes.
But your right is not lost.
Yes, my lord, I accept.
So now you are challenging the sale itself.
Yes. Now, my lord, that while discussing this, the court says, my lord, that's exactly my point is, my lord, if I can show before the court that the 22(1) has not been complied, there is an infraction of that statute.
22(1) shows that it mandates a notice to you.
My lord,
we don't see any notice provision in 22(1). It only confers a right on you, and court division bench in this judgment says that right is retained even after the sale. You can still go and enforce your right under 22 by seeking that be transferred to you.
Well, this has been taken care of while interpreting section 22. That if my lord takes up, my lord, from paragraph 22, my lord, the relevant issues will be, answers will be there. Let me just place from paragraph 22 onwards. In the case of such and such, reported in such and such, an application under section 22 of the Act was filed for enforcement of a right of preemption, which gave rise to a miscellaneous case. The defense of the opposite party was that the said application was barred by limitation, which was accepted by the learned trial judge. Being dissatisfied, the petitioner preferred an appeal before the learned district court. The appellate court held that the application was not barred by limitation, nevertheless dismissed the appeal on the ground that no appeal lay against the order impugned. Being dissatisfied, the petitioner preferred a revisional application under section 115 of the court. While deciding such a revisional application, a learned single judge of this court held that the application for preemption was really barred by limitation, as according to his lordship, Article 97 of the limitation was applicable and not Article 137 thereof, as wrongly held by the appellate court below. However, his lordship accepted the plea of the opposite party that the appeal before the first appellate court was not maintainable. At this stage, the learned advocate for the petitioner prayed for treating the application as one filed against the original order passed by the learned trial judge. However, such prayer was refused, as his lordship was of the view that no purpose would be served by taking such course in view of the fact that the application was barred by limitation. His lordship further held that the petitioner ought to have filed a suit instead of filing a miscellaneous case for enforcing his right of preemption by relying upon division bench of Kerala or High Court in case of such and such. We at this stage refer to the following observation of the learned judge.
Yes, yes, undoubtedly, you can file a suit.
Yes.
You are not saying you have to file an application only. You can file a suit under section 22 to enforce your right of preemption.
Yes.
But that suit has to have that prayer, not a cancellation of the sale.
No, it says, my lord, the Kerala says, or our High Court says, one has to recourse to section 34 of the Specific Relief Act, where I have to seek that cancellation.
Let us see the main prayer. Have you annexed the plaintiff?
Yes, yes.
Mr. Chatterjee?
My lord, application, my lord, can takes up the can 1.
Yes, we are there. Page 14.
Page 14. Prayer A, my lord, decree of declaration.
No, Mr. Chatterjee, you have not even asked for that right of preemption. You merely seek the result. What would be the result of declaring the suit? That sale would be cancelled, but you are not still not praying for purchasing the property.
Because you should show your readiness.
Correct.
Yes.
Not only that, you must pray.
Your bona fide, your willingness.
Yes,
You have to
Lord,
ask
that-
for purchase of the
Lord,
property.
that is, my lord, somewhere, my lord, I have pleaded to that extent. But, my lord, with due respect to this judgment, my lord, this
Reality,
says, my lord, I have a right to seek cancellation of that seal.
That's a consequence.
No, my lord, kindly
Not-
takes up the judgment, my lord.
Because
full
you have to
marks,
deposit
because
that
that
amount
judgment
probably.
says, my lord, I have a right to seek cancellation even if I do not pray for, my lord, the
You
preemption.
cannot just seek a cancellation and you sit tight and you don't ask for purchase of that property. Why should that be cancelled? That cancellation will only be in aid of your prayer under section 22 to have a purchase of the property. You have to want to purchase the property by exercising your section 22 preferential right. If you ask for that, as a consequence, obviously that deed will be cancelled if that prayer is granted to you.
Just like you see 8 of the Land Reforms Act.
Whatever. So you have not asked for that relief, and you ask for a cancellation of the sale.
Possibly, my lord, this
Impossible.
finding,
Impossible.
if I try, my lord, this placing this paragraph, if I can mold my lord's mind.
Place the paragraph. We have read the paragraph actually, but we place it.
Yes. Now, my lord, the quotation of that single just, my lord. Thus, it will appear from the provisions of section 22 that by subsection 1 a right is conferred, but there is nothing in that subsection to indicate what procedure is to be followed in the matter of enforcement of that right.
That culminates in accordingly the right conferred by section 22 can be enforced only by institution of regular suit. Next page.
Yes. Now, my lord,
After the underlying portion.
after the underline, in
So
case
that is the conclusion.
no, my lord, thereafter,
Then an analogy, as my little brother is drawing with Land Reforms Act, exactly similarly an analogy has been drawn.
for enforcement, accordingly, the right conferred under section 22 can be enforced by the institution of regular suit.
Do by all means file a regular suit, but you did not.
But, my lord, if it has upheld, my lord, kindly gives me a moment, my lord.
Kerala also said so. It is Kerala only which is being quoted.
Yes, Kerala has said, my lord, just the particular paragraph I'm just referring to, my lord, give me a. My lord, kindly turns on, my lord, the internal page 15 of the judgment, and my lord, or my lord, starts in paragraph 24.
Trial code is a good judgment, Mr. Chatterjee. The trial code
Kindly
is
takes
good
a paragraph 24.
Please, short.
24 of the division bench, our division bench.
My lord.
Yes. Page 20, para 24 of our division.
Our division.
It
Yes,
is
yes.
It is
My lord, in that, there is a sub-paragraph 9. My lord, this is where our division bench has upheld it, and my lord had also confirmed it. My lord, may I just place paragraph 9 in paragraph 24. In the light of what we have stated above, we are clearly of the view that the petition filed in the court by the present appellant under section 22 of the Act was misconceived and was not maintainable. The first respondent already sold his interest in the favor of the respondent number 2 to 4, and no steps have been taken by the petitioner in the matter contemplated by law for assertion and enforcement of a right under subsection 1. It has to be noticed in this connection that even though subsection 22(1) does not confer a right in co-heir to acquire the share of another co-heir who proposes to transfer the share, there is nothing in that section which warrants an alienation effected in contravention of the provision, which being regarded as void. Such an alienation will at least be only voidable at the instance of the sharer who institutes the suit for enforcement under subsection 1, and subject to the said limited consent, sale will be operative and binding.
Fully agree.
So, my lord, I, my lord, go under.
Know what you read right now.
Yes. Then, my lord, it says the remedy is, my lord, the next subparagraph. My lord, the lower court was perfect in holding that the prayers incorporated in the petition for declaration of invalidity of the sale effected by the first in favor of the respondent 2 to 4, and for a direction for transfer of the first respondent share in favor of the petitioner as further relief consequential to such declaration are totally outside the scope of an application under section 22(2) of the Act, and we have no hesitation to uphold the said finding. We cannot, however, see our way to agree with the view expressed by the lower court that the proper remedy for the petition is to suit for specific performance. Where there is no agreement, either contractual or statutory conveyance of the property, there can be no question of a party seeking the relief of specific performance. The remedy, as we have already indicated, is only to file a suit for enforcement of limited right of purchase confirmed by subsection 22(1), and in such that the question of invalidity of the sale already affected by the court will be incidental, investigated with it and decided. So, my lord, this prayer for seeking cancellation, my lord, I understand. My lord says, my lord, one prayer of missing
We'll
that
see
I-
what we say in our judgment. Dismissing an appeal. The present second appeal has been preferred against a judgment whereby the first appellate court affirmed the dismissal of the plaintiff stroke appellant apostrophe suit for cancellation for declaration that a sale deed executed by defendant numbers 3 and 4 in favor of defendant numbers 1 and 2 in the suit is void and inoperative and consequential relief of injunction. For sub next para, learned counsel appearing for the appellant argues that both the appellant and the defendant stroke respondent numbers 3 and 4 are class 1 heirs of the original owner of the subject property. For sub next para, learned counsel submits that since the appellant, as such first class heir, has a right of preemption, has a right of prior purchase under section 22 of the Hindu Succession Act, in consonance with the same, the plaintiff stroke appellant filed the suit for declaration of the sale deed executed by the defendant numbers 3 and 4 stroke co-sharers in favor of third parties within bracket defendant numbers 1 and 2 bracket close as void and inoperative. However, the courts, both the courts failed to appreciate the nature of rights conferred under section 22 in dismissing the suit on the premise that there is no bar in a co-sharer transferring his share of the property to third parties. For some next part, it is further argued that the first appellate court went into the question of applicability of section 44 of the Transfer Property Act 1882, which is not attracted in the present case at all. For sub next para, learned counsel cites a coordinate bench judgment of this court in the matter of Srimati Arati Das versus Bharati Sarkar and others, reported at AIR 2009 Cal 8, in support of the proposition that it is not necessary for a co-owner for a co-sharer to file an application under section 22 of the Hindu Succession Act, 1956, to assert his rights under the said provision, but the appropriate remedy is a suit seeking declaration that the sale deed executed in favor of the third party is void. For sub next para, however, we are unable to accept the contention of the appellant. For sub next para, on a careful perusal of Srimati Arati Das Supra, it is clear that the scope of section 22 of the Hindu Succession Act was being discussed therein, in which context the coordinate bench concurred with the view of the Kerala High Court to the extent that the petitioner therein, within bracket co-sharer, bracket closed, ought to have filed a suit instead of a miscellaneous case for enforcing his right of preemption. Next para, in the said judgment, relevant portions of the Kerala High Court judgment were quoted to the effect that it will appear from the provisions of section 22 that by subsection 1 a right is conferred, but there is nothing in that subsection to indicate what procedure is to be followed in the matter of enforcement of that right. Subsection 2 provides for cases where the parties fail to agree on the amount of consideration to be paid for the transfer of the property and lays down the procedure for having the amount of consideration determined by the court on an application being made to it. Thus, it was held that under subsection 2 an application may be made to the court, but the scope of that application is quite limited and may be made only for the purpose of determination of the amount of consideration and not for the purpose of enforcing the right conferred by subsection 1. In cases where any statute creates a right, it was held, without specifying the procedure for enforcement of the right, the person intending to enforce such right shall have to resort to the procedure contained in the Code of Civil Procedure for enforcement of his right. And accordingly, the right conferred by section 22 can be enforced only by the institution of a regular suit. In such context, it was further observed that an alienation by co-sharers of the first class co-sharers, being class 1 heirs, in favor of third parties, as at best can be voidable at the instance of the sharer who institutes a suit for enforcement of his right under subsection 1, and subject to the said limited contingency, the sale would be operative and binding. It was further observed that the prayers incorporated in the petition for a declaration of invalidity of the sale effected by the first respondent in favor of respondent numbers 2 to 4 in the said case, and for a direction for transfer of the first respondent's share in favor of the petitioner as a further relief consequential to such a declaration, were totally outside the scope of an application under section 22 within bracket 2 of the Act, and the said finding was upheld. Next para, thus, the subtext of the cited report was that as a consequence to enforcement of a preferential right conferred under section 22 within bracket 1 of the Hindu Succession Act, 1956, a suit may be filed in which a consequential relief of declaration that the sale deed in favor of a third party is void. Next para, however, such prayer for declaration of the sale deed in favor of third party as void in isolation, without any foundational prayer for enforcement of preferential right of purchase under section 22 within bracket 1 of the Hindu Succession Act, does not come within the ambit of the said provision at all. Next para, in the present case, the plaintiff stroke appellant merely sought for a decree of declaration that the sale deed executed by defendant numbers 3 and 4 stroke co-sharers in favor of defendant numbers 1 and 2 stroke third parties was void and inoperative, and sought for a consequential relief of permanent injunction restraining the defendant numbers 1 and 2 stroke purchasers from transferring the suit property to any person and or creating disturbance in the peaceful possession of the suit property. The prayer asserting preferential right of purchase under section 22 within bracket 1 of the Hindu Succession Act 1956, was however conspicuous by its absence in the plaint of the suit filed by the present plaintiff stroke appellant. Next para, thus, yes.
May I just, since my lord is referring
No,
to Kerala.
No, in the middle of the judgment.
Yes.
The learned trial judge was thus justified in dismissing the suit on the ground that there was otherwise no bar in law in a co-sharer transferring his share of the property, his share of a joint property in favor of third parties. Next para, the appellate court, although traversing a different trajectory of section 44 of the Transfer Property Act, which was entirely irrelevant in the context, in the same breath, also affirmed the findings of the learned trial judge on merit to the effect that there was no bar to a co-sharer transferring his share of a joint property to a third party. Next para, although agreeing with the proposition that such transfer is attended and circumscribed by the right of preemptive preferential purchase under section 22 within bracket 1 of the Hindu Succession Act, in view of the plaintiff appellant having not asked for such preferential asked to assert such preferential right at all, the suit as it stood, was not maintainable and was rightly dismissed by the courts below. Accordingly, there is no substantial question of law involved. SCT 62 of 2026 is thus dismissed under Order 14 Rule 11 of the Code of Civil Procedure. Can 1 of 2026 is also dismissed accordingly.
Much obliged. Only for academically, my lord, may I just...
I'm not interested in academics.
No, my lord,
Too much of academics
3 lines
throughout the day.
My lord, since my lord is upholding the Kerala as well, so my lord, Kerala has 3 lines which says, I did not pray for that. Though that has not been recorded in 2008, my lord, but it is recorded in...
Go by our High Court. We'll come back and take up the Passover matters if the parties are ready. Password.
Item number 18.
Yes, madam. For that.
Yes.
It is the.
Thank you for coming. Yes. You are not reading the matter or what?
No, I has actually not reached the court. I was in another court.
Oh, then it's fine.
Actually, my lord, it is the matter challenging the order of injunction inadvertently filed before the district judge's court, which having no jurisdiction.
You are the plaintiff.
I am the plaintiff in a partition suit.
Injunction refused.
Injunction ad interim stage granted. Defendant appeared and filed on written objection saying that actually the suit property is the share of one of our uncle, 1/3 share. Now, according to the defendant, that share has already been transferred by way of deed of settlement in their favor. And the learned court at contested stage refused the injunction. And challenging that order, I first preferred an appeal before the court of district judge. After hearing, district judge held that under Bengal Agra Assam Civil Courts Act, he has no jurisdiction to entertain that order and refused. And accordingly, I approached here. Now, the Section 5 application which I content, the delay, the period
Here
of
there is a
delay-
Section 5 before us.
Yes. The period
You have
of
to
delay.
serve and come back.
Yes, I have to. But back to that, my lord, I need one leave. Inadvertently, my lord, the respondent number 1
Yes.
has already been dead. I overlooked it. Has already been substituted in the court below. Prior to filing this appeal, leave may be granted to correct the cost.
Yes, yes. As in terms of the prayer of learned counsel for the appellant, leave is granted to the learned advocate on record for the appellant to delete the name of the deceased first respondent and insert the names of his heirs and legal representatives, who, we are apprised, have already been substituted in the trial court, in the cause title of the memorandum of appeal and petitions during the course of the day. Full stop. The appellant shall serve
Can 2
copies of Can 2 of 2026 on the parties, including the added parties, indicating that the matter shall be listed under the same heading on May 19, 2026, when an affidavit of service to that effect shall be filed by the appellant. So you could have asked for this. Should have instructed her.
Actually, she.
Section 5, we have to. চলে আসবে কিন্তু 5 নম্বর সাত দুটো বিষয় আপনি দিয়ে চলে আসুন 9 নম্বর কোড মানে এবারই কি আরে ঠিক আছে আমি চলে যাচ্ছি আরেকটা 5 মিনিট
Item number 20.
Well, I am for the appellant, my lord.
Right.
This is judgment in reversal, my lord. The plaintiff before the learned trial court paid for under cancellation of the deed prepared in 1981. He filed this suit in 2004. The plaintiff's father died in 1969. Then, my lord, her mother, they become major in 1985, my lord, elder daughter, then others. In 1981, the mother sold the Schedule 2 property to the appellant herein, saying that she needs money for her treatment and marriage of the youngest daughter. That is. And then they filed the suit in 2004, after 23 years, saying that we are minor at that time, so we cannot file the suit. We paid for the...
transfer the property on our behalf.
My lord?
It was transferred on their behalf also by the mother.
Yes, my lord, they transferred and my name is recorded.
No, not that. They are challenging on the ground that they were minors, therefore the mother could not transfer on their shares.
My lord, that is. And moreover,
but
my
they
lord,
did not come within the limitation period after
No,
attending
my lord, that point I have taken in the trial court, and that is the trial court rejected their suit.
On the ground of limitation?
Limitation, not limitation, on the ground that they have not paid for cancellation of the deed.
What did they pay for?
They paid for the
title,
declaration and the title and injunction.
There was no prayer for cancellation?
No cancellation, but the appeal court cancelled the deed.
Without any relief?
Amen.
Let us see the appeal court judgment.
Losses. And it is my possession in 1981. I have recorded my name in Yarwar. I have cultivating the land. There's a building there. And বসুন।
No, they asked for the deed. They asked for a declaration that the deed is void, illegal, and not
Yes.
binding. So,
Void, declare the whole deed void, but what is the about the share of the mother? And they are adult, my lord. They are adult in 1985. And they have challenged in 2024. And the appeal court judgment is saying that is when the whole deed has been done.
what is the trial court judgment, Mr. Chakut?
First annexure, my lord. First annexure.
Okay.
And they were asked about the area of the land, plot number, what is it? They cannot say anything. And they're saying we are in possession, we are cultivating.
So one point is that the entire deed could not be declared void because the mother's share was there. She has had the right to sell her share at least.
And minor daughter, younger daughter used to minor that time.
Maybe, but.
And another thing, my lord, they're major. Into 1985, the elder daughter become major.
But they
And
did not
by
challenge-
80, 90, they have become we have taken.
So beyond the limitation period from
We have
attaining
taken, but
majority.
that is
So
not.
how was that dealt with by the trial court?
My lord, can be limitation.
That portion that they did not challenge the deed.
I have challenged. I have challenged. I have taken time possession in owner. Page 71, Rossif's candidacy, they have not paid for cancellation of the deed. One thing. And
so we are admitting on these two grounds.
Malda.
The present second appeal will be heard on the following substantial questions of law. 1, Roman 1. Whether the first appellate court substantially erred in law in decreeing the suit filed by the plaintiff stroke respondent, comma, thereby declaring the entire impugned deed dated November 17, 1981 to be void, comma, in spite of the vendor stroke mother of the plaintiffs being entitled at the relevant juncture to transfer at least her share in the said property in favor of the appellant. Next, Roman 2. Whether the first appellate court substantially erred in law in decreeing the suit, comma, being barred, despite the same being barred by limitation, comma, since the plaintiff stroke respondents did not assail the impugned deed within the statutory limitation period after having attained majority. Any interim application? Stay.
Yes, my lord. Can one.
There shall be stay of operation of the impugned judgment and decree of the first appellate court dated December 19, 2025. Of the first appellate court Corona. Stay of operation of the impugned judgment and decree dated December 19, 2025 passed by the learned civil judge, senior division at Raghunathpur, district Purulia in title appeal number 22 of 2018 till disposal of can 1 of 2026, which of the appellant shall serve copy, the appellant, plural, the appellants shall serve copies of the application on the plaintiff stroke respondent numbers 1 to 3, indicating that the matter shall next be listed before the appropriate learned single judge having determination. Full stop. Next para, service on the defendants stroke pro forma respondents is dispensed with for the present. Full stop. Liberty to the parties to mention the application for enlistment before the appropriate learned single judge having determination.
Get
Thank you.
I'm get
Next.
Item number 24 is certified.
পাসওভারগুলো হয়ে গেল।
My lord, I'm praying for a short passover. I'm for the
Why every
paragraph
matter short
number 1,
passover?
my lord. My line senior is code room number 32. Mr. Ganguly is there.
But I had a talk, my lord. He was saying that this he has not got the memorandum of appeal along with other
You are
applications.
not required to serve.
For that reason, my lord, he was seeking.
We will serve a copy on him, then we'll take it up.
We have received the memorandum of FMAT 88, but not
The other one.
The other one, not the 89.
This is against injunction.
Ad interim injunction, ad interim mandatory injunction.
So why 2 appeals?
My lord, the parent order and extension.
And Mr. Ganguly is
Maybe at the addition stage we'll dispose of the appeals. So serve copies of everything. We'll take it up next week or what? Or
Some urgency is there.
tomorrow then?
My lord, he is ready to argue the matter. He's just engaged in a different court.
The short passover will do. Very short passover. Yes.
Item number 26.
I'm praying for not today on.
No, no. You are a seasoned campaigner. We are not granting.
No, my lord.
Section 5, there was a direction for service.
No, this is first time appearing, your lordship. The learned advocate on record could not come.
No, there was a direction for service. No, not today.
Not today, my lord.
On the prayer of the appellants, the matter is adjourned for the day. Please give your name only. Yes.
Item number 27.
My lord, the plaintiff in a suit for performance of contract, my lord, is the appellant, my lord, challenging an order, my lord, refusing grant of ad interim order of injunction. My lord, kindly takes this ad interim order of injunction dated, my lord, 22nd of January 2026.
Yes.
My lord, the reasons, my lord, the injunction was preferred, my lord, for an order of restraint upon the defendants from carrying on construction over the suit property. My lord, there were 2 agreements. My lord, the subsequent agreement, which is the bone of contention, is the agreement dated 2019.
Why 2 agreements?
Initiated by 2006 agreement, my lord, between the same parties. Those terms were modified, my lord, acted upon, and that 2019 agreement was entered into by self-same parties.
No, did the later agreement say that it's in substitution of the
Yes, yes, not substitution. It's that it's in terms of the original agreement, certain conditions.
So you are now seeking a performance of the second.
19 agreement. Kindly seize this, my lord. The impugned order, my lord, kindly seize the operative portion. Heard the learned advocate for the plaintiff.
Yes.
In support of his contention, the plaintiff did not file the early agreement for the year 2006. Then, my lord, today is also the plaintiff filed the Xerox copy of unregistered agreement dated 28/3/2019. The plaintiff has also filed original copies of advocate letter in reply, and is apparent from the letter that the plaintiff has failed to comply the terms and conditions of the agreement. Then, my lord, prima facie, the plaintiff has failed to comply with the court's order, and the balance of inconvenience is not in favor of the plaintiff. So this is the reasoning, my lord. My lord, admittedly, the agreement was unregistered. It was an agreement, my lord, in the nature of a development cum sale. No possession was given, my lord. So, my lord, non-registration of the agreement could not have, my lord, weighed upon the learned judge.
What is this letter? They have the defendant. That is your cause of action.
My lord, kindly seize this letter, my lord. This is at page 95. My lord,
that is your cause of action.
Yes, my lord. I say, my lord, I was supposed to pay 80 lakhs, admitted. I paid 40, admitted. Now I write to them on 1/8/2025, on 1/8/2025, which is, my lord, at page 89, requesting them to grant me further time to pay the balance. That would be, my lord, page 89. Now, my lord, the reply to this is the letter, my lord, dated 12/8/2025. My lord, now kindly sees page 95, it starts 96, the first paragraph. He admits the fact that I've paid him 40 lakhs out of 80. So that's admitted. That amount has not been refunded. Now, my injunction, my ad interim injunction has been refused on these two grounds, my lord, which I believe is totally extraneous.
The court says that, Acha, very well.
My lord, it's the first day when I move an application, my lord, how could I be in default of compliance of a court's order? Admittedly, my lord, agreement was unregistered, admittedly. My lord, in that event, if it was inadequately stamped, I would have very well understood.
What order is referred to here?
But there's the first order, my lord. This is the first order.
Cannot be. What to say?
Kindly seize the prior page, my lord. Order number 1, dated 21 to 26. The first day, my lord, how can I be in default of a court's order? 21.
Ordered you to do something else, to come properly dressed or something like that.
Court's order date is not mentioned. Which order?
This is, my lord, the order 1, 22, 1, 2026. See the next day, page, my lord. Order dated 22, 1, 2026. Same date, my lord.
এই বলছে অরিজিনাল এই রিপ্লাইটা যেটা অপরপক্ষ দিয়েছে বলছে যে তুমি এটা করো সেটা করো করো না, তো সেটাকে ধরে বলছি ইটস অ্যাপারেন্ট লেটার দ্যাট প্লেন্টিফ হ্যাজ ফেইলড টু কমপ্লাই দ্য টার্মস এন্ড কন্ডিশনস অফ দ্য এগ্রিমেন্ট, সেটা বলতে পারে, সেটাই কোথায় বলতে গিয়ে আবার
So, my lord, out of 80, I've paid 40.
কোর্টস অর্ডার করেছে।
Out of 80, I've paid 40. That's even the defendant admits.
They're admitting it in. What sort of injunction are you asking?
Let them not construct. Thank you.
Well, now what was the injunction you asked in the trial?
My lord, kindly seize, my lord, that would be page number 27, my lord. Claiming, selling, transferring, alienating, encumbering, otherwise creating a third-party interest. How they're constructing.
And raising construction. Very well. The present appeal has been filed at the behest of the plaintiff in a suit for specific performance, pushed up by the impugned order, the prayer of the plaintiff for ad interim injunction with regard to sale, transfer, alienation, and/or construction in respect of the suit property was refused at the ad interim stage. For some next para, learned counsel for the appellant points out that the learned trial judge proceeded apparently on the basis of a reply of the defendant / respondent to a letter seeking specific performance issued by the plaintiff.
The reply is at page 95, my lord. The relevant portion is page 96.
And also on the apparent premise that the plaintiff / appellant failed to comply with the court's order, and that the balance of convenience and inconvenience was not in favor of the plaintiff, without such findings being substantiated by any reasons. Full of that apart, the learned trial judge did not advert to the contents of the materials produced by the plaintiff along with the plaint and the injunction application. Next para, we find from the materials before us, which are also before the trial court, that a sufficient prima facie case for specific performance of an unregistered agreement dated March 28, 2019 has been made out from the averments of and materials annexed to the temporary injunction application filed in the trial court. Also, apparently the trial court erroneously recorded that the plaintiff failed to comply with the court ' order, which is evident from the immediately previous observation that the plaintiff had failed to comply with the terms and conditions of the agreement. Next para, however, whether the plaintiff failed to comply with the terms of the agreement is a subject matter of trial. It is apparent from the reply of the defendant / respondents itself, which was referred to by the learned trial judge, that the defendant / respondents admitted that the plaintiff / appellant paid a substantial part of the agreed consideration, and that there was an agreement between the parties to the effect as pleaded by the plaintiff / appellant. Thus, the appeal is required to be heard on the above question and the other grounds taken in the memorandum of appeal. There shall be stay. The defendants / respondents and/or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and/or encumbering the suit property and / or creating any third-party interest in respect thereof, and / or changing the nature and character of the suit property in any manner whatsoever till disposal of Can 1 of 2026. The appellant shall serve copies of can 1 of 2026 along with a copy of the memorandum of appeal on the respondents indicating that the application shall next be listed for hearing in the monthly list of June 2026 when an affidavit of service to that effect shall be filed by the appellant.
I'm so grateful.
Item number 28.
I'm praying for a week.
No.
I have not brought the brief also today.
Why didn't you bring a brief? Rejoicing or mourning, either way.
No, Malad.
So
it can be kept out on Thursday, Malad. It can be.
we have never found you without a brief, so we are not believing you move the matter. We are giving you
Malad,
10 minutes time, prepare yourself.
Malad, kindly, Malad.
Why week?
Not a week. It can be kept on Thursday, Malad.
Why not tomorrow?
Tomorrow it can be kept. If your lordship.
On the prayer of the appellants, the matter is adjourned till we are keeping it next week. Till May 11, 2026. Prepare yourself. Yes.
Malad, if 47 is also my matter, Malad, it can be kept on.
We'll forget when it comes.
Oh,
Unless somebody is there. Yes. Appearance. Yes, next. Yes, Mr. Banerjee.
Yes, Milord, I appear. Milord, there was a caveat.
Caveat?
Yes, Milord.
You have served?
I have served, yes. This
File the receipt.
affidavit of service.
Good service, Mr. Banerjee?
Yes.
Yes, what is that?
Effect হয়েছে তো?
Checked up? Or should we check up?
Effect service.
Oh, on the advocate, yes. Very good, yes. What is that?
Milord, against a private charitable trust, Milord, religious trust, Milord, some sadhus, Milord, they have moved a suit.
Appropriate timing. Yes. Sadhus moved what?
Moved
Court.
against the
Yes.
Milord, plaintiffs, Milord, before your lordship. They are, Milord, that is at page 103 of the.
No, just tell us what is the
The
issue.
issue remains, there was a trust. Subsequently, the trust deed was amended in the year 2025, challenging the same. But without impleading as a party, the trust, they have moved and the injunction order has been passed.
Who are you? What is your
Milord,
location?
I am one of the trustee. Only I have been impleaded as a party.
So the suit is for what?
Suit, Milord, is for declaration for the revoking the entire deed which was executed in the year 2025.
So let us see the plaint relief first, then we'll come.
That is at page, Milord.
Yes.
Plaint is at page, Milord. So it starts from page 13.
Page 23 are the reliefs.
Page, my lord.
23, yes.
My lord. Removing the defendants whose name appear in the schedule 3 below as trustees, declaration the deed of appointment and the amended deed of trust mentioned in the schedule 2 below be void, illegal and
Setting a scheme also for
Yes.
proper management.
Now, my lord, once ultimately the injunction.
What is the ground of seeking those prayers? What is their allegation against you?
The allegation against the two person, that is defendant number 1, 2 and 3, that we have executed the same, that trust deed, and we are misappropriating the funds. Now the issue remains, my lord, these 3 persons, my lord, they are totally unmarried. Not only that, they are residing in the ashram. They do not have any even bank account.
The unmarried does not mean you cannot practice
No,
fraud.
sannyas, my lord,
Only married people commit fraud.
no, my lord, sannyas, my lord, saint, my lord, it can be.
You're supposed to be a saint. We don't know whether you are a saint.
Now, my lord, if your lordship kindly sees the order passed, by, the trust has not been implemented as a party respondent.
So this application was allowed on contest.
On contest.
What will be the effect of not giving effect to the
Now, my lord, entire.
then the original it reverts back to the
There are
the previous.
There are 4 ashrams, my lord, completely, my lord, stalled. Disciples are coming.
Let us see the impugn order. It's a
Yes.
longish order.
Well, it starts from page 103.
You can refer to the internal pages, Mr. Banerjee.
Yes,
We are
Lord, I can only.
following from the
Lord, these are the undisputed things, whatever that now the only first that the parties Yes, my lord, kindly come to internal page 8. My lord has got it, page 110, running page. Internal page 8, my lord has. My lord, I am just reading from the second paragraph. From the photocopy of the letter dated 11th January 2025, the Srimad so-and-so, it is apparent that he tendered resignation a trustee on that day. No confusion remains that on so-and-so's Srimad so-and-so was trustee, but the resolution did not bear his signature. So, the alleged new board of trust was reconstituted in his absence. On the contrary, the plea of the defendants is that after death of the settler and subsequent resignation of Srimad so-and-so, the board of trustee remained with one life trustee. As a result, the board of trust lacked minimum requirement of 3 trustees, and so in order to fill the post of the 3 trustees, the defendant number 1 as life trustee on 24th February 2020 executed deed of appointment of new trustees, deed nominated and appointed the defendant number 2 and 3 as 2 new trustees in the board of trustees. Thereafter, on 6th March 2025, the new board of trustee executed an amended trust deed. Another, the defendant number 1 has been nominated and appointed as settler. Here, the defendant number 1 has been shown as the life trustee, but other trustees have been given term of 10 years with eligibility of a reappointment. As such, there is a prima facie deviation from the original deed of trust and the amended trust deed of trust. In the light of the discussion made above, so and so, now the order has been passed. First of all, my lord, it's a private, a religious trust. That is absolutely within their domain. What they will do with that.
decision নিতে পারবে না the decision of any involving any person as the trustee or the management কোনো পার্টিকে ঢোকাতে পারবে না with the leave of the court.
Mr. Banerjee, we are thinking about admitting the appeal and granting stay subject to 2 riders. That the assets of the trust shall not be,
yes,
not be
I'm
dealt
willing
with.
to.
And secondly, that there won't be any appointment of fresh trustee or removal of trustee in the meantime.
My lord, I will come.
The present appeal arises out of an order of temporary injunction passed in connection with a suit filed by the plaintiff stroke respondents for removing the defendant stroke appellants as trustees, for declaration that a deed of appointment and amended deed of trust mentioned in Schedule 2 of the plaint is void, illegal, and inoperative, and for setting a scheme for proper management of the trust. Next parallel, counsel for the appellant points out that the trust itself was not made a party. That apart, the impugned order is devoid of appropriate reasons for the purpose of staying the for the purpose of restraining the defendants altogether from giving effect to Annexure 5, that is the amended trust deed, and Annexure 6, that is the appointment of new trustees. Next para, apart from the above factors, we also find that the impugned order might have the effect of granting the final relief in the suit at the stage of adjudication of a temporary injunction application. Thus, the appeal is admitted and shall be heard on the above questions and the other grounds taken in the memorandum of appeal. There shall be stay of operation of the impugned order till disposal of Can 1 of 2026, subject to the riders that the appellants shall not, that the parties shall not, in any manner, create any third party interest or deal with the assets of the trust in any manner whatsoever, and that there shall not be any new appointment of trustee and or removal of trustee during the subsistence of the present interim order.
My lord.
Full stop. The appellant shall serve copies of Can 1 of 2026 as well as the memorandum of appeal on the respondents, indicating that the application shall be listed for hearing in the monthly list of June 2026 when an affidavit. Oh, you have already filed then.
Yes, my lord. Affidavit of service is there because there was a caveat for such.
আচ্ছা তাহলে প্রথমে একটা করে দাও যে despite service none appears for the caveat. Affidavit of service filed to be kept on. আর লাস্টে যেখানে শেষ করলাম তাহলে তো সার্ভ কপিজ ওখান থেকে কেটে দাও, যেখানে ইনজাংশন করলাম ওই পর্যন্ত থাকবে, উইথ সাবজেক্ট টু দ্য রাইডার্স বলে যে দুটো রাইডার দিলাম সেটা থাকবে, তারপরটা কেটে দিয়ে তারপর থাকবে উই আর কিপিং দি অ্যাপ্লিকেশন অ্যালাইভ, দ্য রেসপন্ডেন্টস শ্যাল ফাইল দেয়ার অ্যাফিডেভিটস ইন অপোজিশন টু দি অ্যাপ্লিকেশন within a fortnight from date. Push up reply if any shall be filed within a week thereafter. Within a working week thereafter. Push up the application shall next be listed for hearing on June 15, 2026. Copy service or direction.
My lord.
You can communicate this or you have to
Yes, my
communicate
lord, I
because of the
shall,
injunction.
I shall.
So you better to serve a server copy of this order. Pass over.
Number 24 and 25, appear for the respondent number 1. Lordship, my senior is conducting a matter in court number 6. Kindly give me some time. I will
We'll
just
take it up tomorrow then. Every time we're passing. We cannot.
He has served me, I don't know, my lord. In item number 24, he has served me the memo and all these three applications. I don't know whether there is an application item number 25.
Whatever is unserved, just serve a copy. Please ensure to have a talk with him outside the court.
He's from my bar, my lord.
He's
a good friend of mine and also from my bar, my lord.
So you penalize him otherwise.
Penalize him.
Yes, in kind. On the prayer of the appellants, let the matter stand adjourned for the day. Serve whatever during the course of the day, please. Give a name.
Item number 30.
30, I am for the year.
Yes.
The appellants are the plaintiff in a suit for a partition and cancellation of
No caveat.
no caveat.
Yes. Mr. You are leading Mr. Bardhan?
Yes.
How dare you? Yes. Yes, sorry. Please.
Lord, I am the plaintiff in a suit for partition and for cancellation of Lord 1 give deed and 2 Lord the Kobalas the sell deed. It was a case that I made out was that Lord my predecessor in interest Lord he had executed Lord unknowingly Lord the give deed as well as the Kobala deeds. Although I am as a legal heir entitled to inherit Lord the portions of the property.
So you waited after his or her death and then you filed.
No, he died in he had died in 2020, and obviously and those were executed prior to that. But Lord, I also asked for Lord the partition of Lord the remaining portions of the property. Now, Lord, the learned judge in the ad interim ex parte stage, Lord said that I could not show Lord possession as that there is no urgency because Lord I could not show that the construction is sought to be made in the property. These are not the only two grounds. Lord, to which Lord the answer is that whether Lord I am in possession of the property or not, Lord, so far as Lord there are 5 plaintiffs before your Lordship. The 5th plaintiff, Lord, I can show at page 111 of the stay application that Lord his name appears in the record of rights. Therefore, the learned judge was quite wrong, Lord, so far as one of the plaintiff is concerned, Lord, about the possession in the record of rights, which is a prima facie case of his possession. But this is Lord where the learned judge has gone wrong. Now, Lord, so far as Lord the partition is concerned, Lord, all that I asked for in the injunction application that there is no alienation of the property in the meantime, and Lord the property, Lord, there is no accretion on the property by way of construction. But that was imperative because of the reason, Lord, if there is a change of Lord the nature and character, and Lord there is a partition, Lord, that will Lord hamper my Lord the occupation in the property as well as Lord the nature and character will be changed. But so this was Lord the ambit of the matter. If your Lordship kindly comes to Lord the reasoning.
What was the injunction is sought in the trial court, Mr. Mukherjee?
No, that was Lord that
possession.
not to change the nature and character.
And person.
Not to raise any construction and possession.
Position.
Page 14.
It's a character transfer. The present appeal arises out of the rejection of the plaintiff stroke appellant's prayer for ad interim injunction. Push up, the matter arises from the appeal arises from a the genesis of the matter is a suit for declaration that certain transfer deeds executed by the predecessor in interest of the appellants are void and the consequential relief of partition and other reliefs. Full stop. Next para, learned senior counsel appearing for the appellants points out that the learned trial judge arrived at an erroneous finding with regard to possession, at least insofar as one of the plaintiffs is concerned, inasmuch as the name of the plaintiff stroke appellant number 5 also.
Appellant number 5.
Appellant number 5.
Plaintiff appellant number.
Is recorded Agarwala's and Das.
Das's name is recorded in the record of right.
You have a common predecessor in interest.
Lord, in respect of this particular property, Lord, your lordship will find that pro forma defendants are there too. So this is a big property, 1.61 acres.
Anyway,
so because it is a partition suit, Lord, all the co-sharers have been arraigned as a part.
Is recorded as recorded in the records of rights of the property. So it is further contended that the learned trial judge ought to have restrained the defendant stroke respondents at least from changing the nature and character of the property as well as from creating any third party interest in view of the nature of the suit. For sub next para, on a perusal of the impugned order, we find that the learned trial judge observed that the question of whether the deeds should be declared to be void cannot be decided without holding trial, at the same time proceeding on the premise that no inference can be drawn as regards the legality of the said registered deeds of transfer. Full although there was no infirmity prima facie with such finding, fact remains that in view of the nature of the allegations made in the plaint, a trial is required for the purpose of deciding the issues involved. Accordingly, a prima facie case for grant of injunction, at least in respect of change of nature and character and third party interest creation, has been made out. Hence, the appeal will be heard on the above questions and on the other grounds taken in the memorandum of appeal. The parties shall remain restrained by an order of injunction from selling, transferring, alienating, and/or creating any third party interest with regard to the suit property, and/or from making and/or from changing the nature and character thereof till disposal of Can 1 of 2026. Next para, the appellants shall serve copies of Can 1 of 2026 as well as the memorandum of the appeal on the respondents, indicating that the application, all the respondents, because partitions, indicating that your relief is injunction is only against,
only against not the primary principal defendants.
Directing the injunction restraint kader bolam, directing both parties. The parties shall remain na kore, the appellants as well as the defendant stroke respondent numbers 1 to 4 shall remain restrained. তারপর যেখানে কপি সার্ভিস করতে বললাম ওখানে কপি appeal on the respondent defendant stroke respondent numbers 1 to 4, indicating that the application shall be listed next for hearing in the monthly list of June 2026 and file an affidavit of service to that effect on the returnable date. Service on the pro forma defendants stroke pro forma respondents is dispensed with for the present in view of no relief having been sought in the appeal against them. আচ্ছা, till disposal of the application বলেছি কি? হ্যাঁ, হ্যাঁ, ঠিক আছে। Yes, thank you. Yes. Yes.
31 is my appeal and 32 is my learned senior friend's appeal. The plaintiff is the appellant in 31 and the defendants are the appellant in 30. But before I proceed with the merits, may I indicate two things for which we should receive some admonition. 2 points against us. I should first try and indicate that and before going. But first is
Mr. Chaturvedi, please take a seat. We'll just take.
There was a previous round of appeal from an ad interim order where there was an issue with regard to caveat. So your lordship would kindly have a look at the first volume where in page 65, the plaintiffs had gotten ad interim order which was assailed in appeal. But only one thing that I should indicate in page 65, though that is not the subject matter, but just to indicate, kindly sees the fifth paragraph. But there the trial court has taken note that there was a caveat filed. But thereafter the trial court held that that is not a caveat which should restrain the court from passing any order because that was filed by somebody else, so on and so forth. So your lordships were pleased to consider that at page 68 and set aside that order, remanding the matter back to the trial court for adjudication afresh. So but here that was not a case where there was no caveat. We indicate that there was a caveat, but that caveat should not be an impediment.
Not your fault. That was interpreted by the court.
But where our fault is and where we should be admonished is that, in this appeal, we initially on the first day, we were instructed that there was no caveat, but there was a caveat. We had served, and after that, we are moving. So it was about a month back that we had served. So now we are moving. Though initially, on the first day, your lordships might recollect, that when I had sought to move, we were instructed that there was no caveat. But we were carrying copies for the other side because we had served them there and now. So, these are the two things which I should indicate before proceeding with the merits of the appeal.
No, we did not admit the appeal or pass an interim order.
No. First, we said that we were under the impression, but we were carrying copies. We gave.
They had appeared and pointed out.
Yes. And Mr. Owen Banerjee was also there. He had showed because we said that our instructions were other.
So you have already been admonished for that.
Yes, but I should, because your lordship, but I distinctly recollect because your lordship said, remind me on the next day. So, I thought that I should point out what fell from your lordship before proceeding.
Yes.
But before taking your lordship to the impugned order, may I just indicate the facts in a nutshell? Because this is a case where a suit is filed concerning a trust. The trust, manages an educational institute. So, two trusts have really come together to run an educational institute. The plaintiffs are one set of trustees, the defendants are the other. So, plaintiffs are from one trust who have now been inducted as trustees in the other trust.
And vice versa or not?
No. So, the dispute is really between the two groups of trustees. And the problem is faced by the educational institute. There was a scheme framed by the district judge that certain both sides advocates were appointed. I mean, two advocates were appointed to be the joint receive special officers to manage the affairs. But could I show that order first before taking your lordship to the impugned order? For the only reason, our allegation is that the impugned order travels beyond that order. So, possibly.
No, just tell us what happened. Yes, the conclusion, then we'll look at
yes,
the papers.
So, in the impugned order,
two special officers were appointed to conduct manage the affairs of the trust in general.
There was an executive committee. Particular things were given, indicated in that order, which they would manage.
Very well. Including bank accounts and all.
Yes, mostly bank accounts and all,
obviously.
And dispensation of salaries and all. The difficulty why we are up before your lordship from the order impugned is that by this order, the meeting of the trust has been stayed completely. On the ground that since special officers are there, they should be done. So it is our primary point that the functioning of a trust.
That order does not exclude the otherwise functioning.
Yes.
So is it appealable otherwise?
Order 39(1)(2), so that is the only. But our case is that, my lord, the functioning of the trust was never given to, my lord, the special officers.
You have to show the court that they can happen together also. That
Yes.
They will be in charge,
Right.
but still it functions.
Yes, yes.
So there has to be overlaps and areas which are like
Which
a
are
Venn diagram
segregated.
sort of. Yes.
Yes. And the function that it was never the intention of the court to, my lord,
So you have to see that previous sort
yes,
of.
that is by, my lord, I.
Yes,
Kindly
absolutely.
comes to page 83 once, my lord. But this is where the scheme was framed. And this is really a suit under section 92 of the, my lord, Code of Civil Procedure. But this is after remand when your lordships were pleased to set aside the ad interim order. So the final hearing.
Page 83 of Can 1.
Yes. Would your lordship kindly come straight away to page 85, where, my lord, the contours of the special officers' functioning have been given. Page 85, could I place it?
Right.
Now on consideration, towards the middle of the page. Now on consideration to the above, the following scheme be formulated as an interim management by this court to secure the smooth functioning of Gayatri Chetna Foundation till the disposal of the suit. 1. Names of 2 advocates from each side are to be provided for appointment as joint special officers who will monitor the affairs of the educational institution in terms of the scheme as framed. The learned advocates to be nominated as page 85. I'm sorry. Page 85.
Can 1 is the volume. It has a volume.
I'm sorry. There are 2 appeals. Ours is FMAT 76 of 2026.
FMAT 96.
76.
FMAC
76.
FMAT
96 is their appeal.
Okay, 76.
Item 32. Now the order starts from 83. If your lordships are pleased to take page 85.
Got it. Please. Yes.
Could I just place serial number 1 for Justice?
You may.
Yes. Names of 2 advocates from each side are to be provided for appointment as joint special officers who will monitor the affairs of the education institution in terms of the scheme as framed. The learned advocates to be nominated as joint special officers will be remunerated by the respective parties. Expenses, if any, incurred by the said joint special officers will be reimbursed to them by the respective parties jointly from the funds of the said trust. Then 3, and this is all important, an executive committee consisting of 3 members has to be formed, which will be headed by the, kindly marks this, my lord, chair of the principal, not the principal, the chair of the principal of the educational institution, and 2 other nominated members, 1 each for the plaintiffs and the defendant side. The executive committee shall act in assisting the joint special officers as and when called for. Then 4, any disbursement of expenses which may be required for running of the said institute shall be sent to the joint special officers through the executive committee, who after joint verification shall issue a formal letter or requisition to the authorized signatories of the said trust, that is the plaintiff number 1, namely such and such, and the defendant number 1, namely such and such, to the instant suit for signing the required checks for disbursement of funds. Any formal letter requisition approved by the said committee has to be placed before the authorized signatories within 48 hours from the time of receipt of the letter or requisition, and the authorized signatories shall sign the checks within 24 hours from the date of receipt of the formal letter or requisition for disbursement of the required funds. All original documents apropos functioning of the trust and the institute, including original checkbooks, shall be kept under the supervision of the joint special officers and the principal of the institute in the office of the principal under lock and key. Neither party shall, kindly marks this, take any policy decision or engage any new staff for running the trust and the institute without taking leave of this court. The scheme is restricted only for the smooth functioning of the education institution without influencing other charitable activities of the trust. So, my lord, this was the order where certain powers were granted to the committee, and it was given that no new policy decision or engagement of a new staff would be there without taking leave of the court. That is 7.
So
serial
money
numbers.
requisition has to go through the
Through the
special officers.
special officers.
Joint, the executive committee role is to assist the joint special officers. It goes through them to the special officer and vice versa. 48 hours.
Yes.
24
For signing
hours.
of checks.
No, 48 hours for their
Letter of requisition shall sign the
they'll
checks.
issue the checks within
Yes.
24 hours.
And then 7 is where any policy decision
And
or
engaging
engaging a
staff.
new staff would be has to be done with the leave of the court.
And document supervision.
Yes. Now, my lord, kindly sees the notice by which the meeting was called.
This policy decision and new stuff, the joint officers are not
No,
to do.
no.
But parties won't do without leave of court.
Without leave.
So therefore, impliedly meaning that the parties may do that with the
May do that, but there has to be a leave
Leave
obtained
of
before
court,
that
with
is
leave of
implemented.
Yes.
Now, kindly sees the notice which is impugned, page 166, my lord, kindly takes volume 2.
Yes.
But 166 is the notice convening the meeting, proposing to convene the meeting. Now, this is dated 31st of January 2026.
13 January.
I'm sorry, 13 January for
You are the plaintiffs, you said.
I'm the plaintiffs.
Yes.
But the notice is dated 13th of January 2026. Your lordship would find the date at the top left of the. And the meeting is proposed on 31st of January. Could I place it, Milord? I, such and such, one of the trustees of Gayatri Chetna Foundation, by way of the letter, email and letter dated such and such, it has been brought to my attention that the faculty members and students of the institute being run under the trust have raised serious allegations against Mr. Such and such, the current principal of the said institute. In furtherance of such complaints, the internal complaints committee of the said institute has conducted preliminary inquiry and held meetings from time to time to probe into such allegations being leveled against the principal. Upon such inquiries being made, the ICC has recommended to suspend the principal till conclusion of the proceedings conducted by the ICC.
It was a POSH Act complaint.
Yes, yes, it was a POSH Act complaint. Hence, in terms of such suggestion,
By the ICC, by the ICC, a
by,
meeting of the
by the ICC, a meeting of the trustees of the required to be convened. Required to be convened to decide on the steps to be taken in respect of such complaints against the principal and on the suggestion by the ICC. Then,
So you challenged this notice?
no, I did not. They challenged. Other agenda to be included in the meeting, a discussion over the introduction of new courses and future prospectus.
You say you are the plaintiffs.
I say I am the plaintiff. I did not challenge this meeting. The defendant's
What
application.
was the relief sought in the suit?
Relief is regarding management of the trust.
Sort of framing a scheme.
Framing a
sort of.
scheme regarding management.
So you said 92
Yes.
ingredient
Yes.
is there.
They challenged this notice and they say that the meeting could not.
Challenge how?
By filing an application under Order 39(1), which is the subject matter of challenge. in
39
this.
Rule 1 and 2 was filed by the defendants.
Filed by the defendant. Defendants Order 39 Rule 1 and 2
What
application.
about yes, 168?
And I'll end
This
it.
is the price in the suit.
Now, my lord, we are aggrieved by this portion where the new courses and future prospectus was also proposed to be deliberated in the meeting. The penultimate line of.
You also have a problem with that?
No, this was injuncted. So I have a problem and I have come up.
Oh, what?
So we had proposed a meeting.
Sorry, you're aggrieved with what? Other agenda?
Yes, that sentence, my lord, where the new introduction of new courses and future prospectus has also been stayed.
So you would be happy if this portion is cleared and the other portion remains?
Now, my lord, what had happened was, my lord, the meeting, now they file an application. That is, their application is at page 168, where they challenge, my lord, this notice and kindly sees the prayer at 170. Their prayer is from holding any meeting, injunction from holding any meeting on daily functioning and or holding any meeting in view of the notice dated such and such for taking any step against the principal and to take any policy decision of Gayatri Chetna Foundation in violation of order number such and such dated 2nd June 2025 in the trust suit number such and such. This is the order which I had placed.
So they are saying that the steps against the principal tantamount to policy decision.
No, if you
Let us see their
kindly
allegation.
sees their pleading,
Yes, let us
they
see.
kindly sees page 169,
Yes.
In fact, 168, paragraph 4.
That is the fact.
So on the complaint, the principal was kept under suspension. Somebody else was appointed. So I had requested your lordships to mark that chair of the principal and not the.
Yes, that we remember, but para 10.
Yes. But we had
Destroy, yes.
undertaken.
No, trying to destroy the allegations in the injunction.
That is there. That is the allegation in the
No
injunction.
right to call any meeting to against the principal. No.
Yes. Now, my lord.
To take any policy decision.
Yes.
New course and future prospects is policy decision, they say.
Yes.
It's a school.
It's a college. Yes, it's an educational institute. It's a college. Now, my lord, kindly takes a look at my affidavit and my written objection at 172. I'll trouble your lordship with only 2 sentences. It starts from, my lord, 172. Your lordship would kindly have a look at page 182.
The written objection is 10 times the size of the injunction application. You must have
No, I was inducted
later
in the appeal.
Very well, yes. Yes, you may have so many things to say.
Paragraph 44, yes, my lord, page 182, paragraph 44.
Yes.
The plaintiffs further undertake that any resolution passed or minutes of the meeting shall be placed before this learned court for approval, and only upon leave granted by this learned court that it shall be enforced. So specifically indicated in the written objection, and also, my lord, paragraph 53 at page 186. Not the last line at page 186. Once again, reiterate. Now, what the learned court does is that the meeting is injuncted altogether. And there's a finding that, my lord, the complaint with regard to the principal cannot be looked into by the court because that is before the POSH committee. We are not going into that. But so far as the other aspect is concerned, this is a policy decision. Since there is a special, there are special officers, it should be through them. That in our humble understanding.
You are agreed with this part that the prospectus and those
Yes,
things
new courses.
New
That is
courses
clear.
have been injuncted, and they are apparently, we'll hear Mr. Chaturvedi, but apparently on the other part.
On the other part where the principal, yes.
So he is the principal.
He is not
the other
principal.
trustees.
He is for the other trustees who are supporting the principal.
Well,
But we are for that second portion of the agenda where we want to take decision on the courses. But the meeting has been stalled altogether. There is no meeting. So the functioning of the trust is being stalled by the impugned order. And it was in our understanding. It is never the intention of the court to stall the functioning altogether. Now kindly comes to, takes a look at the order impugned. Your lordship is looking at from the application for stay or the memorandum of appeal, my lord?
we'll look at it from the memo, but
Right.
give us half a second.
Yes.
Yes.
No, just the first paragraph of the order to indicate whether it's an appeal from an order 39 rule 1 and 2. Kindly see the first paragraph. It's a defendant's application under order 39 rules 1 and 2. Now the finding is, my lord, at page 7. If I may place from the third line at page 7, the page number is at the bottom. It is not in dispute that V-Day order passed by this court dated 2nd June 2025. This court was pleased to formulate interim scheme to ensure smooth functioning of Gayatri Chetna Foundation till disposal of the suit, and pass direction upon the parties for appointment of joint special officers, and in compliance thereof, parties also acted upon it. According to such interim scheme formulated by this court, neither parties shall take any policy decision or engage any new staff for running of the trust and institute without taking leave of this court. It is also stipulated that scheme is restricted only for smooth functioning of educational institutions without influencing other charitable activities of the trustees. Evidently, there is an executive committee headed by the chair of the principal. It is clear from the said scheme that no individual has been appointed by name to head the executive committee as per interim scheme formulated. If there is any complaint against the incumbent principal within provision contained under the POSH Act, it has to take its own course in accordance with the provisions laid down therein. And if there is any recommendation of IC, the employer has to take a call on that. This court is not empowered to deal with the issues involving the complaint of any sexual harassment by the staff or employees in this suit filed under Section 92 of the CPC. Neither the scheme framed by the court can be pressed into service to interpret the veracity of the complaint or recommendation made by IC or decision to be taken by the employer on such recommendation. We are not agreed by this portion. We are agreed by the portion after that. Scheme clearly relates to the functioning of the educational institute and the policy decision in connection therewith, and such scheme is binding on both sides. Parties are litigating in this suit in respect of relief claimed by the trustees as prayed for, which includes direction upon the parties from this court to act in accordance with the objective laid down in the trust deed, and in order to come to conclusive finding in the suit. This court formulated schemes for effective management of the institution. Kindly marks this, my lord, in the next sentence. The executive committee is well empowered to deal with smooth functioning of educational institution, to take policy decisions in connection therewith within the ambit, scope, and scheme so formulated, and may take leave of the court if so required. This, in our humble understanding, was never permitted, that this would be done by the executive committee, by the special officers, and they would take them.
It's the other way around.
It is the other way.
Converse was not true.
Yes.
That is your.
Yes. If so required, then the executive committee, of course, shall not deal with the recommendation of IC and under the POSH Act, as interim scheme does not prescribe. So therefore, this court refrains from passing any order with reference to agenda number 1 as stipulated in the notice date 13/1/2026. Now, insofar as the second agenda is concerned, it reveals that the meeting of the trustee has been called to take decisions on introduction of new courses and future prospects in connection therewith. In considered opinion of this court, the same directly comes in conflict with clause 7 of the internal scheme, according to which neither parties shall take policy decision nor engage in any new staff.
বলছে ফিউচার পাসপোর্টের পলিসি ডিসিশন, এটা পলিসি ডিসিশন, পলিসি মানে কি ফাইনান্সিয়াল পলিসি রিক্রুটমেন্ট এগুলো দেখি।
Yes. Mr. Gupta will continue after the recess, and Mr. Chaturvedi will come after 5 minutes. My learned brother will deliver a judgment in the single bench, and immediately after that we'll say. So 5+2 like that. Yes.
But I was placing from the impugned order, my lord. If your lordships kindly, my lord, take, my lord, page 7 of the impugned order at the bottom.
You're placing page 8.
You're placing page 8, yes. But page 8, 5th line.
Yes.
Now, insofar as the second agenda is concerned. Has your lordship got me?
Yes.
Now, insofar as the second agenda is concerned, it reveals that the meeting of the trustees has been called to take decisions on introduction of new courses and future prospects in connection therewith. In considered opinion of this court,
Yes, please continue.
in considered opinion of this court, the same directly comes in conflict with clause 7 of the internal scheme, according to which neither parties.
Was it future prospects or prospectus? In that notice, just let us check up once.
Texts, I think, but time permits me. In the agenda.
Yes, in the page 167, it was prospectus, not
And-
future prospects.
No, and new courses. Prospect.
New courses is there, common, but prospectus is different from future prospects.
Yes.
Yes, correct.
It is on record that no leave was taken from this court to hold any such meeting by any of the trustees, especially when there is executive committee constituted by this court to deal with smooth functioning of educational institution pending instant suit. In the given facts and circumstances, pending adjudication of the instant suit with reference to the relief as sought for by the plaintiff, if trustees are allowed to call the meeting and take decisions on various policy matters going beyond internal scheme formulated by this court without taking leave of this court, same will create irreversible situation and it may result in multiplicity of proceedings between the parties. In that context, the defendants have strong prima facie case to have an order of injunction against the plaintiffs to restrain the plaintiffs from holding meeting to discuss on introduction of new courses and future prospects. It appears that the executive committee is well empowered to deal with such issue, taking leave from this court. I find that the balance of convenience inconvenience tilts in favor of the defendant numbers 1, 2, 4, and 6 in seeking injunction and restraining order against the plaintiffs from calling a meeting to discuss policy matter involving introduction of new course and considering future prospects in connection therewith. However, defendants cannot have any order of injunction with regard to Agenda 1, which relates to complaint against under POSH Act against incumbent principal. Executive committee or parties are free to approach this court to seek any modification relating to interim scheme or formation of executive committee in view of any subsequent changed circumstances. In the prevailing circumstances, this court is of the view that the defendants will suffer irreparable injury if an interim injunction is not granted in their favor, restraining the plaintiffs to decide such policy matter involving new course and future prospects thereof, when there is an internal scheme prevailing without taking leave of the court. In result, injunction filed by such and such succeeds, however, only limited to extent that the plaintiffs, including Subroto Datta, be restrained from holding meeting of the trust involving any decision on the introduction of new course in the institution and future prospects thereof without leave of this court. However, the prayer for any restraining order with reference to the steps to be taken against the principal under the provisions of POSH Act is refused. Now, my lord, in the second matter, my lord, item 32, which is the defendant's appeal, they had really challenged the other portion of the agenda not being interfered with, and also another point has been taken is that the person who had proposed to convene the meeting was not authorized as per the trust deed. So, my lord, apropos that, your lordship would kindly have a look at the trust deed once. And it starts from page 108 of volume 2. Now, the clause for the meeting is clause number 25 at 129.
Yes.
May I place it? Clause 25, meeting of the trust. For management of the trust, it will be necessary to hold the meetings of trustees from time to time. Therefore, there should always be at least one meeting of the trust in a quarter, which is 3 months. Thus, there must at least 4 meetings in a year. Information of these meetings should be given to all trustees by the managing trustee 5 days before the due date. But they take a point that the person who proposed the meeting to be convened was not the managing trustee, so the meeting per se could not have been convened at all. Now, my lord, kindly takes a look at the written objection. Now, kindly comes to the written objection, my lord, the relevant portion, my lord, at page 177 and 178.
Yes.
My lord, 177 kindly takes a look at, my lord, paragraphs 23 onwards. Pursuant to the same, the plaintiffs have requested the defendant number 1, who is the managing trustee, to hold a meeting of the trustees time and again on several dates, including via letter dated such and such sent via speed post. However, the said defendant number 1 willfully ignored such requests to safeguard her own vested interests by safeguarding the said principle. A copy of the letter is annexed. Then, para 25, the plaintiff state that having no other alternative, the plaintiff number 3 had called the meeting of the trustees to decide on the steps to be taken in respect of the recommendation of the ICC committee on such and such. Turning over, my lord, to paragraph 25, it would not be out of place to mention that in any event, and as would be evident from the trust deed, that the managing trustee is obliged to call for a meeting of the trustees at least once every quarter, and information of such meeting has to be provided 5 days prior by the managing trustee. Kindly see paragraph 26. However, till a date, and since the plaintiffs have been inducted into the trust, which is in 2020, no meeting has been called for by the managing trustee, being the defendant number 1, despite repeated reminders and requests. Therefore, having no other alternative, the plaintiff number 3, being one of the trustees, had called for a meeting. So what they do is this collaboration between the trusts, my lord, where I have to plow in the funds and I have to manage the entire running of the educational institute. They were to look after the trust aspects. They get the money, the investment from me, yet they will never call a meeting. So we were left with no other option but the plaintiff number 3 calling for a meeting. Now the notice for the meeting is given on 13th of January and the meeting date is 31st of January. So they had sufficient time. The trust deed provides for a 5-day notice. But this, they had more than 2 weeks. So this is one of their moot points in their appeal, that the person proposing to convene a meeting.
Is there an assistant managing trustee here?
No.
All right.
They came before the court. Now kindly sees, they came before the court on 30th of January. And they got the injunction. So, my lord, what happens ultimately is, my lord, these affairs of the trust is getting stalled, but it is, in our humble understanding, subject to my lord's testing it, of course, not the intention of the order by which the scheme was formulated as an interim measure to, my lord, knock the doors of the court at every stage prior to everything to be done with regard to the trust. If something is taken, which is a policy decision, then only a leave of the court is required.
What, in your opinion, is a policy decision? Give an example. Because you are introducing new courses.
Yes.
So that may be a sticking point. So what do you say? Give an example.
Policy decision would be regarding the affairs of the trust as such, but the educational institute, it is an educational institute, so there would be courses.
What can be a policy decision to instead of imparting education, it will be something else, or
regarding the management, my lord, the management affairs.
One example, one concrete example. Think of one.
Salary, new teachers, so on and so forth, and the shifting of office.
Why not new course?
Because educational institute.
Is it a policy? Isn't it a policy decision? Because an educational institute imparts education on certain subjects. There are courses in place. So if you introduce new courses, so isn't it a matter of policy pertaining to the policy? Because it directly relates to the functioning of the educational institution, but you're introducing new courses altogether.
Yes. So, my lord,
So that is one point you have to overcome.
yes, my lord, two things, my lord. Firstly, my lord, I would address why. Firstly, I would try and address on the point that this is not a policy decision at all. But my lord, may I take my second point first, which is, even if it is so, we have stated that we would take leave of the court.
And not only that, the executive committee is not empowered, you were saying.
Yes.
As per the
Yes, so
that order also.
Trustees have not been rendered nugatory.
Permits the parties to do that.
Yes.
Meaning the trustees.
Yes. If your lordship
Leave
kindly
of
takes
court.
a look at that,
Seven,
those clauses, clause 7.
We remember, yes.
No,
So,
apart from this committee with regard to that education course, is there any separate committee for that? Some committee is looking after that.
Committee is not looking after the course.
সেটা ট্রাস্টের টাকা আসবে হ্যাঁ ওরা বলছে ওদের এক্সিকিউটিভ বলছে এটা মিটিং ডেকেছি এজেন্ডায় আছে ডিসিশন নিলে সেটা একেবারে সাবজেক্ট ওটি করবে এটা স্টে হয়ে আছে
If your lordship kindly comes back to page 85, which is volume 1, that those scheme, not in, if your lordship reads the powers which has been foisted on them, nowhere they said that they had to convene a meeting for any decision. On the contrary, clause 7 says neither parties shall take any policy decision. So one can resolve to take
implicitly
subject to
parties may take policy. That we understand, yes.
So, my lord, even if, my lord, your lordships hold that new courses may be policy decision, but I need not really join issues with that.
In your affidavit, you have stated that this is only an agenda of a meeting. If you take a decision on that, we'll place it for the approval of
It might be that the majority does not approve of any new course.
Page 182 of your
Yes, 182 and my lord, 2.
And reiterated somewhere else.
Yes,
187 for
yes. So, my lord, here, my lord, the decision could have been of the majority that no new courses. So there is no question of going to the court.
Correct.
And my lord, insofar as the other objection of theirs is concerned, that they are aggrieved by two aspects. One is the principal issue, which they say is a principal issue, which is not. And the second is, why is X calling for a meeting dehodes the clauses of the trust, which says the managing trustee should be the person calling for a meeting. But here, my lord, we have stated on oath that right from the induction of the plaintiffs into the board, into the this trust as trustees, there has never been any meeting. So, my lord, what their intention is to cripple the affairs of the trust. And this possibly could not have been the intention of the court to monitor each and every aspects of a trust, which perhaps, my lord, the courts are slow in doing. That's the only thing.
Slow in both senses. Mr. Chaturvedi is asking your permission to start. Yes.
Lord, kindly, Lord, sees Lord, the impugned order, Lord, it has been placed before my Lord. Lord, the scheme of the things, Lord, it include, Lord, the first clause is very important. Lord, that the committee will monitor the affairs of the institution. We are essentially, my Lord, concerned now with the affairs of the institution and not, my Lord, with regard to the affairs of the trust. The application which is made, it pertains to, Lord, affairs of the institution. Because new courses would be introduced in the institution and the constitution of the executive committee is sought to be altered by inducting a new person on the chair of the principal. The executive committee is to comprise of 3 persons, one to be nominated by each group of trustees and to be chaired by the chair of the principal. The allegation against the chair of the principal means now the attempt is to alter the constitution of the executive committee of the institution. So this is not with regard to Milord as to who should, I'm sorry.
No, please.
As to who should convene the meeting of the trust. This is not a meeting of the trust. And with apropos the running of the affairs of the institution, kindly permit me, my lord, at the risk of repetition, my lord has already seen it. My lord, kindly sees, my lord, how the learned court, my lord, has consciously recorded, my lord, the previous order, which, my lord, framed the scheme. My lord, kindly, my lord, sees, my lord, the impugned order,
No, if you say, Mr. Chaturvedi, this relates to this now proposed action relates to the affairs of the institution and not the trust.
Yes.
Then it is not governed by that order at all, because that relates to the functioning of the trust.
No, that
monitoring institution.
Only institution, Lord, may I, Lord, only indicate that. Lord, that confusion, Lord, Mr. Gupta, I would say this with an affection to him, that he has been successfully, Lord, able to create a cloud over it.
No, education institution, yes.
So, Lord, the scheme, Lord, kindly sees.
Very well. Yes.
Now, Lord, kindly sees, Lord, the scheme, Lord, at internal page 5 of the order. Lord, kindly sees, Lord, first would be very important.
Yes, seen.
Name of 2 advocates from each side are to be provided for appointment as joint special officers who will monitor the affairs of the educational institution. Yes. Then, Lord, the learned advocates to be nominated joint special officers will be remunerated, Lord, not important. Lord, kindly sees 3. An executive committee consisting of 3 members has to be formed, which will be headed by the chair of the principal of the educational institution and 2 other nominated members, 1 each of the plaintiffs and defendant side. The executive committee shall act in assisting the joint special officers as and when called for. Then, Lord, kindly sees, Lord, 7. Neither party shall take any policy decision or engage any new staff. Now, Lord, what is, Lord, sought to be done? Lord, kindly, Lord, comes to, Lord, internal page 3 of the order.
Of the present order.
Of the present order. Lord, kindly sees, Lord, about, Lord, 7 lines, Lord, from the top, Lord, lines starting with the words in the middle. It is also contended that.
Yes, after Praveen Mukherjee.
My Lord. It is also contended that after formulating the scheme, the academic institution was somewhat smoothly operating, though several attempts were made by the defendants or the agents and representatives to create state of chaos and disrupt the smooth functioning of the educational institution. It is also contended that the scheme as framed by this court is only restricted to smooth functioning of the educational institute and its aspect. It is also contended at present 3 subjects being so and so.
Mr. Chaturvedi will dispose of the appeal either way.
Yes. So
here, now, today.
Yes.
So not on order 41 only.
Yes. Lord, are being taught. And plaintiffs have planned to expand the same. So, Lord, what is, Lord, the scope, Lord, of the agenda? This is, Lord, the plaintiffs are contending. The court is recording what the plaintiffs contend. So, the scope of the agenda is, Lord, to increase the number of courses to be taught. Now, my Lord knows, my Lord, now these study centers, my Lord, are not being permitted by the university from, Lord, this session onwards. So, this has to operate as a full-fledged college. So, what courses are to be introduced? Is it not a policy decision, my Lord? I put this question to myself. What subjects are going to be taught in my institution? Is it not a policy matter of...
Supposing it is a policy decision, Mr. Chaturvedi, Mr. Gupta's point is also that as per that order, it was the parties who could take that decision subject to leave of court.
Yes.
Now, apparently his argument is that this is only an agenda has been fixed for a meeting. In their opposition, they say categorically that that will be an approval will be taken after they take a decision on that. So at the agenda stage, why should it be stayed?
Yes, Lord, there is...
the parties can take a policy decision also.
But that is where, Lord, I join an issue.
Yes.
Then, Lord, it is, Lord, governed by the first clause, which says, Lord, that the scheme is for monitoring, Lord, the institution. So whatever you want to do, there is, Lord, the executive committee who will monitor the affairs. You need to place the issue before the executive committee. Lord, the executive committee, Lord, will, since it is monitoring.
But how do you reconcile 1 and 7 then?
Lord, 1 is, Lord, for monitoring. 1 is for monitoring.
7 is independent of that executive committee. Court, they can take, you can take a leave directly from the court. Either.
No, Lord, with deepest of respect, they are being special officers. Lord, any action in terms of 7 will have to be, Lord, taken through the special.
Routed through 1.
Through the special officers. Because, Lord, otherwise the appointment of special officers is rendered redundant. But the special officers, my lord, in my understanding, would be the interlocutors between, my lord, the trustees and the court. So whatever the trustees want to do, they have to express it to the special officers. But the special officers, my lord, would seek the leave. When a leave is being sought, then, my lord, there is a level playing field for both the parties to agitate before the court that this policy decision should not be permitted. They would say, I'm sorry. Then there would be a level playing field for both the parties. They would say that one party would say that this is a policy decision which is in the interest of the trust. The other party may not agitate, may concede to it, or may not take a different view. And the court would decide whether the leave is to be granted or not to be granted. So we may not say that this may not is ignoring the scheme to which they themselves have conceded. Because when the scheme was formed, names were invited for appointment of special officers, they have given the names. So they were acting in terms of the scheme. It is only, the respective understanding of the schemes, which is at loggerheads. Existence of scheme is not denied. But I am, we, are aggrieved, rather by the other part of the order, which refuses to interfere insofar as convening the meeting in respect of the first agenda is concerned. Now, my lord knows,
Regarding 7, it is undisputed that the leave of the court is to be obtained.
My lord.
So whether is there any direct contravention of this provision?
That is
the moment it is made that subject to the approval of the court.
Kindly.
So 7 cannot be contravened.
7 cannot be contravened.
Yes, so it is clear.
Yes.
So is there any decision which goes against this 7?
The Lord kindly sees, kindly sees first, the clause 1.
Yes, clause 1 is
Clause
there.
1 is appointment of special officers.
Yes, affairs is a vast thing. Okay,
so,
there is a vast state of affairs.
Including.
And this is a minor thing. Okay, whether they are
minor is a part of the major.
Whether the trustees are competent to take a decision, that is the question.
Yes.
And if so, definitely court's approval is required.
Whether the trustees can initiate a process for deciding when there is an authority appointed by the court to monitor the affairs.
This is a special clause. You see, sections that is clause 7. That is a general. 1 is a general clause.
Yes.
Now 7 is a special clause. Now whether 7 cannot be contravened. Okay, leave has to be obtained. Now whether the parties have contravened section 7, that is clause 7.
They are attempting to.
Yes, if they contravene, then
they are attempting to, because the moment they say that this is the agenda of the meeting, we are going to decide this.
No, but that decision has to be kept in abeyance. Unless the leave of the court is, that has to be kept in abeyance.
There is nothing which indicates, the notice does not indicate that. Hence, when we reply to them, to this notice, we say that you are not competent to hold the meeting.
No, you see, meeting has to be held for different purposes.
The meeting, has to be, kindly, permit me to say this. That I want to hold a meeting with regard to introduction of new courses. Bereft of 7, does it relate to the affairs of the institution or not?
Court's permission is not required to hold a meeting. I think you admit this.
With regard to the meeting of the trust, it is not required. But with regard to the affairs of the institution, it is.
See, policy decision has to be taken in a meeting.
Kindly do not read only 7. Kindly see, kindly comes to page 5 of the order. Under what circumstances the scheme was framed? It is undisputed position that the defendant number 1 to sought for restraining order for holding any meeting of the trustees of foundation to adopt any resolution on the ground that such meeting is against the order number 14. So our specific case is that you can't hold a meeting. This goes against the order framing the scheme.
Where do we find from the scheme that they cannot hold a meeting?
Yes, now I come to that. Whereby this court formulated scheme for smooth running of the management. I shall place the order which framed the scheme if required. The relevant part of the scheme then The name of two advocates of each side who will monitor the affairs of the educational institution. Now, I want to hold the meeting of the institution to introduce new
So
courses.
their presence is required according to you. Special officers' presence in the meeting is required. It may be so.
They will convene the meeting.
No. Question is, you see, whether that meeting has to be presided by the special officers.
They'll convene the meeting means their presence would be required because
You
they are
see,
the
regarding the course, an expert body's opinion is required. So whether the special officers can opine which subject is necessary for which purpose.
they may not be the experts.
But they have to be present in the meeting.
Yes. They have to, number one, convene the meeting.
Okay.
Whether
So special officer has to convene the meeting.
Convene the meeting. Then Lord kindly sees Lord 3. There would be an executive committee of 3 members. Has to be formed, which will be headed by the chair of the principal of the institution and 2 other nominated members, one for the plaintiffs and the defendant side. The executive committee shall act in assisting the joint special officers as and when required. But this is the expert body appointed to assist the special officers in running the institution. So the meeting may be convened by the special officers, but with regard to the affairs of the institution, it is the executive committee who has to take the call. Court has vested these powers with them. Or else, my lord knows, a college, has a governing body. So these trustees, they will nominate their own members as governing body.
Affairs continue throughout the year, okay?
Yes.
But this policy decision, it takes just once in a year or once in 2 years, whatever it is.
The court, left nothing, for speculation. Court, fixed with regard to the financial aspect. The court has fixed, who will do. The court has, said that the checks will be prepared by the plaintiffs, will be sent through the special officers. Special officers will cause verification, will send it to the defendants. The defendants shall sign and give it back. So nothing is left to speculation.
Agendas of meeting are fixed by the special. That means meetings are called by the special officers.
Meetings will be convened by the special officers, will be conducted by the executive committee. Lord, kindly will not permit me, subject to being corrected. The executive committee consisting of 3 members has to be formed, which will be headed by the chair of the principal of the educational institution. The executive committee shall act in assisting the joint special officers. To do what, my lord, is a question that I put to myself. To monitor the affairs of the institution.
What is your argument regarding the second point, the POSH Act, that inquiry?
Yes.
That they are trying to violate 3. By changing the composition of the executive committee.
Yes.
And what about your his argument, Mr. Gupta's argument on chair of principal as opposed to the incumbent?
Yes. Now, my lord, what is happening is, they have constituted as POSH committee.
That's under a different statute.
Under a different statute, but what
Court is quite right in saying that will take its course.
I kindly will permit me, why I say that had this been rooted, through the leave of the court, I will not have a chance to impress upon the court. Don't grant them leave because this is per se illegal.
But Mr. Chaturvedi, won't that be extra legal in the sense that POSH Act contemplates ICC and the procedure?
But there has to be a committee, in terms of law. What has been done is, these 5 plaintiffs have added themselves as a members of the ICC. Now, the ICC Act, Section 4, says that a senior member, of a senior employee has to be the chairman. Now
that you always have a right of challenge to that on the constitution of the committee under the act itself.
Now, who? I put this question to my. I am not affected.
The principal, then why are you? If you are not affected, what is your locus standi to file the appeal?
No, with regard to the other part of it, kindly look at this way.
How are you aggrieved? The principal may be aggrieved.
With regard to the apprehended decision.
Exactly.
But I am.
That's our next question.
Yes.
It will be an apprehended cause of action.
Right. Now, I am today on whether this can be done by a.
So your line of argument is same as the first point.
Authority who has assumed jurisdiction.
So that you are heavily relying on clause 1, in fact.
My lord.
That has to be the route through which everything goes.
Yes. 1 and 3. 1 is
1 and 3.
Yes.
All right.
Everything that has to be done
So
by
they're trying to change the composition of 3 by changing the principle.
Yes, they are changing three. They are changing the three executive committee by changing the person on the chair of the principal, and then get the one milord in their favor, because then the monitoring would be in their hands.
So that's all.
This is.
Any reply? Short, very short.
Yes. But firstly, my lord, as your lordship correctly pointed out, my lord, the chair of the principal, when that order was passed, there was no complaint at all. The complaint was of October. The order is of June. September. The order is of June. So, my lord, principals may come and go. That is why, my lord, the court had indicated that the chair would be the head of the committee would be the chair of the principal. So, my lord, this submission possibly is really not available to the defendant. Secondly, they are not persons aggrieved as it fell from your lordship. Thirdly, my lord, clause 1. Thirdly, my lord, clause 1 is to manage the affairs as is decided by the trust or the institute. So, my lord, they are to monitor only.
No, there, Mr. Chaudhary, there's a point that you're trying to confuse, quote unquote, between no, between
Yes, yes.
educational institution functioning and trust functioning.
But this really combines the two. This order really combines the two. If your lordship sees,
Yes, in a sense, yes.
yes,
Because 7 pertains to trust also.
and also possibly 3. I'm sorry, my lord, 2 going from the trust fund,
Trust cannot be divorced from the educational
because that is the functioning of the trust. So,
monitoring part of it, monitoring
Yes.
the affairs would be of the affairs of the educational institution.
as yes, in terms of the scheme as framed. So, my lord, the scheme which is framed here permits policy decisions to be taken. So, once a policy decision is taken for a course or not, they will monitor that. If a new course is then, if new faculty is engaged, are employed, they will make their payment and all.
Does the monitoring of the affairs also include the formulation of new policies?
But perhaps, my lord, it cannot,
That is
subject
what
to
is
my
the
lord's kind interpretation,
friend's argument.
is because the language is who will monitor the affairs of the educational institution. So, my lord, the affairs of an educational institution cannot be whether a new course has been taken, which is a policy decision of the trust. So, if a trust takes that decision that my institute would open new courses, then that new courses can be monitored. Again, subject to my lord's interpretation of that. My lord. And, my lord, the other thing is that this, from whatever has been submitted by my learned senior friend, my lord, that special officers were never permitted to call a meeting. My lord, the submission is that all the meetings have to be mandatorily routed through the special officers. Perhaps that is not evinced from any of the portions in that order. And, my lord, the order also does not render the trust deed per se nugatory, because if that be so, then the entire functioning of the trust.
The earlier meetings were convened by whom?
Never convened after we.
Prior to this.
But we do not know. We have pleaded specifically that since our induction, they have their objective is stalemate, not do anything because I have already inducted money. So let them enjoy that. And, my lord, the meeting clause is not altered.
You also go and enjoy some other matter. You're closing our books. It's hard enough. Was the appeal formally admitted? We said
No, my lord, the first day.
The appeal is
The
admitted.
admonition of the first day is the first.
The appeal is admitted to be heard on the grounds taken in the memorandum. Puts up next para. The court indicates to learned counsel for both sides that the appeal itself will be taken up for hearing in view of the short point involved. Puts up heard learned counsel for the appellants and learned senior counsel appearing for the respondent numbers 1 to 4. Puts up hearing is concluded. The matter is reserved for judgment. The appeal is reserved for judgment.
But only thing, there are 2 appeals. So appeals and the
Appeals,
respective
sub-
appellants.
right. Their appeal in Europe, right? Thank you.
Great.
Thank you.
অন্য ইয়ে নাকি এইটা
এটা হারালে মুশকিল হয়ে যাবে।
There was one hearing, my lord, in this court when we had, after 60 odd days of hearing, 60, where HIDCO, that those 61 retributions were heard.
Yes.
Every day from 2 p.m. to 4:30 p.m.
Ah.
But the parties had on the last date indicated to the honorable judge, my lord, that should we file a note.
আচ্ছা।
Then the reply was that take my note, see, jointly see if I have missed anything. Note was given to us for one day, and we both of us sat, my lord, and
Which bin?
Justice Banerjee.
That's bad.
So they were given. When we said that should we file a note?
Yes.
My lord, I am appealing on behalf of the plaintiff respondent, my lord.
Right. Yes.
My lord, the two applications, the appeal was dismissed for non-prosecution, my lord. On
This appeal.
yes,
This appeal was dismissed for non-prosecution.
yes,
Acha.
on 18th of November 2025, my lord. Thereafter, they filed two applications, CAN 5 for
For the
restoration.
respondent.
Yes.
You're for the respondent.
Yes.
Oh, restoration application.
Two application, CAN.
One for what? Restoration.
Yes, restoration.
Restoration?
And second is for the transposition.
So you're agreeing to both?
No, my lord.
Agreed to none?
No, my lord.
Then let them
My
move
lord.
Let them move them. Yes.
Lord, this my kindly my lord takes up CAN 5, my lord. This is my application for recalling and restoration of the appeal. But your lordship's order is at page 15, my lord. Lord, since my lord appellants were not interested to proceed with the appeal, hence my lord this was dismissed for non-prosecution. Now my lord, the person who was taking steps before this honorable court, my lord, he has acted against our interest. So my lord, we have preferred CAN 6, my lord, for transposition of his name.
He was in charge of conduct of the.
Yes, my lord. Yes, my lord.
You have averred that in this one.
Yes, yes. In CAN 6.
The CAN 4 also that should be there. Yes, that is one of the premises of this also. That is the explanation why this was not.
Yes, my lord. CAN 5, my lord.
Yes, you have stated. Paragraph 3 you have stated on the merits of the matter. Why unnecessarily?
My expansion starts from para 7.
7, yes.
Para 7, my lord.
Loss and surprise. Not even that. No. The cause of action for the main matter is still continuing.
No, my lord, we first came to learn from my lord on 28th of November 2025, my lord, when we received a notice.
Oh, from that you learned.
From there I learned.
How is the appellant number 11 connected to you?
Appellant number 11.
Are you related to each other?
Yes, my lord.
Yes. Surname is the same. Must be same.
Yes. He is the son of Ramesh Mondal.
These applications have been filed by the other appellants.
Other appellant, my lord. Other appellants. My lord, in this application, my lord,
shouldn't you give a notice to appellant number?
Yes, my lord, I have served.
Oh, you have served.
I have served.
Appellant 11 also.
Appellant 11 also, my lord. That's affidavit of service is also on record. I have served, my lord.
Yes. So on that ground, you are seeking for transposition.
Yes, I am seeking for transposition.
You have checked that the affidavit of service has been served.
Yes, sir.
Let us hear the yes, Mr. Admissibility.
My lord, kindly, my lord, first take the CAN application 5, my lord. Restoration, my lord.
Take the mic a bit closer to you. Yeah.
My lord, their appeal was dismissed, my lord.
Non-prosecution in the
non-prosecution,
not on instruction by the client not to proceed. Non-prosecution because they said they had lost contact with the client, which they've explained. Basically, in a way, dismissed for default with a different tinge, different color. So now they come up and say that the person who was looking after the case, he was not conducting well, and therefore they seek virtually this is a recall restoration application, and the other is for his transposition up to notice to him.
They are saying that this is the sufficient reason, my lord.
Why not?
My lord, kindly come to page 11 of CAN application 5, my lord.
Yes.
Page 11, in the beginning, they are saying that your petitioner to inquire about the present status of the first appeal.
Page 11 of CAN
5.
CAN 5.
That is a restoration application.
Okay.
The learned advocate informed your petitioner that since the said Varun Mandal alias Tarun Mandal, being the appellant number 11, who usually used to take steps with respect to the instant proceedings before the Honorable Court, did not keep any contact with him and had also failed to provide appropriate instruction, and accordingly the my lord, kindly come to the word, my lord, who usually used to take steps. Usually means
Sometimes he did not take steps,
sometimes,
others also took
yes,
steps.
He was entrusted to take the steps.
yes, they have not
To do that.
Yes, they have. He is not guilty, or he is not. Oh my lord. Normally, my lord. Usually, my lord. Generally, he is not bound to take steps, my lord. Every person, there are 12 respondents, including this Varun Mandal, my lord.
There is no expansion for them.
Every person is liable to take care of this case, my lord. My lord, he was not bound. Neither they has appointed him as a power of attorney or empowered him, especially empowered him to take steps in this matter, my lord.
Anything else?
So, my lord, he was he was authorized by to look after the case, my lord. Kindly come to their affidavit. He is only to sign this affidavit. Only to sign, not to look after the case.
No, sign the
Yeah.
affidavit means what? He is signing
That
with
is the same thing, my lord.
responsibility.
Look after the
He
case.
is coming to sign the affidavit. That means who will keep in touch with the advocate?
এটা অন্য লোক সাইন করছে যে যাকে ট্রান্সপোজ করতে চাইছে অবভিয়াসলি সে সাইন করে
সে সাইন করেনি
এটা তো চেক তো করছে না বলি
ওইটাই কথা বলছি
If he is authorized by them,
We have heard
then
you.
he is bound to
Any
take
other
steps.
point, Ms. Rani?
My lord, this is a negligence, my lord. This is a negligence, not only part of the
What else?
but
What else?
and negligence is not a sufficient cause, my lord. My lord, I am placing one judgment, my lord. Negligence cannot be called a sufficient cause to restore.
Negligence definitely cannot be caused a sufficient cause.
Yes.
Yes.
No, 20, yeah, 2014 Supreme Court 746. My lord, negligence, my lord. Sufficient cause shows, my lord.
Para 11, 12.
Yes, my lord.
Yes.
Paragraph 9 also, my lord.
9 also.
Fifth of one, sixth line, my lord. In the sufficient cause means that a party should not have acted in a negligent manner, or there was a want of bona fide, or in parts in view of the facts and circumstances. On circumstances, what, my lord? Suit. What was the? I am coming, my lord. What was the fact, my lord? And
Facts of the suit we won't go into.
Facts of the
facts are only of this restoration application. Regarding the main merits of the matter, we are not definitely not hearing you on either of you on that.
That means, my lord, they are negligent. They are not taking any action. This is an inaction on the part
What
of
was this application for with regard to restoration application?
Yes, my lord.
Section 5. That is condonation of delay.
Condonation of
Any other point, Ms. Rani?
My lord, these are the points, my lord. And my lord, if they are, if your lordship allow this application, then kindly give me time to heard the section order 23 application, my lord. Kindly fix the date, my lord.
Order 23 why? 23.
The can 6, my lord. Transposition.
We are allowing that also. That is a necessary consequence of allowing this. This person is not looking after their case. They want to transpose him. He has been given a notice. That's why you ensured that a notice is given to that appellant also. Their appeal, they want to transpose him. That person is not disputing. You don't have any locus standi even to oppose that.
The transposition, my lord, I am not the defendant, my lord.
You are a respondent in the appeal.
Respondent in this
The
appeal, my lord.
appellants say that one of us do not want to continue. We want to send him in the category of proponents only.
Then, my lord, he has not appeared. He is living there, my lord, in the same premises, my lord. But
maybe.
But they want to transpose this
appellant 11
appellant
to performer
to the performer respondent, my lord. If they
performer respondent, you ask?
Yes, performer respondent.
If he transferred in the performer respondent, my lord.
Yes.
Then
How are you affected? How are you affected at all? the short conspectus of the present two applications bearing Can 5 of 2025 and Can 6 of 2025 is that the appeal in connection with which the said applications have been filed, comma, was dismissed within double inverted for non-prosecution, double inverted clause, by an order dated November 18, 2025. Whose learned counsel appearing for the petitioners argues that the appellant number 11 had been contesting the appeal on behalf of the appellants, all on a sudden, comma, the petitioners were shocked and surprised to receive a notice from the office of the subdivisional officer Boshirhat, comma, upon attending the hearing pursuant to which the petitioners came to know that the appeal had been dismissed. Next para, it is contended that the petitioners immediately visited the chamber of the erstwhile learned advocate on record to inquire about the present status and learned that appellant number 11, comma, who usually used to take steps with respect to the appeal, did not keep in touch with him and also failed to provide appropriate instructions, comma, for which the learned advocate was unable to take steps in the appeal. Next para, accordingly, comma, the petitioners, being the other appellants, comma, seek the said order dated November 18, 2025 to be recalled and the appeal to be restored. Next para, in Can 6 of 2025, comma, on similar grounds, comma, the petitioners, comma, being the rest of the appellants, comma, seek the transposition of appellant number 11 to the category of pro forma respondent. Next para, learned counsel appearing for the respondents contests the said applications. Learned counsel places reliance on the averments made in paragraph number 9 of Can 5 of 2025 to the effect that Borun Mondol alias Torun Mondol, being the appellant number 11 within double inverted, usually double inverted clause, used to take steps with respect to the instant proceedings. It is submitted that the connotation of the said expression is obviously that it is not appellant number 11 alone who used to take steps in the matter, but it was the usual practice for him to take such steps. It is further argued that no explanation has been furnished for the inaction and negligence on the part of the other appellants insofar as the dismissal of the appeal is concerned. Next para, learned counsel cites such and such, Vasavraj versus such and such, reported at AIR 2014 SC 746 for the proposition that negligence or inaction or lack of bona fides on the part of the litigant cannot be construed to be double inverted sufficient cause, double inverted clause. Next para, insofar as the transposition application is concerned, comma, learned counsel also opposes the said prayer. Next para, upon hearing learned counsel, comma, we find the explanation furnished in paragraph numbers 9 to 12 of Can 5 of 2025 to be sufficient explanation for the lack of instructions on the part of the appellants to their counsel on the relevant date. Next para, from the records, comma, it is clear that it is the appellant number 11 who used to take steps with regard to the appeal and affirm affidavits. Next para, thus, comma, there is thus, comma, the explanation furnished in Can 5 of 2026 is sufficiently plausible to the effect that since the said appellant was at the helm of affairs, comma, the other appellants did not actively participate in the conferences with the advocate, with their erstwhile advocate for the conduct of the appeal. Next para, from the tenor of the order dated November 18, 2025, it is clear that although the appeal was dismissed for within double inverted non-prosecution, double inverted close comma, the same was not any specific instruction by the appellants for the appeal not to be proceeded with, but due to communication gap between the appellants and their advocate. Full stop, next para. Accordingly, comma, insofar as the proposition laid down in Basavaraj and another supra is concerned, comma, there cannot be any manner of doubt with regard to the proposition laid down therein. Full stop. However, comma, in the said case, comma, the Honorable Supreme Court was considering the condonation of delay. Whereas in the present case, comma, the application has been filed within the statutory limitation period for filing a restoration application. Full stop. Next para, even otherwise, comma, in view of the above discussion, comma, we do not find any clear proof of negligence or inaction or lack of bona fides on the part of the appellants per se. Full stop. Hence, Can 5 of 2025 is allowed on contest, thereby recalling the order dated November 18, 2025 and restoring FA 214 of 2022 along with Can 3 of 2023 and Can 4 of 2025 to their original file and number. Push up next para. We take, insofar as Can 6 of 2025 is concerned, comma, we take note of the fact that despite service of notice as per direction of the court, comma, the appellant number 11 chooses not to appear at the time of hearing of the matter. Full stop. Next para, thus, comma, the allegations against the appellant number 11 made in Can 5 of 2025 and Can 6 of 2025 remain uncontroverted insofar as the said appellant is concerned. Full stop. Next para, the appellants are the dominus litis of their appeal, and it is not for the respondents to dictate as to who should be arrayed as an appellant and who as a pro forma respondent. Full stop. In the facts and circumstances as narrated above, comma, we are sufficiently impressed with the necessity to transpose the appellant number 11 to the category of pro forma respondent in view of the said appellant having apparently failed the other appellants insofar as the conduct of the litigation is concerned. Full stop. Hence, Can 6 of 2025 is allowed on contest, thereby directing appellant number 11, namely Borun Mondol alias Torun Mondol, to be transposed from the category of appellant to that of pro forma respondent in the appeal. Full stop. The necessary consequential correction amendment to that effect shall be carried out in the cause title of the memorandum of appeal as well as the cause title of the other pending applications filed in connection with the appeal. No orders to cause certain certified policy. Regarding the other applications, we'll take it up on the next day. We'll come prepared on Can 3 and 4.
Can 3 and 4.
We'll take only one thing, Can 3 and 4, if your lordship would kind enough to look at the
use the mic, Mr. Bhatt.
18th November 2025. Kindly see, my lord, the order dated 18th November 2025, the order of dismissal. Kindly see, my lord, the third paragraph, hence FA number 214 of 2022, along with Can 3 of 2023 and Can 4 of 24 are dismissed for non-prosecution without any order.
There wasn't any order.
No. First of all, my lord, I had only filed the appeal. 3 and 4 was filed by the respondent. My lord, if your lordship restores the appeal, my lord, they are not praying for restoration of their applications.
Well, the purpose of it is solved.
Number 2.
Can 4 application, my lord. I have filed the Can 3 is their application.
Can 3 and 4
3 and 4 both are, my lord. I have the copies, my lord. Both are filed by my learned.
4 is already purpose solved, my lord.
What purpose?
When this appeal was dismissed, my lord, in the meantime, my lord, that application was Can 4 for the
I tell your lordship, my lord,
for the protection of police, my lord, for the protection of police self, my lord, as because, my lord,
petition filed by which my learned friend had got that order.
No, at that time, my lord, when the appeal was dismissed here, my lord, and I have in execution, I have got the full possession with the full satisfaction of decree, and that is the agriculture land, my lord. I have harvest paddy there, my lord. In there, my lord,
Police
at
help,
the
you
time
have
of,
already harvested the paddy. You asked for police help in Can
yes,
3.
here, my lord,
Can
and
4.
in Can 4, my lord.
So you have already got the paddy.
Yes, my
So Can
lord.
4 has been rendered infructuous.
Yes, my lord.
Can 3?
That is expeditious hearing of the appeal, my lord. Paper.
Their application.
No, you have filed the application, my lord, calling for LCR, my lord. I find, my lord, the from my brief, the erstwhile learned advocate had already prepared paper books.
Any other application is pending?
No.
There is state in disposal.
My lord has to be pending, my lord. Can 1.
Cannot be stay because otherwise they could not have got possession. They're saying.
My lord, Can 2.
Expeditious.
Can 2 ta pending ki na? Appropriate order.
So Can 4 we are recording, Ms. Rani, that it's
Yes, that is infructuous, my lord.
infructuous.
My lord, Can 2, my lord, is an application, my lord, filed by my client, my lord, for preparation of paper book, LCR expeditious hearing of
So
the
Can
appeal.
Can 2.
Can 2.
Can 2 or Can 3 are same, sir, then.
Can 2 ta
What is
pending
Can
ki na?
3 then? What is Can 3?
Yes.
And Can 3 is, my lord, the application for send down the record, my lord, as the execution was pending, my lord, and
Now you've
in the
got.
meantime, yes, my lord.
So
I
Can
already
3
got
also
a
is
precedent.
infructuous?
Three also infructuous, my lord.
And
And
Can 1, my lord, was filed by my client, my lord, praying for, my lord,
Injunction, that is a
injunction.
injunction, my lord.
Injunction, my lord, from putting the degree into execution.
Infructuous.
Infructuous because degree has been. 2 is
5 and 6 was only pending. 1, 2, 3, 4.
2 হচ্ছে for expeditious calling for paper book LCR lower court record. But from Millard, the brief which has been handed over, Millard, from the learned advocate on record, Millard, I find, Millard, the paper book is ready.
Paper book is ready and they have prayed
Millard,
before your
even
lordship
paper book is
to
ready,
file a
Millard.
supplementary paper book, my lord.
Records have come.
Yes,
You
my
asked for sending down,
yes,
so it
yes,
must
yes.
have come.
No. Your record is here, my lord.
Millard, I can
We'll
start.
dispose of all the applications.
I can start the appeal today itself, immediately. Ready with
Whether
that.
she is prepared in the matter. In the appeal, you are prepared.
No, my lord, I have not come with the preparation.
Paper books have come before us also, is she? Ajay, what is the appeal?
Yes.
Let us dispose of these applications first, then we'll think about that.
Application 1.
পারবেন নাকি
যা বললাম তারপরে বলছি Can 4 of 2020, Can 4 of 2020 which year? 25?
Disposed of. এখানে pending
My lord, there is a supplementary paper book, my lord, which they have not served me, my lord.
Can 4 of 20 will not take up there.
Millard,
Can 4 of 2025 is an application for police help
সবই disposed, যে last order
filed by the respondents
করে দিয়েছে।
to enable the respondents to harvest paddy in the suit on the suit from the suit property. Full stop. Next para, learned counsel for the respondents, however, submits that the same has been rendered infructuous in view of the decree, impugned decree having already been put into execution and possession being taken. Full stop. Accordingly, Can 4 of 2025 is disposed of as infructuous. Full stop. Next para, learned counsel for the respondents further submits that Can 3 of 2023 was an application for sending down the trial court records in order to enable the respondents to have the decree executed, which of the same has also been rendered infructuous in view of the decree having already been satisfied. Full stop. Hence, Can 3 of 2023 is also disposed of as infructuous. Full stop. Next para, learned counsel for the appellant submits that Can 1 of 2020, what was that for 2025?
Can 1.
Yes.
One is a stay application,
Of
my lord.
2020?
2022.
Of 2022 was filed for injunction or stay?
Injunction restraining the respondents from putting the degree into execution.
For injunction, restraining the respondent from putting the decree into execution, full stop, for obviously, comma, due to the reasons narrated above, comma, the said application has also been become infructuous and is accordingly disposed of.
This was ordered, my lord. The Honorable Justice Tapabhattu Chakravarti
What order was passed?
order, my lord.
Disposed of.
Yes, disposed of to pay the 10 lakhs rupees to me, my lord.
It was disposed of.
Yes, my lord.
Well, our Millard system says disposed of records.
Can 2?
Disposed of, my lord.
Excellent.
Can 2?
Can 1.
It was show if it was disposed of then. What about Can 2?
Can to their
ক্যান
application.
টুটা কি আছে লিস্টে দেখাচ্ছে? হ্যাঁ ডিসপোজাল
Can to is their application for disposal of.
কোনটা চাই দেখছো এই ক্যান ওয়ানটা হচ্ছে এটা
পেন্ডিং নয়। ক্যান টু ইজ অলসো ডিসপোজাল, তাহলে ক্যান ওয়ানটা কেটে দাও। Since we are informed that the appeal is otherwise ready for hearing, comma, let the same be placed in the list for hearing on May 20, 2026. 20th May for hearing. Come prepared. What? So grateful.
Number 34. The FA for the respondent.
Yes, Mr. Kaur.
I'm for the respondent petitioner for the appellant opposite party.
Acha, you are for the appellant.
The respondent
Hello,
appellant. No, no.
One intelligence, my lord,
Opposite party.
20th, my lord, kindly skip. 20th, my lord.
Not
I am-
20th.
Not 20th, my lord.
Why?
My lord, I am engaged in another court, my lord.
Uh,
Twen-
Disengage yourself from that.
After 22nd May, my lord.
No, no, why? You'll be coming to court after 22nd.
No, my lord.
Let us fix it on 23rd.
Then, my lord.
No, no, let it appear on 20th. Let us see whether we can take up. Yes, Mr. Kaur, you are for the appellant opposite party.
Appellant opposite party.
Very well.
So the petitioner before lordship is the defendant in the original suit for specific performance of a contract. Where not the agreement was an unregistered, unstamped document, which was initially not admitted in evidence. This application is under section 61 of the Indian Stamp Act, my lord, which provides not that the appellate court, the court to which the appeal lies, that court can reopen the issue of stamping. So my application is under section 61. Now, and I'll be relying on a judgment of the Honorable Apex Court recent judgment, which says that if the issue of admissibility is not conclusively judicially determined, the court can always reopen it. Although there's a bar under section 36 that if it is admitted in evidence,
That is not a bar to court.
Not a bar to court if it is not judicially determined. I shall try to show that it has been admitted. The issue whether the document was sufficiently stamped or not, that point was never decided. Although
No, but section 36 also provides an exception for section
under section
61.
61.
So that's why 61 was the only resort.
Only resort for me, my lord.
Let us see 61 once, Mr. Banerjee.
May I just
It's not every day that you come across a section 61 application. Therefore,
here, my lord, the document was initially admitted in evidence. An application was filed by my client saying that it is not sufficiently stamped. It was
adjudicated.
It was not rejected. Again, not judicially determined.
Administratively rejected.
Held that since section 36 is there, document has been taken on record.
So what else is judicial?
Whether the document is admissible, sufficiently stamped or not. Court held that.
But that was an adjudication.
No, since section 36 comes, court says that there's a bar under section 36, so you cannot reopen it.
But you did not challenge that order.
That order was challenged in revision. The same thing that there's a bar under section 36, you cannot. But this is the recent judgment of the Apex Court says that the court has to judicially determine whether the document is admissible.
So let us first read once section 61, then we'll come to that judgment immediately. A very short question.
Very short question.
So all this happened obviously in the trial court.
In the trial court.
Now you are taking this before the appellate
Before
court.
the appellate court. When I'm reading 61.
61, yes.
When any court in the exercise of its civil or revenue jurisdiction of any criminal court, any proceeding under chapter 12 of chapter 36 of the Code of Criminal Procedure makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp or upon payment of a duty and a penalty under section 35, the court to which appeal lies from. Or
So you are neither the collector nor the court, Mr. Banerjee.
I can point out to the court.
So you are invoking our
I am
jurisdiction.
invoking the court. Jurisdiction of the court, my lord.
Can it be done on if an application is provided for and it's restricted to the
I
collector?
can point out to the court, my lord. Application by collector, but I can.
If
point
nothing
out
was
to the
stated, court can take into consideration, then we can understand.
This not
If it's specifically stated that application of collector or suo motu. Anyway, let us hear you. Let us for the time being give it the widest amplitude. Yes.
The such first mentioned court may, of its own motion or on the application of the collector, take. So this is not the provision. Now, in this matter, what happened? Not the document was admitted. Then we filed one application pointing out that it was objected to, objection was not recorded. That order rejecting that application is not at page 32 of the application. Here, my lord, we have taken the point that PW1 during evidence has said that the document is not properly stamped and he is ready to pay the stamp. This fact was pointed out to the court. But court did not go into the judicial determination of whether it is stamped or not. Rather went on the fact that it has been admitted, so you cannot reopen. That is my point. If your lordship can take up page 32 of the application.
But here 61, does it permit us to reopen the issue? It has been decided by the trial court. This was a specific point you took, an objection you took there.
My submission.
Because this says the order of admission, if it's an order of admission simpliciter admitting the document, then court can not reopen. In fact,
after the admission, when it was pointed out, the court said that the order is annexed. Court says that
36 bar.
It has there's a bar.
That was also an adjudication, maybe erroneous adjudication, but an adjudication also.
Adjudication on section 36, but not on the admissibility. Now,
So not on this section 61(1) scenario. I mean, not on this aspect of the matter, whether it was sufficiently stamped.
I will rely on this judgment of the apex court, which the specific question was framed whether it can be reopened or not. On that note, the court says that it is a judicial determination, otherwise it is the duty of the court. The substantial question arising for decision in this civil appeal is whether upon admission of an instrument in evidence and marking as an exhibit by court, despite the instrument being chargeable to duty but is insufficiently stamped, such a process can be recalled by the court in exercise of inherent power saved by section 151 of the Code of Civil Procedure for the ends of justice or to prevent abuse of the powers of the court.
So this was under section 150.
151. So, I have filed an application to your lordship under section 61. But I have invoked the jurisdiction of the court to go into this issue of admissibility, my lord, whether it is stamped or not.
What was held here?
Here, my lord, if your lordship kindly comes to paragraph 12 onwards.
It was held that under 151 it can be done.
150 can be done. Can be done, and the court has held that if it is judicially decided.
Where is that?
Paragraph 12 onwards, my lord. 12, 13, 14. May I read 12, 13, 14?
Yes.
Go to the
Yes.
Read in isolation, a literal interpretation of section 35 of the 1957 Act seems to make the position in law clear that once an instrument has been admitted in evidence, then its admissibility cannot be contested at any stage of the proceeding on the ground of it not being duly stamped. A fortiori, it would follow that any objection pertaining to the instrument's insufficient stamping must be raised prior to its admission. However, section 35 of the 1957 Act is not the only relevant section. It is preceded by sections 33 and 34, and all such sections are part of chapter 4, titled Instruments Not Duly Stamped. Certain obligations are cast by section 33 on persons or officials named therein. Should the presiding officer of the court find the instrument to be chargeable with duty, or it is either not stamped or is insufficiently stamped, he is bound by section 33 to impound the same. Section 34 places a fetter on the court's authority to admit an instrument which, though capable with duty, is not duly stamped. The statutory mandate is that no such instrument shall be admitted in evidence unless it is duly stamped. The presiding officer of a court, being authorized in law to receive an instrument in evidence, is bound to give effect to the mandate of sections 33 and 34 and retains the authority to impound an instrument even in the absence of any objection from any party to the proceedings. Such an absence of any objection would not clothe the presiding officer of the court with power to mechanically admit a document that is tendered for admission in evidence. The same limitation would apply even in case of an objection regarding admissibility of an instrument owing to its insufficient stamping being raised before a court of law. Irrespective of whether objection is raised or not, question of admissibility has to be decided according to law. Presiding officer of a court, when confronted with the question of admitting an instrument chargeable with duty, but which is either not stamped or insufficiently stamped, ought to judicially determine it. Application of judicial mind is a sine qua non, having regard to the express language of sections 33 and 34 and interpretation of perimeteria provisions in the Indian Stamp Act by this court. However, once a decision on the objection is rendered, be it right or wrong, section 35 would kick in to bar any question being raised as to admissibility of the instrument.
It should be 36 probably.
36 will not possible because 36
is the bar.
To bar any question being raised as to admissibility of the instrument on the ground that it is not duly stamped at any stage of the proceeding. and the party agreed.
And a decision has been rendered on the objection, be it right or wrong.
Taken to bar in question as being raised as to admissibility of the document on the ground that it is not duly stamped. So, then the court goes on to what should be judicial determination. That has been discussed in paragraphs. Paragraph 18, on the face of such an order, it does not leave any scope for doubt that on the date the GPA was admitted in evidence and marked as an exhibit, the trial court did not deliberate on its admissibility, much less applied its judicial mind, resulting in an absence of judicial determination. In the absence of a decision on the question of admissibility, or in other words, the trial court not having decided whether the GPA was sufficiently stamped, Section 35 of the 1957 Act cannot be called in aid by the respondent. For Section 35 to come into operation, the instrument must have been admitted in evidence upon a judicial determination.
You say the judicial determination has to pertain to the admissibility itself.
Stamping, yes. That
So
has to be done.
merely saying that no, this is
Admitted in evidence.
barred by 36.
No objection. That will not. It has to be decided. No, the document.
Whether actually that is insufficiently stamped.
The duty of the cast on the court to see whether it is actually stamped or not. That is a judicial determination. Otherwise, 35 or 36 will not come in. Once there is such a determination, whether the determination is right or wrong cannot be examined except in the manner obtained in Ordinance Section 35.
35 in a sense operates independently of 36. 36 debars a party from taking an
objection. So the mandate not upon the presiding officer is from 33, 34 and 35. That mandate is there. Now this has to be read with Section 61. So it is not closed. I can take up the issue. And now I'll place the order which was passed on my objection, because if your lordship holds that the point has been decided, then I have nothing. No case. Page 32.
That would also be barred by the principle of res judicata, apart from everything else.
If the judicial determination,
if
the point is decided, whether it is sufficiently stamped or not, if that point is decided, but that point was not decided in my humble submission. Revision order Page 32, my lord. There were two petitions filed, my lord. Today is fixed for hearing petitions dated 13/12/2006 and 15/1/2007 filed by the defendant. Both the petitions dated 13/12/6 and 15/1/7 filed by the defendant and the written objection filed by the plaintiff to the said petition filed by the defendant. From the petition dated 13/12/2006, it transpires that the defendant has stated that the plaintiff in para 5 of his affidavit in chief has stated that he has filed the original agreement for sale dated 15/5/2002 and the said agreement has been marked as Exhibit A. It has also been contended in the said petition that the said agreement dated 15/5/2002 is neither made on proper stamp.
Plaintiff's exhibit was marked as A.
Yes.
Isn't it marked as 1, 2, 3, 4? The plaintiff's.
But plaintiff's documents are always marked as.
No, that is in the original side, Exhibit A, B.
Yes, my lord.
But in the district code, it is
the other way around. Yes.
Then I'm wrong, my lord.
No question of being wrong, Mr. In the district courts, what happens in the trial courts, plaintiffs are exhibit one series. And anyway, so might have been tendered to their witness or something like that. Anyway, let us proceed.
Then, my lord, the agreement is inadmissible in evidence and as such it cannot be marked exhibit. It has been prayed in the said petition that this court may be pleased to consider the objection raised by the petitioner in the matter of marking the said agreement as exhibit. The said defendant filed another application on 15/1/2007. In that petition, it has been stated that the said agreement was made on proper stamp paper, nor it was a registered document. It has also been stated in the said petition that PW1 in his evidence has stated that he is ready and willing to pay the court fees of stamp duty on the said document as per the provisions of the Indian Stamp Act as amended. It has also been stated that this defendant came to know from the record that on 13/12/2006 that the said document has been marked as exhibit, but no order as per the provisions of law was passed considering oral objection raised by the lawyer for the petition. The plaintiff filed a written objection stating inter alia that the original agreement for sale has been marked as exhibit applying the settled principle of law as the same has been admitted in evidence without any objection from the side of the defendant. It has also been stated in the said written objection that the statements made in para 3 of the petition of the defendant are misconceived, misdirected. This goes on, then next paragraph. I've gone through the materials and record and the evidence of PW1, which was recorded on 10/11/2006. From the said deposition, it transpires that the said oral testimony of PW1 was dictated in open court. Thereafter, it was typed by the concerned ministerial staff. Learned advocate for the defendant has relied on a decision reported in so and so. Then the decisions have been not quoted. Next page, my lord. Here on provisions of section 36 of the Indian Stamp Act, learned advocate for the plaintiff has vehemently submitted that in para 9 of the WS, defendant has unequivocally admitted that this defendant entered into an agreement on 15/5 for sale of the premises for a total consideration of 19,50,000 only to the plaintiff. To him, the said document is a bilateral agreement, and the defendant has also relied on the said document. Therefore, to him, it is an admitted document. To him, this is a judicial admission by the defendant. He has relied upon section 58 of the Indian Evidence Act. To him, at this belated stage, this court cannot put any endorsement on the to the effect objected to. So, this was the
Banerjee, if you lend that interpretation, what you are wanting us to lend to section 61, that would negate the very purpose of section 36. So the embargo is squarely on the person who did not take an objection, you in this case. So section 36 creates a clear embargo subject to dilution by section 61, except in the circumstances under section 61.
61.
Therefore, if we constitute section 61 to take away that embargo, under the garb of court's suo motu consideration, you can also point out that objection. That will be doing injustice to the section itself. Probably I'm not clear. I'm repeating that. Section 36 creates an embargo specifically on a party, the other side, defendant in your case. Specific embargo on that party, only exception is carved out in section 61, subject to section 61.
Right.
Section 61 does not confer you the right, collector or court. So one is the state, the revenue authority which is affected. Court's powers are retained. It's always written in anything, order of 227B, everything.
Under 61, it is written.
Under 61, like
Or
order of 227, those powers are written. Court always has the power if it wants.
Right.
But here,
I am debarred from taking this.
You are debarred. There was 61 also
There
does
you have
not lift
36
that
and
embargo. 61 does not lift that embargo. So if you read 61 along with section 36, conjointly read, the embargo on you remains.
Now, my lord, in view of this,
Collector and court has the right.
Now, upon the pronouncement of the apex court,
Does not change the situation on
151, I cannot invoke the power. This says that inherent power under 151 can be invoked.
First of all, this is not a judgment on, this is not a precedence on section 61 scope. First of all. Secondly, this does not deal with a specific situation where an application was made, an objection application was separately made. This only deals with a situation where it was admitted, the situation on that date, that can be reopened. But here you specifically took out, there was a second stage here. You took out an application specifically.
This application may be not read as well my invoking the power of the court under section 151. I have two limbs. There are two limbs of my argument. First,
that has been decided here. Here, court
has decided
permitted that 151. Your 151 then has been rejected already. 61 cannot be that 151.
My application was not an objection, my lord, to the.
That was your 151, which was allowed by the Supreme Court. Up to that stage, if you preferred a revision against that, we could have invoked this.
Revision has been preferred, my lord, which was
there.
again in the revision again, my lord, the court has said that in view of 36 you cannot reopen.
Yes, therefore you have lost there. So you have reached, you have crossed this stage. That was the 151 stage you have crossed. That was the 151 stage. You are right.
Now, Lord, if my
this deals up to 151 stage.
This, Lord, I understand, Lord.
You have crossed one stage further.
But in this case, my lord, the court says that there has to be judicial determination. My case now, my lord, is that there was no judicial determination as appears from this order. Only, my lord, on technical ground, the objection has been turned down.
Not a judicial decision is taken in what context? Judicial
regarding stamping.
No, we read out the language of para 14 here. Ought to be judicially determined. However, once a decision on the objection is rendered, a decision on the objection, be it right or wrong, section 36, it should be would kick in. You took out an objection, decision taken on that, right or wrong? Wrong.
But this decision has to be read, my lord, in paragraph 18. If your lordship reads 14 with 18, what shall be the decision, my lord? If your lordship
On the
reads
question of
18,
admissibility.
what is the decision? Decision would be a decision, my lord, conclusive decision of the court that no, the document is not.
But this is not a precedent for section 61 scope.
No, not on 61, my lord.
But section 61 is not considered here at all. 151, even if we take it that under 151, it can be determined.
Lord, my first submission would be that section 61, Lord, may be not read in the manner that since the court
Mr.
has the
Banerjee,
power.
this judgment, what this judgment does it is prolong your time. That section 36 contemplates you have to take an objection. Prolongs your time to take the objection to wriggle out of the rigor of section 36 up to the pendency of the suit. Basically, it's that.
Appeal is continuation of the suit, Lord. So I can now also, Lord, I can invoke 151, Lord, because of the only fact that, Lord, there was no judicial determination as per section 18. Had there been a judicial determination?
So 151 has been decided rightly or wrongly.
যেটা বলতে চাইছে ওই যে ইস্যুটা ডিসাইড হয়ে গেল এই পর্যন্ত এইখানে যেটা বলছে কোর্ট কি বলছে সুপ্রিম কোর্ট যে জুডিশিয়াল ডিটারমিনেশন কিসের আর ডিসিশন এই ডিসিশনটাকে কোয়ালিফাই করছে এখানে আর ডিসিশন অন দ্য কোয়েশ্চেন অফ অ্যাডমিসিবিলিটি এই যে লাগবে ডিসটিংগুইশ করতে চাইছে অ্যাডমিসিবিলিটি ইস্যুটা কোথাও নেভার ডিসাইড মানে কোর্ট বলেছিল যে তুমি দেরি করে করেছো আফটার 36 এ করেছো সেকশন 36 এ অলরেডি বার কিন্তু মেরিটে বললো না ওটা ওই ডকুমেন্টটা মানে রিভিশনাল জুরিসডিকশনে তো সেটাই সেই পয়েন্টগুলো নিয়েছিল তাহলে রিভিশনাল কোর্টের এগেইনস্টে সুপ্রিম কোর্টে যেত
They are escaping, Lord, payment of stamp duty, Lord, at the trial court stage. Now I am pointing out, Lord, and I am not relying on paragraphs 18 and 21 to submit that, Lord.
Manage the collector and get an application file. You can.
Lordship has seen paragraph 21, Lord. The duty cast upon the court should have considered this point. The court has never considered whether document is stamped or not. They only went on, Lord, whether I have objected or not on that day, whether it is.
Revenue would suffer a huge loss. We can understand, but revenue is not coming up.
No.
Section 61 is for that purpose
Yes,
only.
the
Otherwise, why collector is not a party? Why should the collector be given an opportunity?
Lord, considering these paragraphs, 18 and 21, Lord, the 61, Lord, application may be considered constituted not as a application invoking the power, inherent power of the court.
If you had not
to
made
point
that,
out to the court.
If you had not made that application, Mr. Banerjee, it would be much easier for us to do that.
That is the impediment. But I say, Lord, that application, Lord, doesn't conclusively, the order doesn't decide, Lord, on merit. There's no judicial determination. Para 18. Only technicality.
And para 21 is very specific on that. What you are saying. Para 21. But if this is to be taken to the hilt, Mr. Banerjee, there would be no meaning to the section 36. 36 should be just erased from the statute. It's you who are taking this point. And this is the second round.
Point was taken but not decided. So whether I can take it up again, my lord. The question framed was, my lord, substantial question arising for decision in this appeal is whether upon admission of an instrument and its marking as an exhibit by a court, such a process can be recalled by the court in exercise of inherent power. That was the question.
That stage is over now. That application was that
151, Lord, was not decided, my lord, as per para 18.
This stops up to 151.
151, which is
you have got one step further. You have gone up in revision against that loss there.
But in the order of the revision also doesn't decide the issue of Millard.
No, but then it's constructive res judicata. Or issue estoppel at least. They have raised this issue. Took a stand. Not issue estoppel, constructive res judicata, definitely.
No, but not so far as stamping is concerned, it's a duty on the court.
No, Mr. Banerjee, you took a point categorically that this is not admissible. That was
my
disputed
point
on
was that I
whatever
have
ground.
objected, it was not recorded. My application was that I have objected.
That application was decided either way.
That was decided.
Difficult to interfere in. Let us hear Mr. Kaur. Yes, Mr. Kaur.
May it please the Lord.
Yes. But good argument, Mr. Banerjee. Let us think.
I'm sorry.
Sorry, Mr. Gauri. Yes, sorry. Yes.
My learned friend has read the order of the trial court, but he has referred to rely on the judgment of this court in revision. Lord, may I hand up to your lordship?
Please. This is the revisional order passed against that order?
Yes.
Yes. That order?
It is dated 17th October 2012. Lord, second paragraph. The application is at the instance of the defendant and is directed against the order dated 1st February 2007, passed by the learned civil judge Senate Division, 3rd Court at Alipur, entitled suit number so and so, thereby rejecting 2 applications filed by the petitioner. The short fact is that in marking a document, agreement for all, no objection was raised. And the document was marked exhibit on proof. Then on the next day, Lord, this is also incorrect. I'll show it to your lordship. An application was filed for raising objection on the ground that the section 36 of the Stamp Act has not been complied with, and the document was required to be properly stamped, and so impounding was to be done. Another application was also filed on the same fact, and those 2 applications were disposed of by the impugned order. Being aggrieved, this application has been preferred. Having heard the learned advocate for the petitioner and in going through the materials on record, I find that the said agreement for sale dated was marked as Exhibit A. While the document was marked Exhibit, no objection was raised. But the learned advocate for the petitioner has pointed out that in paragraph 2 of the application an objection was raised, while another learned advocate for the defendant regarding marking of the same. Anyway, there is no indication in the deposition, but simply recorded that document has been marked. Under the circumstances, the learned trial judge has held that the contention as raised by the defendant is an afterthought, and as such, he did not accept such contention. The learned trial judge is the best person besides in this respect, because the matter has taken place in his presence, and as he recorded the document has been marked exhibit, meaning thereby no objection was raised at the time of marking. This being the position, the impugned order should not be interfered with. The application is therefore dismissed. My lord, my submission, first submission before your lordship, is the issue is res judicata. They have raised the issue. They have gone up to the highest court. They have rejected.
The second highest court. Yes.
Whether they are entitled to come to this court. Lord, I am grateful to my learned friend for citing 62 Supreme Court. There is a specific passage in that
62 Supreme Court.
Yes, my lord.
No, it's a
No, no.
reference in 2018. paragraph.
62 Supreme Court.
No, he did not cite.
That is at page, my lord, the GM Shahul Hamid versus Jayanti R. Hegde.
It's a reported judgment.
It's a paragraph.
Just now
It's paragraph.
Paragraph
Of
50.
this.
appeal number 1188 of 2015.
Yes.
Yes.
You should be grateful to the judges. He did not cite. So they cited.
No, my lord, I am grateful to my learned friend for citing this judgment.
His judgment so that he could, yes.
My lord, if your lordship takes paragraph 15, where a question as to the admissibility document is raised on the ground that it has not been stamped or has not been properly stamped, it has to be decided then and there when the document is tendered in evidence. Once the court, rightly or wrongly, decides to admit the document in evidence, so far as the parties are concerned, the matter is closed. Section 35 is in the nature of a penal provision and has far-reaching effects. Parties to a litigation where such a controversy is raised have to be circumspect, and the party challenging the admissibility of the document has to be alert to see that the document is not admitted in evidence by the court. The court has to judicially determine the matter as soon as the document is tendered in evidence, and before it is marked as an exhibit in the case. Record in this case discloses that the hundis were marked as Exhibit 1 and P2 and bore the endorsement admitted in evidence and the signature of the court. It is not therefore one of the cases where a document has been inadvertently admitted without the court applying its mind to the question to its admissibility. Once a document has been marked as an exhibit in the case and the trial has proceeded all along on the footing that the document was an exhibit in the case and has been used by the parties in examination and cross-examination of their witness, Section 36 of the Stamp Act comes into operation. Lord, this part is relevant, my lord. Once a document has been admitted into evidence, it is not open either to the trial court itself or to a court of appeal or revision or to go behind the order. Such an order is not one of those judicial orders which are liable to be reviewed or revised by the same court or of a court of superior jurisdiction.
This has been diluted in this judgment itself.
Lord, this is a 4-bench judgment.
And what has been held in this judgment is contrary to this. Have you
Lord,
got a
now-
copy of this judgment by any chance? This is a four-bench.
This is a 4-bench judgment.
Four bench.
Four
judge bench.
4 judges bench.
So they should prevail then.
Milord, may I get a
15
copy?
says 4 judges.
Yes, we'll just check up.
May I get a copy?
I'll just check up.
A bench of 4 honorable judges. It's recorded. Paragraph 50.
A bench of 4 judges this is recorded here, Milord.
Oh, such.
Right.
Yes.
Followed by a 3 judges bench.
Huh?
Followed by a 3 judges bench.
The 3 judges bench diluted it a bit. If you see the 3 judges bench,
3
the
judges
italic
bench is also
portion,
there, Milord. The next one.
where a document has been inadvertently admitted without the court applying its mind, the instrument could not be said to have been admitted in evidence with a view to attracting.
Milord, in any event, 4 judges bench remains.
No, Javed Chand itself held that.
Because the court has applied the subsequent matter, reason, on the application.
And court also considered Javed Chand. In the subsequent Ramratan, court considered Javed Chand.
Yes, Milord. Milord, I'm sorry, Milord.
Yes, please continue. Yes.
Milord, my first submission is, if the Supreme Court has held that once a document has been tendered, rightly or wrongly, then it cannot be challenged subsequently. This is my first submission before your lordship. My second submission before your lordship is that they have challenged the order passed by the district court. And they have come up to the High Court in revision. Therefore, the issue cannot be re-agitated now in the appeal. Whether it is right or wrong. Lord, may I only give factual aspect, my lord, and then I will. My lord, 1 or 2 dates, my lord, if your lordship permits me. My lord, document exhibit A was tendered on 10th November 2006. Miller, I'll give the relevant passages of the judgment from which I am quoting this. Then, my lord, 2 applications were filed.
1312 and 15-1, 2006.
13 December and 15 January.
Yes.
Then these applications were disposed of by order dated
1st of February.
1st February 2007.
Yes.
And my lord, I have handed over the revisional.
That is 17th of October,
That's
2012.
17th of.
These are the relevant dates.
These are the relevant dates.
Yes.
So, my final submission before your lordship is that as held by the Supreme Court, even the appeal court does not have jurisdiction to reopen the issue once the document has been admitted. without objection.
Just one more date. The decree was passed in 2021. So after more than 9 years, they are reopening the issue.
So, my lord, in this application, it cannot be said that they have any right to reopen the issue. Those are my submissions.
Yes, Mr. Banerjee, anything to add?
Nothing more.
Nothing, yes.
Thank you, White Mate and leadership.
An interesting question has been raised in the present application, which has been filed under Section 61 of the Indian Stamp Act 1899. Full stop. Learned counsel appearing for the respondent stroke petitioner submits that the agreement for sale on the strength of which the plaintiff stroke respondent filed the suit for specific performance within bracket from which the present appeal arises, bracket closed, was marked as an exhibit in the suit on May 15, 2002. Full stop. Next para. On November 10, 2006, the date will be different. On November 10, 2006, marked as an exhibit on November 10, 2006. তাই বললাম কি? না, on November 10, 2006. Full stop. Next para. Subsequently, on December 13, 2006 and January 15, 2007, respectively, two applications were filed raising objection to the marking of the document on the ground that the same was insufficiently stamped. For the next para, Vide order number 14 dated February 1, 2007, the learned trial judge dismissed such application primarily on the ground that the objections were raised as an afterthought. Full stop. A divisional application bearing CO number 1219 of 2007, having been preferred against the same, it was disposed of on October 17, 2012 by affirming the order dated February 1, 2007. For sub next para, learned counsel for the petitioner argues that neither the trial court nor the revisional court adjudicated or judicially determined the issue as to the admissibility of the document concerned, but merely turned down the objection thereto on the threshold question of maintainability, having been labeled as an afterthought, apparently taking into consideration the bar under Section 36 of the Indian Stamp Act. For sub next para, learned counsel argues further that Section 36 is subject to the exception as provided in Section 61, which, in turn, permits the court to suo motu take an order admitting an insufficiently stamped document into consideration and, if of the opinion that such instrument should not have been admitted in evidence, to pass appropriate orders in that regard. For sub next para, learned counsel contends that although the power conferred on the court is suo motu in nature, the jurisdiction of the court may be invoked by a party for the limited purpose of bringing to the notice of such irregularity, upon which the court may be prompted to exercise such suo motu powers. For sub next para, learned counsel cites a two-judge bench decision of the Honorable Supreme Court in support of his contentions, in the matter of J.M. Shahul Hamid versus Jayanti R. Hegde. Full stop. In the said decision, the Honorable Supreme Court observed inter alia that irrespective of whether objection is raised or not, comma, the question of admissibility has to be decided according to law. It was further held that the presiding officer of a court, when confronted with the question of admitting an instrument chargeable with duty, but which is either not stamped or is insufficiently stamped, ought to judicially determine it. Application of judicial mind, comma, it was observed, comma, is a sine qua non, having regard to the express language of sections 33 and 34 and interpretation of pari materia provisions of the Indian Stamp Act 1899 by the Honorable Supreme Court. However, comma, once a decision on the objection is rendered, comma, be it right or wrong, comma, Section 36 would kick in to bar any question being raised as to admissibility of the instrument on the ground that it is not duly stamped at any stage of the proceedings, and the party aggrieved by alleged improper admission has to work out its remedy as provided by Section 58 of the 1957 Act. Next para. In the same breath, comma, the Honorable Supreme Court stressed upon a judicial determination, quote unquote, judicial determination as to the question of admissibility of the document in question, and highlighted the duty of the court to ascertain whether the correct stamp duty was whether the document is correctly stamped, sufficiently stamped or not, comma, since it pertains to the fiscal interests of the state. Next para, Learned Counsel argues that in the present case, comma, neither the trial court nor the revisional court at the first instance decided the objection of the respondent stroke petitioner on merits by adjudicating on the question of admissibility of the document, but merely turned down the objection of the petitioner on the ground of maintainability. Next para, thus, comma, it is submitted that it is well within the powers of this court, semicolon, rather, comma, the duty of this court, comma, to look into whether the document in question, within bracket Exhibit A, bracket closed, was sufficiently stamped. Next para, Learned Senior Counsel appearing for the respondent controverts the arguments of the Learned Senior Counsel appearing for the appellant stroke opposite party, controverts the arguments of the petitioner and submits that the petitioner is barred by the principle of res judicata in re-agitating the self-same issue after the same has been decided up to the revisional court. Next para, Learned Senior Counsel further places reliance on the proposition laid down in Javer Chand and others versus Pukraj Surana, reported at 1962 to SCR 333, comma, which was referred to by the Honorable Supreme Court in G.M. Shahul Hamid Supra, comma, to reiterate the proposition that once a document has been admitted in evidence, comma, as in the said case, comma, it is not open either to the trial court itself or to a court of appeal or revision to go behind that order, and that such an order is not one of those judicial orders which are liable to be reviewed or revised by the same court or a court of superior jurisdiction. It is, comma, thus, comma, argued that once the attempt of the petitioner to object to the admissibility having failed, comma, the same question cannot be permitted to be re-agitated at the appellate stage. Next para, upon a careful perusal of the ratio laid down in G.M. Shahul Hamid Supra, comma, it is evident that the said judgment was rendered in the specific context of whether upon admission of an instrument in evidence and its marking as an exhibit by a court, such a process can be recalled by the court in exercise of inherent powers saved by section 151 of the Code of Civil Procedure. Full stop. In such context, it was observed by the Honorable Supreme Court that unless there was a specific judicial determination of the question of admissibility, the court ought to assess the admissibility of the evidence, even at a subsequent stage of the suit. Full stop. Next para. However, the said judgment cannot be said to be a binding proposition, with utmost respect, binding precedent, with utmost respect, on the interplay between sections 36 and 61 of the Stamp Act, since such question was neither raised nor adjudicated upon by the Honorable Supreme Court in the reported judgment. Full stop. Next para. That apart, the stage up to which the Honorable Supreme Court permitted the court to reopen the question of admissibility has already been exhausted in the present case by the respondent stroke petitioner. Full stop. During pendency of the suit itself, although the document in question was marked as Exhibit A on November 10, 2006, two subsequent applications, respectively dated December 13, 2006 and January 15, 2007, were made by the respondent stroke petitioner objecting to the admissibility of the same, purportedly under section 151 of the Code of Civil Procedure itself. Full stop. Next para. However, such applications were categorically rejected by the learned trial judge, which was affirmed in revision by a learned single judge of this court. Full stop. Hence, the chapter envisaged in GM Shahul Hamid Supra has already been exhausted by the petitioner much prior to the filing of the present appeal itself. Full stop. Coming to the question of section 36 and its relation to section 61 of the Indian Stamp Act, the nature of exception carved out in section 36 is categorical. Full stop. Section 36 provides that under normal circumstances, where an instrument has been admitted in evidence, such admission shall not, italics say, except as provided in section 61, italics close, normal, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. Full stop. Although section 37 per se casts a duty on the court not to admit in evidence an instrument chargeable with duty for any purpose unless the instrument is duly stamped, the said section is circumscribed by section 36. Full stop. Insofar as section 61 is concerned, subsection 1 thereof categorically mentions the class of entities at whose behest an issue of admissibility can be reopened at a subsequent stage. Full stop. The said two classes are respectively the collector and the court itself. Full stop. Subsection 1 of section 61 clearly stipulates that when any court in the exercise of its civil or revenue jurisdiction makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp, or upon payment of duty and a penalty under section 35, the court to which appeals lie from or references are made by, such first mentioned court may, of its own motion or on the application of the collector, of its own motion থেকে collector পর্যন্ত italics of the collector, comma, takes such order into consideration. Full stop. Next para. Thus, a clear demarcation had been made in section 61 as to only the collector or the court itself, within bracket suo motu, bracket closed, being entitled to reopen the issue. Full stop. If we consider the overlap of sections 36 and 61, it would be the party to the litigation who objects to the admissibility of the evidence who has not been given a second chance under section 61, comma, the right of reopening under the said section being reserved only for the collector and the court. Full stop. In the event section 61 is construed to mean that the suo motu powers of the court can be invoked in the garb of bringing to the notice of the court by one of the litigants who are specifically debarred under section 36 to reopen such issue, comma, it would be effacing the effect of section 36 from the statute book itself. Full stop. Next para. Thus, comma, on a conjoint reading of section 36 and section 61, comma, it is evident that it is only at the behest of the collector or suo motu by the court that an issue can be reopened at the appellate stage, comma, once no objection is taken when the concerned instrument is admitted in evidence. Full stop. Next para. G.M. Shahul Hamid protracts the stage where such objection, comma, as contemplated in section 36, comma, can be taken and extends it to the pendency of the suit itself, comma, during which, comma, under section 151 of the code, comma, the court can exercise its inherent powers for the ends of justice or to prevent abuse of the process of court to consider the question of admissibility of the instrument. Full stop. Next para. However, comma, the judgment does not touch upon the powers of the appellate court under section 61 as discussed above. Next para. The second question which falls for consideration is whether the adjudication by the trial court at the first instance on the objection taken by the petitioner to the admissibility of the document in question has attained finality. Full stop. Next para. Learned counsel for the petitioner seeks to distinguish between such adjudication and a double inverted judicial determination on the admissibility as contemplated in G.M. Shahul Hamid Supra. Full stop. Next para. However, comma, with respect to learned counsel for the petitioner, comma, such distinction is artificial in the context of the case. Full stop. The specific objection as raised now was taken by the petitioner in its applications before the trial court. Full stop. Such application was decided on merits, comma, be it on the ground of bar under section 36 or on the ground that it was an afterthought and made at a belated stage. Full stop. The petitioner, comma, not stopping there, comma, assailed the said order in a revisional application, and a learned single judge of this court conclusively decided the revisional application against the petitioner. Full stop. It would give rise to judicial anarchy and impropriety if such a concluded adjudication is reopened under the pretext that there was no quote-unquote judicial determination at the first instance. Full stop. Any adjudication by a competent judicial authority tantamounts to a judicial determination. Full stop. The moot contention before the trial court at the first instance, comma, when it passed the order dated February 1, 2007, and the revisional court in its judgment dated October 17, 2012, was the admissibility of the instrument itself and no other question. Full stop. Whatever might be the ground on which the objection as to such admissibility was turned down was a judicial determination for all practical purposes on the said issue. full stop, hence, comma, by operation of the principle of res judicata, comma, the petitioner cannot be permitted, comma, particularly in the teeth of the bar of section 36 of the Stamp Act, comma, to invoke section 61, whereas the said section does not permit an aggrieved party to the litigation to raise such issue afresh. Full stop. Such right is reserved only to the court and to the collector and cannot be invoked by the petitioner. Full stop. Next para, in such view of the matter, comma, this court is of the opinion that the petitioner cannot be permitted to reopen the self-same issue in the under section 61 of the Stamp Act. Full stop. Accordingly, can, what is the number of the can? Can 2 of যেটা আছে 2025 is dismissed on contest without any orders to cost. Sorry.
One prayer you to Lord.
Yes.
The appeal is ready for hearing.
That is
Paper
one prayer, Mr.
I-
Kaur, which we are, don't embarrass us with that prayer.
My lord, if your lord, you can.
The paper books are filed, everything is ready.
Everything is ready.
Something must be unready.
Not yet, my lord.
Are you sure that paper books?
I have not received, my clerk went to the department, no, it has been filed, but
Very
we have not received it.
Since learned senior counsel appealing for the respondent submits that the paper books are that the appeal is ready for hearing, comma, let the same be listed for hearing in the monthly list of June 2026.
Grateful to lordship.
Much of that.
Thank you. Next.
In this matter, Lordship, I am for the appellant. Long back, there was a direction for service, Lordship, we complied, but
What happened?
serve a notice and come back, Lordship. This is the first appeal.
Served long back.
2024 direction was there, though it was served, Lordship.
So you filed that affidavit of service? Service of what? The applications?
Applications.
What are the applications?
3 application, one Lordship for stay, another for Lordship section 5, another leave to appeal, because Lordship, some of the Lordship dependent was died, Lordship, without taking any steps, Lordship, the suit was declared.
Very well. Learned counsel for the appellants fairly submits that although service of the applications has been effected on the respondents, comma, such service took place long back, and as such, fresh service may be directed. Full stop. The affidavit of service filed in court today be kept on record. Full stop. In view of the prayer of the appellants, comma, the appellants are directed to serve copies of Can 1 of 2023, Can 2 of 2023, and Can 3 of 2023 afresh on the respondents, indicating that the applications shall be listed for hearing in the monthly list of June 2026. Full stop. A fresh affidavit of service in that regard shall be filed when the matter is next called on for hearing.
Grateful, Lordship.
Thank you.
That is the time for the appellant, Lordship. On the last occasion, Lordships, there was some delay.
Deficit court fees 186 days delay. Deficit court fee of 26,610.
Lordship, that I have already. Lordship, this is the receipt.
Yes, defects removed.
Lordship, the only 2 defects. Only 2 defects couldn't be cured, Lordship. One is the modification of the decree regarding the.
That has to be sent down.
Lordship, that the appellant has already preferred one order 20 rule 7 application for modification, Lordship.
Modification to what extent?
The date of the judgment is not correct in the decree.
Section 5, there is a section 5.
Lordship, in respect of section 5, Lordship, I have to submit that the department calculated the delay from the date of the judgment. Lordship, after the judgment, the appellant preferred one appeal before the district judge, Lordship. The district judge granted liberty to file before the appropriate forum, Lordship. So,
still there is a delay. You may at least get benefit of order, section 14.
Lordship, but
limitation runs from the date of the judgment.
Date of the judgment, Lordship.
You preferred an appeal before another forum. That's no. You have to file an application for condonation of delay.
Lordship,
file it. Let it go out of the list. Lordship. On the last occasion, also we pointed out that there is a delay.
Lordship,
it appears that no condonation application has been filed by the appellant. Full stop. Let the matter go out of the list with liberty to the parties to mention for inclusion in the list as and when such application is filed. আপাতত out of list.
Grateful to Lordship.
Long back, this appeared before us.
Lordship, but in respect of application under
Who gave you this impression that no section 5 should be filed?
so the department instructed me to get proper instruction from the
Nowadays, you are being governed by the department on legal matters also.
Lordship, but
Peculiar. Yes, next matter.
grateful.
This 7, Your Lordship, I'm for the respondent.
Respondent.
For the respondent landlord, we have already executed the decree.
Execute degree.
Taken possession and
One last chance to them. If they don't appear, dismiss for
another thing, Your Lordship, is I believe as per my instruction, the appellant has expired.
Appellant has expired.
Appellant has also expired after passing of the decree.
Take instruction appropriately. Then will regarding the date and the particulars.
I'll come up with it on
Take instruction. If he has died before 90 days, we'll just say that the appeal has abated. And then if they want to set aside evidence subsequently, they'll come. Learned counsel for the respondent submits on instruction that the appellant might have met his demise in the meantime. It is further submitted that the impugned decree has already been satisfied by the respondent taking possession of the property. Hence, in all probability, last academic. Learned counsel for the respondent is requested to furnish the date of death and proper particulars of the heirs and legal representatives left behind by the appellant, if any, if possible, the respondent shall also furnish a copy of the death certificate of the appellant. For such limited purpose, let the matter stand adjourned and be listed in the monthly list of June 2026. In the meantime, ask your client to take out a death
I shall
certificate.
inquire regarding the death certificate, but I shall also furnish the.
Nowadays, death certificate is given to everybody, from the corporation.
Shall inquire
If it's corporation area, we don't.
I shall inquire out regard to that and the order regarding the full satisfaction of
That also you bring. Better. We'll record both and.
Great.
Yes.
Dismissed for default case, my lord. Restoration application has been filed
within time.
Within time. Paragraph 10 and 11, my lord, they have stated the ground.
What?
Sickness, my lord.
Why? Not Hawaii, sorry. Something else. Some other place. How is not the right word to say now.
Advocate.
Yes, we are allowing the restriction. Hearing learned counsel for the parties, we find that sufficient explanation for the absence of the appellant on the relevant date has been made out. Accordingly, can 3 of 2026 is allowed on contest, thereby recalling the order dated January 5, 2026 and restoring the cans were dismissed. Restoring can 1 of 2024 and can 2 of 2024 to their original file and number. Appeal is pending.
Appeal is pending.
Well, can 1 and 2 then we have to take up. Yes. Move it.
Can 1, my lord, that there is a delay. There is also delay. That section 5, 575 days.
Only 575. What is the reason for the delay?
Delay, my lord, the change of advocate. They have stated, my lord, paragraph 10. That the appellant.
Then you have to serve that advocate. This is a specific allegation.
Wrong suggestion. That is applicant states that there are.
Wrong suggestion, then you serve that advocate and come back.
Yes.
Sub.
Wrong advice from his previous advocate who has misguided the present appellant defendant to file a said miscase. Instead of filing an appeal, the same has been withdrawn by the said appellant 21st December 2024. Wrongly as by তাহলে তাহলে তো হবে advocate কে নাম লিখে বলছিস সব
serious what is the allegation? Let us see if it's serious, then we'll.
Serious, my lord, the advocate has misguided. Kindly see paragraph 10, page 5. Oof, Nara. Wrong advice from his previous advocate who has.
Why do you use such strong language? If it was couched in a softer language, you could have overlooked this. There may be wrong legal advice. All of us, we pass wrong judgments, which is set aside by the Supreme Court. You give wrong advice. We never know whether an advice is correct or wrong before it goes to the court. But why misguided and all these allegations? If you couch it in softer language, you could have heard your learned friend and decided it here and now. So this is a challenge against what? Regular
The
degree.
section 18 of the Hindu Adoption and Maintenance Act finally decided the trial court and against me. That is the attached petitioner is the retired person, is pension, he is earning pension.
No,
The trial court has decreed the order 15,000 per month to the wife and the daughter. And
no, suit for maintenance.
Maintenance.
So what miscase did you file?
Miscase did you
Section
file?
47 of CPC millet and
Change
order
it to-
21, rule 98 and 100.
In the
In the execution proceedings.
So that is not a substitute
No.
for appeal.
Not this.
I don't get the benefit
When
of section 40.
this was withdrawn by the earlier advocate. Thereafter,
What a good ground. What is it? 500 something days.
575 days.
Mistake. Mistake.
These are the only grounds millet which have been.
Yes, you have annexed the order of the miscase.
Yes, this is the memo of
When it was filed and when it was disposed.
miscase title suit has been, they have been asked.
I haven't stated your occupation in the affidavit. Why haven't you stated your occupation in the affidavit?
This has been the annexed, the title execution case, miscase has not been annexed. Miscase has not been the annexed.
একটা ডিগ্রি পাস হয়েছে তার এগেইনস্টে তো ফিল হবে
On the last occasion, millet, your lordship had been pleased to millet direct them millet to supply a copy of the miscase.
What about service?
Service, miscase, service.
Plaint and miscase. Which
Plaint and miscase, let us see the plaint and miscase.
The miscase has not been served. Miscase service will see.
No, have you got a copy of the miscase?
Millet, I had supplied millet on the last occasion millet. That should be there in the record millet. A copy of the miscases millet and also the copy of the plaint millet.
You served. This is the copy of the miscase. The one copy I have.
Plaint we have got. Miscase must also আগের বার দিয়েছি না
These are
দিয়েছে না
তোমার কাছে
কি দিয়েছে তো কপি দিয়েছে
আচ্ছা না না ওখানে আলাদা দেখুন
আলাদা করে
ওকে দেখুন এটা প্লেন
তুই ফ্রেশ ফাইল করেছিস?
হ্যাঁ
তুই ফ্রেশ ফাইল করেছিস?
আমি ফ্রেশ করিনি আমি এটা উইথড্র করে নিয়েছি বুঝি তো রং অ্যাডভাইস
লোয়ার কোর্টে
লোয়ার কোর্টে
Miscase is not a substitute for appeal.
Appeal.
Then
Well, the long aspect of the learned advocate of the court below, they have filed miscase again, which has been withdrawn.
very cast an aspersion on the advocate. But it is a fact that this was filed. So it's obviously it was wrong advice.
Yes, that is true, millet.
No use will be, no purpose will be served in giving notice to, it will be embarrassing that advocate.
Yes,
In
he
this
will also be embarrassed. As a matter of fact, they will be also embarrassed.
No, we want to embarrass somebody who blames who blames advocates. We want to do that always.
At the
If
drop
you
of
cast
the
an
hat,
aspersion on
millet,
an advocate, you have to serve a notice.
there is a millet tendency to
But
millet.
No, here it's a they are right in saying that a miscase was actually filed.
Yes, it was millet.
Yes, this is an admitted position, no difficulty on that. So what do? Tell us.
I leave it to your lordship, millet. I shouldn't be harsh.
Obviously, দেখতেই পাচ্ছি। Well, you are saved for the magnanimity of your learned friend and my learned brother. Otherwise, it would be a bad picture. Hello, Pradeep. Third learned counsel for the party. The delay in preferring the appeal has been sought to be explained by the appellant by taking resort to a miscellaneous case which was filed in connection with an execution proceeding levied in respect of the impugned decree. For sub next para, a copy thereof is handed over to court by learned counsel for the respondent in his usual fairness, from which it transpires that the executability of the impugned decree was questioned in the said miscellaneous case. For sub next para, upon hearing learned counsel for the parties, we find it plausible that the petitioner, being a layman in law, was misguided due to erroneous legal advice at the relevant juncture, and, instead of preferring an appeal, filed a miscellaneous case in respect of the connected execution case. First up, accordingly, in view of sufficient explanation for the delay having been furnished, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 374 of 2024. First up, the said appeal is deemed to stand registered and admitted. Yes. Now on merit, now move your stay application. What is your what is your prima facie case? What is your ground of challenge?
Ground of challenge, my lord, in the WS, they have not been, my lord, discussed about the written statement. I am the defendant.
You are the son.
Son. I am the father. I am the father.
Oh, you
My
are the
father. And can to put the, my lord, the story is required, my lord, page 3 and 4. That is the note, no affidavit of asset, my lord, the filed before the trial court. Though, my lord, the trial court discussed about the order of maintenance.
No, what are you aggrieved with? Maintenance was given to you.
Maintenance was given to me, but
you were not satisfied with the quantum.
The quantum, it has been too much high.
Given to me, Millet.
You are
I have the wife, yes, Millet. Wife and the daughter, Millet. Unmarried daughter, Millet. 15,000 Millet was given as maintenance, Millet.
Oh, this is wife and
unmarried. She is, my lord, employed. My pension amount is, my lord, 26,900.
Yes, are you agreeable to go to mediation?
Yes, we,
as you
let us send it to mediation.
Yes, you take your chance there, thereafter it will come.
Chere then me employed to very well. Go to the mediation.
Very well.
In the meantime, but Millet, they should keep on making payment, Millet.
My lord, I am the lastly, my lord. Well, lastly, I have
How much payment?
15,000 Millet.
How much payment you received last?
Last 15,000. I have
15,000. They are making payment, Millet.
Okay. Just wait for some time.
Yes, this will not prevent anything.
Yes.
The matter arises out of a maintenance decree passed in a
16,000
proceeding instituted by the respondents, being the unmarried daughter and the wife of the appellant. First of next para, in view of the nature of the proceeding, we deem it fit to explore the avenue of mediation to resolve the issues between the parties amicably. First up, accordingly, let the matter be sent to the Calcutta High Court Mediation Committee. First of the file be sent immediately to the committee for such purpose. First of next para, it is made clear that the reference to mediation shall not preclude the appellant from carrying on paying the amount of maintenance directed by the impugned decree in the meantime.
I'm grateful.
Well, lastly, page on 4th April, my lord.
No, he's not disputing.
Admitted.
Not disputing.
I'm grateful.
খুব ভালো কাজ করলেন তো যদি সেটেল হয়ে যায় এটা ডিসপিউটটা তাও খুব ভালো কাজ করলেন এবার অনেক সময় নাম দিয়ে দিই এক্স
ওরা ওদের টাউন yes respondent appellant yes.
On last occasion, my lord was pleased to direct me to serve the copy of the application for
You are appealing for all the respondents.
All the respondents. Plenty of respondents.
Well, yes, Mr. Pal, what is the
my lord, the expertise decree was passed.
decree of
My position.
eviction decree?
Suit for eviction of trespasser and one of the khas position.
So what is your ground?
The ground, my lord, well, it's totally fraud. No summons was issued. And the defendant number shows in the plain, my lord, the signature was forged. We don't have any knowledge. This suit was filed in the year 2017.
Your signature in what? The summons?
In the Okalatnama, as well as in the WS. The person is illiterate, my lord, the one room, 55 rupees of rent. She did not have any knowledge. Even brothers did not have
degree.
expertise degree, and my lord, he did not know. Even we are totally in dark. On 19th November 2024, my lord, the appellant number 1 came to know that, my lord, we have initiated from the,
Not necessary.
from the read code, my lord, when our
You have
position
not
was
taken out an order 9 rule 13 application.
we have not taken out.
The difficulty, as my learned brother rightly points out, is an appeal will be an illusory remedy because we can't take evidence for the first time here. That is a difficulty. That is what we are wondering. Order 9 rule 13, you have greater scope in a sense. Appeal also, you can take challenge the same on the same ground. No difficulty on that.
There are serious allegations regarding forgery and all
Yes,
this.
but we have moved
That has to
from
be
the
proved by
read code.
evidence.
From the when I taken for the position, I'll move before the read code. From the read code, of the office report, the police report came to know that the suit was filed, and accordingly, on the basis of the expiry decree, the was executed. Then we move before the criminal court for obtain an order. We have to obtain an order, my lord. The read code passed an order to take, my lord, the signature, verification of the signature. Police was kept, ma'am. The verification signature was made. The matter is pending before the read court now.
Signature in the Wakalatnama.
Okalatnama as well as the written statement.
So that writ petition is pending.
It is pending.
So what is the
The police was directed to
period of delay?
310 days.
What is the ground?
Ground, my lord, on 19 November 2017, suit was filed. 19 November, the appellant number 1 came to know. Appellants came to know. On 20th day, immediately thereafter, when the position was taken over, if she went to the police station, lodged the complaint on 19th. They did not take, my lord, the steps. On 20th morning, she went to the tenanted premises. She was mercilessly beaten up. She was admitted to hospital. She moved before this, came to the High Court.
But you say she, there are 3 more persons.
Three was the
Sons are also there.
brothers and sisters, the appellant number 1.
The 2 brothers are also there. Why
Brothers are also there, but the sister was residing there. Brothers, for the timing, they were not there. But she was admitted. But she moved before the read court. From the read court on 25th November, the order was passed to lodge an FIR, and the report was filed. On the report, she came to know. Then he before this approached the advocate before the trial court to obtain an order, judgment, and decree. The obtained an order.
So after you were beaten up and evicted, then you came to know about this.
Yes.
Yes, Mr. Bhattacharya, what do you say?
My lord, 2-3 things. Well, first of all, my lord, this is a concocted story. My lord, they appeared file written statement. My lord,
So
this
they're
is the
saying that it's
statement. My lord,
fraudulent.
no, fraudulent, my lord. Then, my lord, kindly see the consequences. The oath commissioner has to be held up. Without confirming, my lord, who or the my lord in trial
No,
courts.
we are not afraid of hauling up the oath commission.
I'm not even going into that.
Whoever is required to be hauled up will be hauled up.
Exactly.
No difficulty on that.
Whoever. My lord, then, my lord, if he levels that allegation, my lord, then, my lord, who affirmed and who...
No, evidence was adduced by this thing.
Nothing. Even if...
Simplicity written statement. If there would have been evidence, then it would have been a very false story.
Definitely. Now, my lord, kindly thinks another thing. My lord, my lord, my lord, my learned, your lordships, my lord, it fell from your lordship that why don't you go and file, my lord, an order 9 rule 13 application. My lord, we have by the process of the court, by the seal belief of the court, we have recovered possession. Kindly see, my lord, page 7, para 11, their statement.
Yes.
Kindly see, my lord, entirety need not be read, my lord. Kindly see, my lord, Justice Tirthankar Ghosh upon on the middle of the hearing as pleased to pass an order inter alia directing the police authority to take steps into the matter as per FIR lodged by the petitioner being Bowbajar KFPS case number 280 dated 28 November 2024 under such section on or about 26 November 2024 and filed a miss case being miss case number 8861 of 2024 before the learned registrar bench, City Civil Court at Calcutta for restoration of possession, and aforesaid miss case is pending for consideration. My lord, they chose to file an application for under section 144 of the Civil Procedure Code, but not order 9 rule 13. They had, my lord, time at that point of time also. This came to their knowledge. We are in 2026. What explanation, my lord, they are giving in the
Now, in
section?
the evidence, there was any cross-examination or
The
simplicity?
evidence was not taken, the ex parte degree.
Ex parte degree. That means simpliciter, Vokalatnama filed, written statement filed, and thereafter disappeared.
Disappeared. Only on the basis of the only PW1.
Anyway, but that is from their side.
Correct.
From your side is written statement, Vokalatnama, and disappeared.
Only shown 1%.
Rightly felt from your lordship, my lord, it requires, my lord, evidence to be taken. I do not know whether in appeal, my lord. One, but number two, this is, my lord, an appeal filed by whom? Heirs of the original tenant. My lord.
No, they were occupying the property. You obtained a decree against them.
Definitely.
Against them. So they are the judgment debtors.
Definitely.
They admitted that I am a tenant. In the written statement, in the judgment manual, we find that they have admitted I am a tenant. My father was the original tenant.
They must be taking resort to 2G.
2G, exactly.
Yes, yes.
My lord, today, my lord, I am raising a point regarding maintainability of this appeal.
That will be decided in the appeal itself. How can we decide that at the section 5, sir?
Prima facie. I am on the maintainability of the.
Let us allow the, since you are on prima facie, let us allow the section 5 and take up the time.
Then, my lord, then the allegation has been made against us on forgery, then I'll file affidavit.
File it quickly.
Fortnight.
Fortnight mistakes has been before the vacation, file it so that they give them a copy before the vacation. Sapal, you will file your reply within 1 week after the opening and then. In view of the serious allegations made in the condonation application, learned counsel for the respondent seeks to use an opposition thereto. Accordingly, the respondents are directed to file their affidavit in opposition to Can 1 of 2025 by May 22, 2026. Push up, reply thereto, if any, shall be filed by June 12, 2026. The application shall next be listed for hearing on June 16, 2026. Affidavit of service filed today be kept on.